Good morning, good morning, good morning, amazing. Leonard, I hope you're doing well today. It's Wednesday, it's March 18th, and boy, we have a lot to talk about. We had hoped that we would see a juror have something to say, and today is that day because a juror has spoken with ABC. We're going to talk about that. I promised on verdict day, though I forget all of what I said on verdict day because my brain is so tired. But I said on verdict day, we were going to look at some of the bond hearing that we had not seen in a number of years. So we're going to take a look at the bond hearing together. We're going to take a look at the verdict forms because I have those. We're going to take a look at sentencing because I have some modifications to make because my memory and reality are not the same. So there are some updates about sentencing that we need to talk about. And we need to talk about what is going on today because I need to make some disclaimers on what stream might sound like today. But we're going to roll the intro and then we'll get into those disclaimers. So sentencing, verdict forms, juror speaks out, and, well, we need to take a look at that bond hearing in hindsight because I feel like we're going to learn a lot. I saw this in the chat. Jojo Corton said, am I the only one who waves back? I hope not. I hope we can all just wave to each other and be like, good morning. I mean, good afternoon, good evening, good middle of the night, depending on where you are. Today is just. We also might have to chat a little bit about who has reached out to the EDB post-trial. We'll talk about it. However, all of you are going to say, EDB, are we going to do interviews? I'm going to tell you, I am more comfortable doing that after sentencing. Given this defense team, do you blame me? I think I am more comfortable waiting until after sentencing. That's where I'm at. So, I know everybody, I am not a journalist. I think lawyer brain first. And I do not want any conversations to be leveraged in sentencing at all. So we're gonna talk about that a little bit too, because we got some tea to spill. And we got some other stuff to talk. We got so much stuff to talk about. But Leonards, we need to roll the intro. Let me know where you're coming in from, what you're drinking. EDB, how many coffees is that today? One. It's the first one, which is appalling. It's been that kind of a day. I know. It's the first one. Right? Let's roll the intro. Let's talk. Emily, the sound's not in the right place. I mean, we thought it was, but no, it's not.
And the evidence in real time. So you know what's happening. No law degree required.
It's a Monday of a Wednesday.
They're here for the facts, not and let's get to court.
It's like, it's hump day, but also it's not. Okay, what did I have a chance to find? First, I found the pen that to me looked like Amy Richins' pen in the trial. I do not know if it was the same pen. It is probably not the same pen. But this is the pen I was talking about that I could not find. It was in my book bag, which is not a backpack. It is, I'll have to post a picture, but I have a big old bag with the multiple books there are different types. ADHD. It's like you have to have something for hydration, but then you also generally need something for caffeination. And then sometimes you need something fun. Books are the same way. You need something for fun, something that you're working on, something that you want to finish, all the things. We need to address this morning real quick because Leonards, I'm just going to tell you because we're just friends on the internet and there's just a few people here. So it's fine. The way I was dead asleep this morning because I was like, we're streaming at 11. Everything's going to be gravy. We worked on prepping the stream last night, albeit really, really late because the ADHD brain processes, let me know if this is you, after 10 p.m. Shit doesn't really happen the same way before 10 p.m., after 10 p.m. So I was sitting on the couch with George. We were chilling. Travis comes downstairs, my oldest, just turned 18, and is like, hey. I'm like, hey. And he's like, so, laptop immediately closes. And then we talked for like 2 hours. And then I was like, hey, so you have school tomorrow? He's like, I do. And I'm like, there's a few things I need to finish. And he's like, yep. And I'm like, I love talking to you. I do not want to say we cannot chat, but also I want to be like a helpful parent and be like, I'm aware that you have school tomorrow, but I also want all of the conversations while you can just walk down the stairs and have a conversation with me. So then I am torn because I'm like, I want to still talk. So then he goes upstairs and he's like, I'm going to get ready for bed. I'm like, that's amazing. And then he is sending me memes on Instagram. And then I'm sending him memes on Instagram. I'm like, come back down here. Talk to me about the memes. So then we talked for a little bit longer. And then I was like, okay, but for real, we need to go to bed. I need to finish up grabbing stuff for stream tomorrow. And we need to go to bed. Emily, I didn't see stream populated this morning. No. Emily went to bed really late. I was like, I'll do it first thing in the morning. Do you know what happens first thing in the morning? Get up-ish, say goodbye to Dr. B, G, T, go back to bed. I'm like, we're streaming at 11. We got time. Alarm is set. My alarm does not go off. Nay. I hear ladders outside of my house. Ladders. And I'm like, the fuck? And then my cats freak out. And then I'm like, why are the cats freaking out? And why are there ladders? And then there were drills. Drills are a very distinct sound. There were drills. And then I was like up with my phone trying to put on my bathrobe. And I was like, why are there ladders? And then I look out the window and I can see that there's ladders. And then there's drills, and I have no idea what's going on. And so instead of, the first thing I do is call Dr. B. I'm like, hey, there are people with ladders. He's like, oh. So I told the company that is going to replace all the rain gutters that they could do this today. And I was like, what? And he was like, yeah. I'm like, the gutters. He's like, yeah, we talked about the gutters. I'm like, we did. But like, we never said it was like happening today. And he's like, oh, well, they had availability to do it today. And I was like, but they're pulling all of the gutters off of the house. Apparently the gutters were undersized. Who knew? Whatever. So sure. So they are pulling the rain gutters off of our house where my bedroom is. I am in a robe and I'm just like, okay. When my heart gets back into my chest and not my stomach, and when my soul comes back into my body, I will be able to resume breathing. But what do you mean they're replacing the gutters today? He was like, well, they had availability and trials done, so I figured you wouldn't be streaming. Sir, no. Yesterday, I didn't stream yesterday. If I didn't stream today, people would assume that I was deceased. Like, no, we can't not stream today. We have been in trial every single day for weeks. If I pieced out from Monday to Friday, the law nerds would be like, where are you? What has happened? What's wrong? Where is she? Did anyone make her a Moscow Mule? Like, it wouldn't go well. Dr. B, we all need to chat. We have not officially decompressed together yet. We've barely processed Monday. Took yesterday to like breathe. So Dr. B's like, so you're streaming today? I'm like, uh-huh. But they are wresting in the gutters from the windows And they started at the back of the house. So my office is not at the very back of the house. So by the time we get close to stream starting, they are pulling everything off of the windows near my office. And I'm like, this is so loud that there's no way. And I'm like, I'm just going to have to. So I reach out to Team Baker. I'm like, I'm going to have to push this back until like the noise has settled. And I am in my slippers. I'm still wearing them, but I am in my fuzzy slippers and my bathrobe. And I fuzzy slipper my butt out the garage door. And I'm like, so hey, surprise. I know you talked to my husband. He is not at home. I have like let's call it a work call. Is there going to be like a downtime when it's not this? And they're like, yeah, we probably need like another 45-ish minutes. I was like, okay. We can, y'all don't chat. Do not tell me you've never called stream a work call. Don't tell me you've never called stream a work call. I got a work call. I got a work call with EDB. We got to chat. We've got to consult. We have work to do. Just saying. It is a work call. I'm a lawyer. This is my work. We're kind of on a call. It's fine. We're on a work call. It works for me. So we're consulting together, chat. So they were like, it should be about like 45 more minutes. And I was like, perfect. That's great. Here's what we have not talked about yet. And then we're going to get into like EDB, but a jurist. But yeah. Here's what we haven't talked about yet. This is other than the noise. This is what sent the morning just another direction. So what we have not had a chance to talk about, because I was stressed out and I didn't want to stress you out amongst me being stressed out, but Fred got into some stuff. Well, not really. Fred had an abscess. He's a cat. He's now fine. However, this required a trip to the emergency vet on Sunday. So Emily, were you discombobulated Monday? Yes, I was, because we were trying to get done at emergency vet and get home before we got stuck at the emergency vet due to tornado-y winds. So it's always a Sunday. Emergency vet, by the way, was so amazing. And Fred, even though not feeling good, is such a flirt that everyone was just in love with him. Just in love. Not Fred's fault. Just Fred. Just things. So everyone was just in love with him, and he's just like, hi. And I'm like, oh, buddy. This requires sedation and things. I will spare you the details. Fred is fine. Fred is good. It is oh, wow. We don't see that often in cats. The orange ones are a spicy variety. And I was looking at the weather being like, oh boy. Okay, Sunday. Good. Sunday. This is great. Sunday evening. This is fantastic. Fred is fine. So the thing is, Fred needs medications. And with the unexpected ladder situation, finding Fred this morning and getting Fred to come with me to do morning medications. Yep. So that was an adventure for everyone. Fred is the bestest cat when it comes to giving medications. However, the ladders outside the house are obviously a situation where one needs to be underneath things. Like Fred just took cover. So if I look like I'm sweating, yep. This is why. However, Fred is good. I am not scratched at all. I was covered in cat hair, not scratched. Fred is good. Fred's all good. I might be sweating. It's okay. My Aura Ring believes I've had a workout for the day. It's totally fine. So between the noise and the cat antibiotics and my soul needing to like relodge itself into my body. It has been a morning, but Leonard's, it's days are days. Days are days. This week has been an adventure for all of us. So on Monday when I was like, no, they're not going to come back today with a verdict. Why would they do that? I was like, which is great because I need to eat. I need to eat. And then Monday was Monday. How old is Mr. Fred? Mr. Fred is 5. Fred is 5. He is the sweetest boy. He is the sweetest boy. But understandably, it took a minute to wrangle him and make sure that he had appropriate medication without it all ending up back on me. So, this morning's been an adventure. It has. But also, if you have the Leonard app, you know that our hoodies are back. I will say, the only size we do not have in the oversized hoodie is a large. We sold out of all of the stock of not just it printed for us, but this hoodie in a large is completely gone everywhere. So we have to wait for more of these to be made. Here's what I will tell you about the Leonard shop. We are going to be restocking these as we can. So if you are waiting for the Leonard love, we will be restocking them. We will let you know in the app. However, every single hoodie of our drop shoulder, squishiest, favoritist, not too thick, but still a sweatshirt, but super cozy and oversized, but not so oversized, but still oversized hoodie, until they make more, we cannot restock them. So we have to wait. So we have to wait on the hoodie. And that is where we're at. We have to wait for more to be actually made. We are just completely out. But we are going to be restocking this hoodie, the Leonard Love zip up, and the shirts to try to keep them in stock a little bit more. Other things were limited edition. We have been asking for them to come back. So we have been asked by you for those to come back. And we keep that in mind as we work on our launches about the things that you love. We did a couple rounds of the purple one, but we have had many requests for the purple one. Don't worry. We will get there. We will get there. So we have them. The oversized hoodie is oversized. I size down in this hoodie. I love it, but the oversized hoodie is a lighter weight hoodie. It's all the details are in the description, but it is a lighter weight hoodie. The zip up is a thick hoodie. It is a thick, heavy, like if you're always freezing in AC, you're going to love this hoodie. If you're like, I am always hot, that hoodie is thick. She thick. Warm and smushy, but thick. This is like inside, outside. It's all good if you want sleeves on. The zip up is thick. V said, if I normally wear large, would I be okay ordering an extra large? If you want it oversized, but you'd probably also be okay in a medium because it is an oversized hoodie. It is meant to be oversized. So it depends on the fit that you want. We have to wait for the cups to come back in stock. The actual physical cup is out of stock. So that is what we are working on. We cannot press them ourselves. We have to wait until the manufacturer has more actual cups. So we are working on it. Do not worry. We are working on it. All right. Are we ready to talk law and court and cases and things? We will keep you posted. Look, when I say have the app is where you will get the information. Have the app. Have the app. We'll let you know. Okay. Are we ready? Are we ready to talk court? Yes, we are. Let's go court. Jan said, so the perimenopausal people shouldn't order the thick one. If you do get cold, or if you get cold in air conditioning, you will like the thick one. It zips up, so you can take it off very easily and not have to go over the head. but it is thick. I definitely wear it when I'm cold. I would not wear it in AC because I run warm. This one is perfect for me. But for those of you that are like, I am cold in the AC, it'll keep you warm. It'll keep you warm. All right, ready to go to court? Are we ready? Well, we're not going to court first. Do you guys want to, we should do the verdict form first. We should do sentencing and the verdict form, and then sentencing, verdict form, and then juror, I think makes sense. So let's do those. Let's do that in that order. And I think that makes the most sense. And then if we get yeeted by sharing the juror interview, it'll be fine. This is why we have sponsors on some of our videos. Today, it's the Lawnard Shop. Yay, Lawnard Shop. So let's talk sentencing. Let's talk verdict form. Let's talk juror. Let me pull up the verdict forms first. I think that makes the most sense. And then we'll pull up some of the law because the wonderful attorney in Utah who was like, hey, just a heads up. I was like, oh, that's helpful, because I thought I had pulled that up at the beginning of the case, but I was going to double check while the jury was deliberating. And then the jury didn't deliberate even long enough for me to go say hi to the family and come back. So there's that. Let me make sure I have the redacted verdict form. So let's go to the verdict form first, and then we'll talk about sentencing. A couple of you are asking, Emily, sentencing today? No. Sentencing is going to be in May. They need to do the pre-sentencing investigation report. So you know what we haven't done in a minute? We haven't gotten to swoop. So we can swoop. We can swoop now because we haven't gotten to do it. So let's do that. Let's do that. Let's swoop. All right. Let's pull up the verdict form, shall we? This is the original verdict form. It is redacted, so none of the jurors' names are on it. Stamped March 17th, 2026 verdict form. We're going to take a look at the differences in verdict forms between some jurisdictions and others. Emily, are you throwing shade at the Commonwealth of Massachusetts? I mean, if the shade fits, we need verdict forms that make sense. I think that these do. So let's go through the Kouri Richins verdict form as filled out by the jurors together. Please read the instructions carefully. It does not say take vague notes. Please read the instructions carefully. Be sure to mark only one verdict for each count. Please proceed to count one on the next page. Count one, aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is not guilty of aggravated murder. Look at how easy that is. Look at that. Look at that. Look at that. Look at that. What? What is that? Just two options. It's so easy. Emily, why are you buffering? Because it's so easy. It just makes so much sense. Keep it simple. Inquiry 1A. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances regarding count one beyond a reasonable doubt. Check all apply. Your decision to check any circumstance must be unanimous. Is there any question about what you're being asked to do? Nope. They checked the homicide was committed for pecuniary gain. Must be the money. And two, the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Any substance in a lethal amount, dosage, or quantity. Very clear cut, and I think the attorneys covered it well. But this is where the defense was arguing it has to be fentanyl, it has to be fentanyl, it has to be fentanyl. And where the prosecution was saying it has to be considered by her and actually be lethal. What she gives Eric Richins has to be in a lethal amount, dosage, or quantity. but it does not have to be a particular substance. So that keeps it easy, I think. Look at that. Count one. Should we go on to count two? Count two. Count two. Attempted aggravated murder. We, the jury, unanimously find that Kouri Richins is not guilty of attempted murder with guilty checked. If you mark not guilty, skip count three. If you mark guilty of attempted aggravated murder, you must answer inquiry 2A. Inquiry 2. Wait, did that say that on the one above? It did. I just didn't read it out loud. Inquiry 2A. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances regarding count two beyond a reasonable doubt. Check all apply. Count one. The attempted homicide was committed for pecuniary gain. Checked. 2. The attempted homicide was committed by means of administration of any substance administered in a lethal amount, dosage, or quantity. Not checked. You know why? Because it says lethal amount, dosage, or quantity, and he did not die. It's an attempted murder. Based on the language of this, I think the jury read that and went, all right. If not dead, then not lethal. Fair. Because he survived. You can check one or both. But the jurors read this. The jurors paid attention to it. The jurors just didn't go through and go tick, 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 tick and check everything. And the prosecution didn't argue the puzzle pieces here and didn't argue that the attempt could be by poisoning if you didn't die. Because the language says in a lethal amount. So, fair. Also, it was a quick verdict, but it does not indicate to me that they did not pay attention and talk about this case. It was clear to them. All right. Continuing on. And this, again, the two different aggravators or special circumstances, I think the language of the special circumstance says it has to be administered in a lethal amount. And there's no argument here that that applies if somebody survives. And it wasn't addressed in closing arguments. I think attempted for pecuniary gain makes sense, but attempt and lethal are a mismatch, and I understand. And we can look at the language of some of the special circumstances or aggravators or aggravating circumstances. My brain defaults to special circumstances because that's what it is in California, and that's where I practiced as a prosecutor. So my brain defaults to special circumstances, but they are truly synonymous. Aggravating factor, aggravating circumstance, special circumstance, those all mean the same thing. So it's that murder one plus other factors, and those plus other factors take it from murder one into an aggravated murder or a special circumstance murder. For those of you that are following the Reiner prosecution, you'll see the language there being special circumstances, bumps it from murder one up. All right, count three. Insurance fraud, January 29th to August 1st. We, the jury, unanimously find that the defendant, Kouri Richins, and then it gives not guilty, guilty options, ticked guilty for insurance fraud. Count four, insurance fraud, June 14th, 2022. Unanimously find Kouri Richins is guilty of insurance fraud. And then count five, forgery. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of forgery. Dated the 16th day of March, 2026. That's it, and signed. That's it. That's it. It makes so much sense. Such simple verdict forms. Look at that. Look, just did they do the crime? Yes or no? It's so easy. Love how simple the verdict forms are. This is why the jury instructions matter. The jury instructions need to explain what all of this means. The verdict forms should be this simple. Did the crime happen? Did the defendant do it? That's it. All right. We will continue talking about sentencing real quick. Scout November Light said, could they have put an intended lethal amount? I don't think the prosecution proved what the amount was or how much was put in. And I don't know if the case law would allow them to. When we look at the sentencing, we're going to see what some of those special circumstances are, and we can talk about it. But some of that language you can't change. So let's see. This Joanne asked, how did they find the forgery? Guilty. Unless you're asking me what facts could have supported that verdict, and I'm going to interpret it that way and answer that way as well. I think, and this is pure speculation because we do not know what the jury was thinking, but when the defense argued in closing, Kouri might have had permission. If I'm a juror, I'm looking at that going, oh, so you agree she signed it. You don't know that she didn't have permission, so you agree she signed it then. Just like you agree that she bought the pills from Carmen, because the defense said that she was buying the pills from Carmen. Kouri had, you don't know that Kouri didn't have permission. Okay, so she signed it then? And when they got to, you don't know if she had permission or not. Based on all of the other circumstances, I do not believe that there's any way Eric would have given her permission to sign a new life insurance and not put it in the trust. And I think that Bloodworth did a great job in closing saying Eric put all of his life insurance policies that he knew about into the trust. These life insurance policies were not put into the trust. And you can make reasonable inferences from the facts in the case. And the facts in the case were that all of the life insurance he knew about was in the trust. So why would he just sign this other $100,000 life insurance not to go into the trust? And then when you looked at the signatures, it wasn't his signature. And the testimony was, it was someone who knew his signature trying to forge his signature. And when you look at what was going on with her finances and the rest of it, is there enough there for you to go, oh no, she 100% signed that for another $100,000 in life insurance? Yeah, I think there's enough there. So the defense arguing, you don't know if she had permission, I think was them acquiescing that she signed it. I would have taken it that way if I was a juror. Not everyone might have. Some of the jurors might have sat there and gone, no, they can't say Kouri signed it. But then again, I would look at the beneficiary, but I did a lot of fraud cases. I would look at the beneficiary and go, who's the beneficiary of the life insurance though? Oh, Kouri? Oh, Kouri's the beneficiary of the life insurance then. Well, okay. So Kouri's the beneficiary and it doesn't go into the trust? So who's signing it then? And in the defense closing argument, they said, look, you didn't even look at Cody Wright, the business partner. He stands the most to gain. Okay, well, who stands to gain from the insurance policy? Kouri? Okay, same. Yeah, same. That's where I would have been. I also think once a jury is looking at this going, she murdered her husband for money, I do not think it is a hard intellectual leap to go to, and she was going to get all of the money, however possible. So I think once, especially once they're past the hurdle of the attempted murder, if they're looking at the attempted murder going, okay, so she gets the insurance, she tries to change the other insurance, she tries to kill him, it doesn't work, she asks for stronger stuff and then he dies. They're looking at that sequence of events as kind of the setup to the murder. So they're looking at the sequence backwards. That's how I think a lot of jurors might have seen it. Samantha Clark, this is a great question. I am going to wait until we get a little bit further into questions, lest I deviate too far and we never get back to the juror interview. But it's a great question. I'm holding on to it. I'm holding on to that. Good question. So let's take a look at sentencing, shall we? Because there is information that I had wrong, and so I want to correct the record on that. There's information that I'm sure you're going to see in articles and conversation that is wrong. And I want to correct that because I have now seen so many different recitations of the sentencing, and it is worth a conversation because on Monday I was like, oh, they didn't seek the death penalty. It's going to be LWOP. No, not necessarily. It can be LWOP, but it does not have to be. Emily, what is LWOP? LWOP is life without the possibility of parole. It does not have to be, which I was incorrect about. And I cannot make fetch happen on that. The judge actually has a choice between 25 to life or life without the possibility of parole. I have seen some people say it's 25 years. I've seen some people say it's 25 to life. I have seen some people, including myself, say it's life without parole. It could be either, which breaks my brain, but it could be either. So let's take a look at the sentencing provision here and talk about that real quick, because there is something to argue for at sentencing. The defense has room to argue and is going to want to argue. So let me, I'm going to have to, remember when I moved all this and said I'm going to have to move it again? I meant to do that. And then I didn't. All right, we're just going to leave it. It's fine. I'll read in the words that are cut off. Nah. Emily, are we gonna fight with technology? I mean, sure. Why not? We're all here together. It's time for Emily Fights with Technology. Hopefully it won't be too bad, but I have multiple different scenes to do multiple different things. Emily, this ain't a scene. It's a goddamn arms race. I know. And you are correct. But also, I generally have these set up for the things I do every day. And then it got all out of control because trial. And I moved it to show the seal better. And now I have to just, there we go. We got to make it look, Emily, you just want it to be kind of pretty. I want it to be readable. I would like it to be easy to read. There we go. That didn't take too long. We're getting better. I'm getting better at it. For everyone who has watched me film the podcast in the background, I will take all of the positive affirmation on the fact that I'm getting better at that. I will take it. All of it. Take it, we'll take it. So, sentencing provision. First degree felony, aggravated murder, non-capital felony. Emily, why is this a non-capital felony? Because the prosecution chose not to seek the death penalty. For everyone who said you're doing amazing, sweetie, thank you. Thank you, Chad. Thank you. I need it. It's been a day. This is a non-capital felony because the prosecution chose not to seek the death penalty in this case. So it is a non-capital felony. Were it a capital felony, they would have gotten 12 jurors. And the defense actually argued that this should get 12 jurors because it could be a capital felony. They could have filed to seek the death penalty. They chose not to. But it could have been. So the defense was like, but it could be a capital felony. We should have 12 jurors. And the court was like, the law is clear. If DP is not on the table, then you do not get 12 jurors. DP not on the table, no 12 jurors. So, first degree felony, aggravated murder, non-capital felony, penalties sentenced by the court. A person who has pled guilty or been convicted of a first degree aggravated murder, Kouri Richins, shall be sentenced by the court. The sentence under this section shall be either life in prison without parole or an indeterminate prison term of not less than 25 years, and that may be for life. So the floor on that is 25, and then it goes up. And then the up is determined by the Department of Prisons. So they can then determine whether she's eligible for parole down the road, and things like accepting responsibility and all of the things you can do in custody can play into that. That's up to the parole board. So she could either get life in prison without parole or 25 to life. The judge will get to choose. Now, I can see the prosecution arguing for 25 to life and then adding all of the other sentences. So it ends up being 25 plus, I think it's 15 on the attempt, but we'll go look at that in just a second. But 25 to life plus 15 would be 40. And then plus the fraud counts. I could see them arguing for either like almost 50 years. I don't know if they'll get up to that number, almost 50 years to life as a floor instead of LWOP, and saying it should be this or LWOP. And so I think we will see the prosecution arguing for that. I imagine we will see the victim's family asking the court for life without parole so that they do not have to worry about the potentiality of her getting out of custody one day and continuing to wreak havoc on their family. She's shown no remorse. There is a DV aggravator, which will add time. I do not know how much. We will see. There are multiple aggravators found here. I think there is an argument for life without parole. But I could also see the argument of, is she a danger to the broader community, or was she just a danger to those who trusted her the most? And there's an argument that, and I think the defense will probably argue that this should be 25 to life. But we'll see. But there is an option there. I thought it was just a straight LWOP case. Then again, when we covered Sarah Boone, I was like, wait, you get like life period on a second? What? Like Sarah Boone's got to be sitting in custody being like, what do you mean I never get parole? And Kouri Richins can get parole. Sarah, girl, you were in Florida. Not the same. So LWOP is on the table. 25 to life is on the table. This makes a ton of sense why a pre-sentencing investigation will matter so much. A huge factor of pre-sentencing investigation is taking responsibility. Chat, do you think that Kouri Richins will show remorse and take responsibility when she's interviewed between now and May? Yeah, me neither. And I think the unredacted walk the dog letter, where she's threatening her sister-in-laws, will play into sentencing decisions heavily. Because not only after the murder of Eric did she never, ever take responsibility for it, but she was threatening her sister-in-laws in a variety of ways, and she has another pending case. So I can see the argument for both. If I'm the prosecution, I'm arguing for LWOP. And then at the very end of that, I'm saying, and if the court is not inclined, then I think it is appropriate that all sentences run consecutively. And you stack as much time as you can so that the number of years to life is the biggest number of years possible. And be like, fine, if you want her to have a hope of getting out of custody one day, 25 years is not enough. It needs to be more. And so you stack that up. We'll see. So 25 to life is an option here. The defense will be arguing heavily for 25 to life. I would be surprised if the family did not ask the court for life without parole so that they can close this chapter. Like the clanging cell door of a luxury prison for rich people. Probably not in those words. We're going to take a look at the attempt real quick and the sentencing on that, and then we will go to the jurors. Shelby, I see your question. We are going to talk about that after we get through the sentencing. Shivani in the chat said, will the fraud trial still happen? we'll see what happens. A lot of defendants, depending on their sentence, would try to get a plea deal. If Kouri Richins, there's a lot of ifs. If Kouri Richins gets a indeterminate life sentence, meaning X number of years to life, I can see her immediately trying to take a plea deal in the financial fraud case to try to knock the amount of years that can get added on to that indeterminate life sentence down, or take a plea deal for those to run consecutively. Now, I don't know if the prosecution would be inclined to do that in any way, because they still have a choice. They can be like, nah, no, you don't have restitution. We're not going to roll that way. Mount up and ride. Let's do this again. There are reasons why the prosecution also might say, yeah, you know what? Take the plea, this amount of time, concurrent, consecutive, restitution, we'll figure it out. There might be reasons to deal that. If she gets a life sentence, like an LWOP sentence, I could see Kouri Richins being like, you know what? Nah, let's go back to court. Let's go back to court. Because it could delay her being transported to prison and keep her in local custody while she still has another case pending, which she might find preferable. She might not. It depends. She can probably Google it on her tablet. And ask her lawyers. She might think it is preferable to stay in local custody. She might think it's preferable, if there's going to be media coverage, to stay with the media coverage. She might think it's preferable, while she is appealing the murder trial, to not admit to guilt on the fraud trial. And I think we'll see her going full like Elizabeth Holmes and like, it's business. In the criminal trial, they said I needed an accountant. I'm just a girl. It's my bad. It wasn't fraud. They gave me the money. Did you tell them the truth when they gave it to you? I mean, what is truth? I'm just a girl. I did not rob them. It's just business. Creatively. Sure. So I can see it going a couple different ways for a variety of different reasons. I think the sentencing on the murder will inform the process, but I could very much see Kouri feeling that the spotlight is worth it, or feeling like, you know what? I could see this too. I didn't testify in my last trial. What more can they do to me? Let's go. I'm going to testify this time and explain to all you fuckers why you're dumb. Idiots everywhere. I'm going to get on the stand and tell you what. Because there's nothing left to lose at that point. If she gets LWOP and is appealing and maintains her innocence, I could see her being like, you know what? Y'all are going to hear what I have to say this time. In my yellow shirt. You're going to hear it. Because it can't get worse. What are they going to do? Convict her more? Oh, okay. Sure. So I could see her choosing to go to trial so that she has the opportunity to take the stand and tell everybody what she wants to say. Especially if she can figure out how to get some crust white strips into custody. Yeah, I could absolutely see that. I could absolutely see that happening. Because why not? And she can write a book about it. Yeah, I could see that. I could 100% see that happening. On the fraud case, Lou, Grace, 11, Emily, is it the same defense team doing the civil litigation? No. Oh, did that air last night? Kristen said, I saw you on Nightline last night, Emily. You did phenomenal. I know they had pushed it. I didn't know it was airing last night. If I find it online, I'll share it with y'all. Good to know. I don't think I knew that, but I was chatting with Travis. There's probably an email. that I have seen, that I have not seen, but there's probably an email that I have not seen. Fair enough. If it's on the internet, I will share it. She also will probably not have the same defense team for the fraud case. She does not have the same lawyers for the civil case. And when the lawyers took this case on, the fraud case, they said they were taking this fraud case on till the end of this trial, the murder trial. This is not like their wheelhouse. I'd be interested if like Ramos stays, but he's at a different firm. Nestor and Lewis are not going to stay on the fraud case. They do not want to do it. They do not have the bandwidth for it. They're not doing it. So they are going to at some point withdraw from that case. I imagine that's not going to happen until after sentencing. And then she's going to have to get appointed new counsel. There's a conflict, I am sure, with the public defender's office still and the alternate public defenders. And they're going to go to the panel again and find other attorneys to represent her in the fraud cases. So we'll see. Ramos is a different firm than Nestor and Lewis. So I don't know if Ramos will stay. I don't know if Ramos would want to. I don't know if Kouri would want him to. She doesn't really have as much of a choice. But the day that they were talking about whether they were staying, the day that they did arraignment for the fraud case, it was not streamed. I was on WebEx when that call happened. And the defense attorneys essentially said that they would stay on the fraud case until the conclusion of the criminal case, but that they were not accepting appointment on that case through trial. So they will be off of that case, and they advised the court of that early on. We'll handle it for now, but that case can't move forward until this. So, Tan said, what about Sky? A, I don't think Kouri could afford to rehire Sky, would be my guess. And B, Sky had a conflict that's going to bounce her out of everything. Whatever conflict she had will bounce her out of everything. The conflict with the public defenders was some of the witnesses. So a number of the witnesses have cases that the public defender's office has represented. And we will see some of those witnesses in this case as well. So let's see. We're going to, what did I say we were going to, oh, the attempt. We didn't finish the attempt. Emily, you just started answering questions. I know. That's why I try to hold them to the end, but law nerds are so smart. They're such good questions. But I also want to make sure that we get through the things we wanted to talk about. And I'm going to continue holding some of those questions, and we'll get to it. Shania, we're going to talk about that in just a second. Shania asked about Lisa Darden. We're going to talk about that because the headlines on that are wrong. Lara, is Bestie Chelsea part of the financial crimes? Yeah. Bestie's a big part of the financial crimes case. Bestie's a big part. Bestie's a big part of the financial crimes case. Let's look at the attempt real quick and go from there. That's not what I wanted to do. All right, attempt. Classification of offenses. A violation of section 76-4101, where the actor attempts to commit a capital felony. That's where we're at. We're in the realm of a capital felony. Because they found the aggravating circumstance of pecuniary gain, we are in the world of capital felony, or felony punishable by LWOP, is a first-degree felony. So it says, except as provided for in subsection 2. I don't think we're in subsection 2. I do not practice in Utah, but I do not think we're in subsection 2. Subsection 2 is an aggravated murder which results in serious bodily injury. Eric Richins, by all accounts, was ill and then still went and picked the kids up. So did not go to the hospital. There is argument here that the attempt did not result in serious bodily injury. I think you would be very hard pressed to argue that the attempt resulted in serious bodily injury. I had one of my colleagues' cases at the DA's office was an attempted murder, and the victim had been shot literally in the face, but had been shot in the face with a .22. And by all of their guardian angels, God, and whatever powers of the universe, that bullet hit the victim in the forehead and did not penetrate their skull. So they were shot in the face with a gun, saw the person shoot them in the face with a gun with a .22, and had like a butterfly band-aid. Split the skin, did not penetrate the skull. And so when they were arguing over serious bodily injury, the court was just like, they didn't get stitches though. And the DA was like, but they were shot in the face. And the judge is like, yes. However, butterfly band-aids. And the DA was like, yes, but shot in the face. And the judge was like, I get what you're saying to me. However, I don't think that falls under serious or great bodily injury. Because butterfly band-aids, like not even a stitch. So like, I don't know if we can argue. We can argue there was an attempted murder. We can argue there was use of a gun. But I don't think we can argue that there is, under the law, serious bodily injury. And the DA was just like, I understand. However, shot in the face. So there are circumstances where you can have a very unusual result where you have an attempted murder and the person does not have, under the law, serious bodily injury. And under the law, things like, and I saw all of you saying, okay, but the trauma, I agree, but that's not accommodated for in serious bodily injury. Serious bodily injury is defined. Not even having stitches isn't going to count. And I think in this case, Eric Richins being able to drive the kids to school and being able to, not go to the hospital, I think is going to be the argument that there is no serious bodily injury here. So Ash asked about, what about a concussion? Not the facts of the case that we had. I think there is argument about a concussion. Psychological injury does not count under the serious bodily injury statutes. There are other statutes that can accommodate things, but when we're talking about bodily injury, we are talking about physical injury, surgeries, lots of stitches, broken bones. We are talking about physical injuries. So the butterfly bandages did not count. And it was one of those arguments where it was like, I mean, I'm really glad, like you're glad for the victim. I'm really glad for the victim. But also you're like, this is odd. This is an odd result. So serious bodily injury under the statutes and under the case law talks about physical bodily injury. So I think in this case, using that case as an example, I think in this case, based on the facts, there is not an argument that serious bodily injury on the attempt happened. So in this, I do not think we are in the world of 15 years to life, because I do not think under the law they will be able to argue that there is serious bodily injury. So, wit's end, this is a great question. I'm going to hold on to that real quick. So with concussions, chat, there is an argument, and I bet there's case law on concussions. It wasn't the circumstance with the victim who survived that we talked, well, obviously survived because it was an attempt. There was no indication of concussion and no treatment for concussion. So I don't think we are going to see the argument that this should be 15 years to life, because I do not think we are in the world of serious bodily injury. So I think we are just looking at a capital felony that's going to be punished as a first-degree felony. So if we are looking at that, and if I am reading this correctly, it looks like we might be in the realm of 5 years to life for an attempt, which also breaks my brain that's kind of where we are. But I think we are in the realm of an additional 5 years to life, which again seems really low to me on an attempted aggravated murder. It seems like we should be in the 15 years to life realm, but vibes is not what we do. I think we're probably in the 5 to life range, which would, if you stacked them, put her in the potential of 30 to life before we get to the fraud cases. So we, I think, are in this 5 to life range because it says it's a first degree felony. And then it talks about murder that's a first degree felony is punishable by 5 to life. Maybe they mean first degree felony under a different subsection, but I think it is 5. I hope I'm wrong and it's more, but 5 to life is a wild swing. That's the wide open spaces right there. But it could be consecutive. Again, my focus is on the count 1, not really count 2, but my focus is on count 1. So again, if she is sentenced to life without parole, will this matter as much? Not necessarily. If she is sentenced to 25 to life, this will matter more. There will be sentencing memorandums that are filed. We will go over them. So what I wanted to correct the most is that LWOP is not the default. It is a possibility. And on this, 5 years to life is 5 years to life. And then the prisons decide how long that is, which we saw in the Ruby Frankie case, which also my brain was like, wait, what? The prisons just decide. Okay. Sure. Strange to me. So let's see. Amy said, does Judge M have the discretion to disregard the prosecution's recommendation? Yes. Judge M can sentence under the law. And on count 1, under the law must be, it says shall, must be either 25 to life or life without parole. Those are the only 2 options. But Judge M has both of those options and can do either. So sentencing, when I said it on Monday, I was like, oh, it's just going to be LWOP. It's an aggravated murder and they didn't seek the death penalty. The only option left is LWOP. Wrong, I was wrong. I still want it to be the way that I explained it, but I do not get to change the laws in Utah. Emily cannot bippity-boppity LWOPity. That's not what happens. Utah is like, no, there are options. Utah is going, there is room for redemption. However, redemption normally, in my understanding, redemption normally involves some type of accountability. So I have not seen any taking of accountability, and I do not think we will see that prior to sentencing. Do you? I don't think we will. I really don't. But then again, the family also has an option to ask. I doubt that any members of the family want the possibility that one day Kouri will be sprung back into the community upon them. But you never know. Families choose to grieve in all different ways. And I don't know. People find forgiveness in ways that I struggle to understand. The same way sometimes I struggle to understand. But I do think when people find forgiveness, they do it for themselves and not for the other person. But I'm interested to see what the family has to say. And then all of this, again, will be subject to appeal. Because she's going to appeal. And I think the way she threatened her sister-in-laws in the walk the dog letter and more does indicate that she still is dangerous, and there still is another case. And that other case is not just going away. 26 additional felonies. I think there will be an argument from the prosecution that she is a danger beyond just herself, even if it's not necessarily a danger that she is going to go out and commit more murders. It does not mean that she is not a danger and that she will not try to continue to harm people. And there are more people harmed in this case, none as seriously as Eric Richins, but there are more people harmed. And when you add the fact that this is a domestic violence aggravator, which she agreed to, I think there's a lot of room for the judge to decide that this is an LWOP appropriate case. So we will see. The judge will get to decide. We will get to watch. Right outside the office. Yep, it's just going to be like that. For all of you that missed the beginning, there is work being done at the house. So if you hear noises, they are mine, not yours. No one is knocking at your door. Come and knock it. No, it's not you, it's me. So if you're listening in the background going, wait, what is that? It's me. It's my house. Apologies. I try not to do that to y'all because it's so confusing. You're like, where is that? Is that me? No, it's just me. So sentencing is going to be May 13th. It happens to be the victim Eric Richins' birthday, which when they set the sentencing date, we were just like, wait, what? I know a lot of you were like, I thought somebody was at my door. I'm sorry. I know. So we'll have to wait for the sentencing. There will be victim impact statements. It's going to be a hard day. It is okay to watch that, not in real time, depending on what you want to do. Impact statements are a difficult day. G Media in the chat said, why would she agree to the DV aggravator? It is a sentencing enhancement, and they didn't want the jury considering it. And the factor that needs to be found is that they were cohabitating. There's no argument that they weren't, and the defense didn't even want the jury thinking about it. So they agreed, and goody. They agreed, and then they took a waiver from her on that. All right. Good Lord. We're going to go to the juror statements and to the bond hearing so I can mute myself when there's noise. And then the next time we do a stream with Dr. B, y'all can let him know. Y'all can let him know that he read that situation improperly. Yeah, I'm sorry for the it. Yep, that's happening at my house. I'm going to queue up the juror interview. I will do my best to mute myself off and on as we get into this, but let's swoop to the juror interview. You guys, there are certain things that just stress me out. This is one of them. I can feel it. Not like coming in the air tonight. Like I can feel the anxiety. I'm just like, it stresses me out. Juror interview. One of the jurors gave an interview to ABC this morning. Let's swoop and talk about it. It is a 3-minute interview. After this interview, we are going to go to the bond hearing that we have not covered yet. And we're going to talk about this juror interview. Again, it is like 3 minutes long. I was hoping we would hear more. I don't think we will. I think that this juror is the foreperson based on everything I have seen. And so when we're taking a look at this from Good Morning America, what I think we are looking at, not yet, what I think we are looking at is the foreperson's thoughts on this verdict. I am very interested to hear what they have to say. I hope that you are interested to hear what they have to say when they sat down with ABC. Hold on. Let me just cue this up so we don't get like fully yeeted, but it is newsworthy and it is worth covering. I will link the full video below. We're going to skip through the anchor reporting and get into what the juror has to say because that is what we want to see. We know that Kouri was convicted. We do. We know that happened. We don't need the reporting on it. We'll see it. So delightful. It's delightful. It's delightful. Let's take a look at what that juror had to say. Let's type properly. All right. Shall we? Ooh, we could do it this way. Hold on. Let's do it that way. Emily, really? Yes, this is the thing. We're going to do that. We're going to do the non-court one because we can. Why? Because we built our own software and it's fun. Really? Yes, really. Love it. We're sending it with that. Let's take a look at what they had to say.
Mom Kouri Richins guilty of killing her husband Eric by spiking his drink with a fatal dose of fentanyl is speaking out for the first time.
There was never a not guilty check with anything, with any element, nothing.
Here's why that's so interesting to me. Do you remember what the defense asked in their closing? The defense said, don't just go back and take a vote. Go back and look at where there is doubt. And this juror is like, nope, yeah, no, no, no. There was never any NG. There was never any NG for us. Nah, nope, no doubt. So interesting that there was zero not guilty, zero reasonable doubt for them.
Is speaking out for the first time.
There was never a not guilty check with anything, with any element, nothing.
Laura and her fellow jurors taking less than 3 hours to find Richins guilty on all 5 counts, including aggravated murder, insurance fraud, and forgery.
Even though
I just want to hear what the juror has to say, but it is interspliced. I do not think that creates an issue for appeal. They were convinced by the evidence. I do not think that creates an issue.
Oh, it was just 3 hours. I felt like we came into that deliberation fully loaded to evaluate the case and to look at the evidence. We had to zoom in on these little bits of evidence and kind of ignore all the fluff and ignore the drama.
Laura says each juror had their...
Emily, what do you think they mean by ignore the fluff and the drama? The gummies, the empty pill bottle, the rest of it. I think this is the foreperson, but yeah, ignore all the fluff, all of the like smoke and mirrors that was put up. Ignore the, this is a wife becoming a widow, and look at the evidence. What do we know? And I think it also means just what do we know that's proven, right? Wow, that's loud.
Up with.
I'm going to back that up a little. I was trying to zoom through the anchor.
All came to the same conclusion.
We were so pent up with so much information and emotion. And so we decided to just go one by one around the table and just let it out.
In 2020.
And this makes absolute sense to me. They've been there for 15 days without a chance to talk about the case. It makes sense to go around the room and say, what did you think? Where are you at? Let's let everyone say what they need to say. What are you thinking? What are you feeling? Talk to me. And I think that's a fair way to do it. Also, the way that she speaks about how they organize themselves also indicates to me that this is the foreperson. And after 15 days, you would want to talk. Absolutely.
23 Richins published this children's book on grief. She says was to help their.
This is a clip of Kouri on the news. We're going to zoom past that. I want to hear what the juror has to say. Oh, the juror's face has a lot to say about the book.
The book in the final days of testimony.
Everyone's just felt like they're hit with a truck. We're like, what? Like, what the hell is this?
Uh-huh. That does not surprise me. What the hell is this? Right. What is this book?
It was so odd and so strange.
The defense rested without calling.
Emily, you're zooming. Yes, I want to hear just what the juror has to say.
Because they did not.
Sided with the prosecution.
People were really sad because they did not want to find her guilty. They were really hoping that she was innocent. And
that makes a lot of sense to me when the juror's like, we went in there wanting to believe that this was all a big mistake. That makes so much sense to me. We wanted to believe that someone would not do this to their spouse. We wanted to believe that this was a horrible accident, because believing that someone would do what Kouri Richins is convicted of doing pulls back a curtain onto something incredibly dark, incredibly chilling, and incredibly scary. That the person that you could be sleeping next to at night could be planning to do this for months and months and months. And so it also says to me that the jurors went in there with not just the presumption of innocence, but actually the hope of innocence, which is more than a lot of jurors go in with. A lot of jurors go in with like, yeah, I know they haven't proved it. Yeah, they're presumed innocent. But like, why are you sitting over there? These jurors went in with, I really do not want what the prosecution's saying to be true. That is kind of above and beyond just the presumption of innocence. And I think that that is incredibly fair and very, very human. And I appreciate that the jurors shared that they went in hoping that this wasn't true. Because if you're going to look at the defense trying to say that this jury should have been moved, or that this jury should have been in Salt Lake, or that this jury should have been somewhere else, and you've got a juror saying, no, we went in there not just believing in the presumption of innocence, but actually really hoping that she was innocent and hoping that we would not see that she did this. And I think that's incredibly telling, that the jury did not want to just go in there and be like, done. Because I think there's a lot of people online who are just like, you know what? They hated her ass. I don't think that's true. I think they were hoping that what the defense said to them was correct, that this was all some horrible mistake, and that this person really didn't do this to their spouse. And it almost sounds like when they got back there, they were just like, ugh, damn it. And that's pretty telling.
For her husband's money. In the end, the jury sided with the prosecution.
People were really sad because they did not want to find her guilty. They were really hoping that she was innocent. And we couldn't come to that conclusion. And it was really heartbreaking, this devastating reality that this family was torn apart. And these poor kids will really basically never have a dad or mom.
Yeah, Richins is.
That is, that's what you would want from a jury. What you would want from a jury is we do not want this to be true. We do not want this to be the circumstance, and there is no other option.
And it was really heartbreaking, this devastating
It's
reality that this family was torn apart. And these poor kids will really basically never have a dad or mom.
Yeah.
And that is the entirety of that juror's statement. I'm just going to zoom because the anchors go to talk about it. Oh, and I love that YouTube's like, you want to see Peter? There's YouTube is like, Peter's up next. That's funny. Go YouTube. But with whenever jurors speak out, there will always be a conversation around, is this going to cause a problem? Is this going to cause a problem on appeal? Is this going to somehow undo everything? And I don't think that's what's going to happen here. Sydney, we're going to link it below. It's commentary. And if you want to go watch GMA, you can. I'm not going to play the anchor's commentary. We're going to look at the newsworthy parts of it because that's what we're going to look at. But if you want to hear the anchor's commentary, Good Morning America has it on their YouTube channel. So I'm not surprised that the jury took this so seriously. And it's actually somewhat refreshing to hear a juror say, this was heavy, this was sad, this was a decision we didn't want to have to make. And I think that's very human. I think that's not something we always see the jurors express, but there is a weight to this. And the weight to that is, I think, well stated by this juror, though they seemed nervous to be, trying to be on Good Morning America via like Zoom or whatever. But it's hard. So it is hard. We don't always get to hear from jurors. I wish it was more that we had heard from the jurors other than like 3 minutes. But they splice. I just wish they didn't splice up what the juror had to say. And just like, if you talked for 15 minutes, just give us the 15 minutes of what the juror had to say. So with that, we're going to go look at the bond hearing. I'm glad to hear what the juror had to say. If the jurors speak out anymore, we will see that. But that's the entirety of that video. Chat's saying more in the written article. I'll go take a look. We can take a look and see if there is. I'll go take a look at that. Articles are much easier to bring up. And then we'll go take a look at the hearing. So let me pull that up if there's more. I appreciate it. I think after our chat this morning, you understand when I grabbed the video that I did not go and look and see if there was more in an article because we had a morning. So let's see. Let me just take a look real quick. Because I would like to hear more from the juror, for sure. Let's see. All right, let's take a look at what ABC News has to say once we get this in a readable format. And by readable, I mean dark mode without autoplay ads as best we can. All right, let's take a look. They describe that it's the foreperson in the article. They didn't say it in the video. I thought that it was based on what we saw. It's nice to see that they clarify. I mean, that's helpful. So good to know that we are correct in that. Thought that it was, not surprised. Let's take a look at what ABC has to say. Let's see if we can do it this way. Perfect. All right, we do not need dramatic headlines. When Laura, they say the foreperson in the Kouri Richins murder trial first saw the mother accused of murdering her husband. She didn't think much of her. Okay. I mean, I imagine the same as Adelson. She was kind of nondescript. Oh, Corey's going to fucking hate that. Oh, Laura. Laura, you do not know Kouri yet. Oh, boy. Oh, boy. Oh, boy. Oh, boy. Laura, she's going to be on multiple jail calls talking about you. Oh, dear. Oh, that is... Oh, that's going to hurt. That's going to hurt. Bloodworth is somewhere laughing. Going, yeah, and she's not a good writer. I know. I think that skirts chat rules on name callings. I don't think that's name calling. I think that is clocking it accurately. Or as the kids say, why? I don't know. I like it better than 6'7" though. So we'll just... She was kind of nondescript, she told ABC News Good Morning America in an exclusive interview. She didn't really show that much emotion. I was trying to get some vibe from her, and it was very hard to pick up on any kind of vibe. Fair. The foreperson was one of the 8 jurors who convicted Richins. They then described the case. She then goes on to say what she said that we saw in the interview. There was never a not guilty check with anything, with any element, nothing. Oh, boy. Lyndon clocked that in the chat. Mediocre prisons for the nondescript in America. It's true. Who said that's facts and evidence? It went by so... There we go. Allie Mama Bear said that's facts and evidence. Yes, it is. My views through a lens at my teen done that to me a few months back, and I was like, what? Yeah, yes. I try to keep up. I can't always. There was never a not guilty check with anything. The prosecution has to be happy with that. The defense has to be pissed. There was never a not guilty check with anything, with any element, nothing. The foreperson, Laura, who was juror number 2, told ABC News of the 3-hour jury deliberations on Monday. Even though it was just 3 hours, I felt like we came into that deliberation fully loaded to evaluate the case. And I mean, they took good notes. And juror number 2, I'm not surprised it was the foreperson, because juror number 2 is the one who was like, weren't we supposed to get a stipulation? I have a note that we were supposed to have a stipulation. Do we have that stipulation? Like, juror number 2 clocked it down to the, where's that stipulation you said? Which was fantastic. So I'm not surprised that everybody's like, and you're the foreperson. Thank you so much. You have been voluntold. You seem very organized. We'll just, you're the foreperson now. They would have gone back into that jury room and everybody would have been like, so we have to pick a foreperson. You're going to do that, right? You're good with that? Good. Voluntold immediately. She said that, let's see. The jurors were shocked when they were told about the book in the final days of the testimony at the trial. Laura told ABC News, everyone just felt like they're hit with a truck. We're like, what? What the hell is this? It was so odd, so strange. They go on to say that, let's see what else the juror said. People were really sad, which we heard in the interview, because they did not want to find her guilty. Laura told ABC News of her fellow jurors. They were really hoping that she was innocent, and we couldn't come to that conclusion. And it was really heartbreaking. There is a heaviness of sitting in judgment of someone else. I imagined that the Walsh jury also, I mean, the Walsh facts are so different, but I imagine the Walsh jury must have also had a moment of like, please do not let all of this be true. This is so awful, just awful. But there is a world where somebody could accidentally OD in this way. This is not that case. Walsh, that's not the case. That's not the case in Walsh. She added that this devastating reality that this family was torn apart and these poor kids will basically never have a dad or a mom, which is true. And okay, so not much more in the article, but that's what was in the article. So they were trying to get a read on her, and they called her nondescript. And at the end of the day, the jury said, we were looking to find not guilty. We were hoping to find not guilty. And we could not come to that conclusion. And that was really sad and really hard. I think that's fair. However, could we ask about the walk the dog letter? Why is no ABC? Look, we do stuff together, ABC. Could you just like phone a friend and ask about the walk the dog letter? We want to know what they thought about the walk the dog letter. I want to know immediately. I also want to know about the steak dinner. Fair, Rex. Rex is like, did they get a steak dinner? These are the things we need to know. TLO said 8 jurors should be illegal. The legislature gets to choose. And the legislature chose. So the legislature picked. And they get to pick. Let's see. There's another article where they talk about the walk the dog letter. Miguelina, thank you so much. I'm going to go grab that right now. Apparently there's another article. Look, they're just, this is why we cover things not in real time, but also this is why we cover things with chat and producers. Because then Miguelina's like, psst, there is one. She answers that question. Perfect. Let's pull it up. Let's see if we can pull it up without 900 autoplay ads and put it in dark mode, because Emily can't read anything if it's not in dark mode. We know this. We know this to be true. All right, let's take a look at a second article. We're going to swoop. We get to use our swoops today. Also with ABC, right? Because ABC would have gotten the entire juror interview, would have sent it out to their affiliates, said, this is what we're putting on Good Morning America. This is what you can tease, and this is what you're allowed to put out after Good Morning America. And then all the ABC affiliates would have run with it. So that's why you're seeing different versions in different places. All right, Emily, inside media a little bit. All right. I can't talk about the autoplay ads because... Juror speaks after delivering guilty verdict in Kouri Richins' murder trial. I love this headline. Look at that. Just the facts. Sticking to the facts. We love the facts. We do not need any more. I'm sorry, Miss Nestor. We're good. We're good. Now that we've gotten the headline, let's see if we can just get to the body of the article here. Emily fights with tech. Nope. It's not going to let me do it that way. Every website is laid out differently. This causes me unending frustration. There we go. Good. We will link all the articles in the description as well. And in case any of you want to go back and look at them, we will link them. Let's see. This is from Park City, Utah, ABC 4 from this very morning at 9:42 Mountain Time. Kouri Richins, 35, was originally charged with aggravated murder. We know the trial began February 2026. Was it only February? Lasted for 3 weeks. After going into deliberation for just a few hours, a jury read the verdict at 6:35 p.m. Mountain. They say Mountain Standard. Isn't it Mountain Daylight Time now? Don't we change it? Don't we put the D in after we spring forward? Or are we on, is it saving time, not daylight? I don't know. Time is a construct. What's the difference between ST and DT? And isn't there a D? Don't we spring forward, we lose time, and then we get the D? Isn't the D like a consolation prize? Emily, the D is never a consolation prize. I thought S was standard, right? Not saving, and D is daylight. I thought we were in the D. Damn it. Where's the D? Ugh. Either way, they say 6:35 MST. I think it's 6:35 MDT. Emily, time is a construct that you do not understand. Why are we arguing over this? ADHD. I can't unsee it. Anyway, they delivered the verdict at 6:35 p.m. Mountain Time. Richins was found guilty on all counts. Sentencing has been set for 9:30 a.m. MDT, Wednesday, May 13th, which also happens to be the victim's birthday. Exclusive interview. One of the jurors, identified as Laura, spoke exclusively with Good Morning America, where she talked about what it was like to sit in the Summit County courtroom as the prosecution and defense made their cases. Well, on day one of trial, Laura recalled feeling as if the Richins family was very tight-knit, and that Kouri was trapped. That's interesting. There was so much anger towards Kouri from the family, which Laura said impacted her original opinions. Oh, did she change her mind? Interesting. Quote, the first thing we hear is these terrible things about her from her sister-in-law and her father-in-law, and she's just sitting there like all by herself, Laura said. At first I was thinking, without hearing the whole story, that Kouri was definitely feeling trapped. Interesting. I love a juror that's open to changing their mind. And you know what? I was surprised that the defense, because we know the defense watched the Karen Reed trial based on some of the things they argued and did. I'm surprised they didn't leverage the outsider angle more. I'm really surprised by that. But they didn't. I really thought that they would. The juror goes on to say, Laura told Good Morning America that once the rest of the evidence, especially the forensic evidence, was revealed, her opinion changed. She said she was blown out of the water. The jurors could then focus on the facts rather than just the family drama. Well, wait until you see the unsealed walk the dog letter, girl, because damn, once you see the whole thing. But again, it's nice to see that jurors can change their minds. One of the most impactful pieces of evidence, according to Laura, was the cell phone pings presented by the state during the alleged drug purchases. They're not alleged anymore, ABC, during the drug purchases. While Carmen Lauber and Robert Crozier's testimonies weren't highly reliable, Laura said the jurors could still grasp what was happening and connect it to the movement of people's cars through their cell phone use. Digital evidence always matters. In fact, Mr. Digital Evidence Kostradimas sent me a message and talked about how great this community was and that he appreciated seeing our coverage of the case and how much we enjoyed the digital evidence. So Mr. Kostradimas, hello. It was lovely to see your message. And yes, the Lawnards are the best chat on the internet. So I was not surprised that Mr. Kostradimas also appreciated how much the Lawnards appreciated. I mean, it's rare that you get 40, 50,000 people going, oh my God, these exhibitors are amazing. Look at how clear the digital evidence is. It's a rare thing that many people are genuinely hyped about your PowerPoint. The hype was real, though. It was a great PowerPoint. I also love how they showed the movement of the phones and the meetup at the Draper in Maverick. I thought it was fantastic. And I'm not surprised that the jury was like, look, people might lie, but your phone's going to tell on you. And so even though they were like, I'm not sure where we are with Crozier and with Carmen, the phones don't lie. It was great exhibits and they made it so easy. Kostradimas made it really easy to follow. I'm not surprised that you see the foreperson of the jury saying that the cell phone use and following the cell phones was a huge deal. It goes on to say that Laura noted that some pieces of evidence carried more weight than others. For example, she said that to some, the walk the dog letter was the smoking gun, but to others, it lacked significance. That's interesting. There were jurors that were like, meh, on the walk the dog letter? It sounds like the jury were not just in lockstep with the prosecution and that they, evaluated the evidence, which is nice to hear. Some were just like, whatever. Fair. Quote, it was so amazing to see the difference of opinions people had and perspective, and that happened often with respect to the different pieces of evidence and the witnesses. But we all led to the same conclusion, that she was guilty. Right. It was really heartbreaking. It goes on to say when it was time to decide on a verdict, Laura told GMA that the jurors chose not to take a formal vote, but instead held a roundtable to discuss all the evidence and testimonies. We decided to just go one by one around the table and just let it out, like nothing in particular, whatever you wanted to say, whether it was emotional experience, whether it was about evidence or witnesses or anything, it was just a chance to let out steam, she said. The roundtable helped all the jurors get on track and in the right headspace to make a decision. They needed to process it. That makes sense. It's completely fair. Ultimately, the group decided that Kouri was guilty. While it was a difficult decision, as no one wanted it to be true, the copious notes and evidence showed that she was. People were really sad because they did not want to find her guilty. They were really hoping that she would be innocent, and we couldn't come to that conclusion. It was really heartbreaking. I think that's fair. You're not going to get much to fight out of this juror's statement. This is what you want a jury to do. You want a jury to go in there and say, is this person not guilty? No, we can't come to that conclusion. And it sounds like they started from the presumption of innocence and then worked towards guilty versus she's guilty, convince me otherwise. I think that is the way the system is intended to work. Start with the presumption of innocence and work from there. And that sounds exactly like what they did. I think the prosecution's closing really helped them walk through this case. I think the closing for the prosecution walked them through this and this and this and this and this. I mean, this is what you want a jury to do. I'm sure Kouri Richins doesn't like the result, but this is where you want a jury to be. It's completely fair. And it's better than seeing a jury that's coming out here saying, I mean, who the fuck does that to their bestie? Obviously, she's a murderer. That's not what you want a jury to see. This jury didn't start with, we fucking hated her. This jury started with, we really don't want this to be true. Fair. And they took the weight of it really seriously. That this was heartbreaking. They were diligent. They were quick. They processed quickly. But it sounds like they were diligent. During deliberation, Laura shared that the jury discussed Kouri's demeanor. The group had a hard time getting a read on her, stating that she seemed like a statue. Oh no. Well, the defense wanted to make that analogy in closing. Don't blink, ladies and gentlemen of the jury, don't blink. She was very still on the face. You know, a couple of times I would see her laughing a teeny little bit or smiling when she was talking to her defense counsel. But other than that, there was very little emotion. Oh, y'all were locked in on the witnesses when she was facing at them then. Y'all were locked in on the witnesses when she was sitting over there going, what? Fair. Fair. The most emotion Laura ever observed from Kouri was when the guilty verdict was read. She seemed upset and shocked, but Laura did not feel like she had any remorse. The judge said, if you have an emotional response, put your head down. I think Kouri felt like she was being told she was supposed to put her head down because she didn't clock much of an emotion and she put her head down. The judge said, if you're having an emotional response, look down. And Kouri was like, oh, I'm supposed to look down if I have an emotional response? Great. We done now? No? Okay. Are we done now? No? Okay. Now? Are we good now? Okay. The foreperson did not feel like Kouri had any remorse. I think when the verdict was read, I think she was surprised. Oh, I definitely think she was surprised. And she was shocked and upset. I didn't see any remorse whatsoever. Yeah, I agree. I agree, juror. I think Kouri thought that y'all were going to buy into her story. I think she went into this trial thinking that y'all were going to see it her way because everyone else are idiots everywhere. Yeah, I think she was shocked. I think she was absolutely shocked. And I think she was mad. But I think she was very surprised that everyone didn't just see it the way that she did. Yep. Laura goes on to say, maybe the other jurors had a different perception. I think she was kind of in her little world. That's a kind way to say it. Kouri was sitting there thinking idiots everywhere, and I imagine her jail calls afterwards were similar to what we see from Charlie and Donna Adelson. Goes on to say after the verdict was read, the jury was able to talk to the judge afterwards. Oh? Excuse me, ABC. Why is this only one sentence? 2 sentences. Y'all got to talk face to face to Judge M. Why isn't that the entirety of the interview? ABC, you are not delivering what the people want to hear. Can you tell us more about what they thought about Judge M and getting to talk to him in person? Tell us more about that. That should be the headline. Jurors talk to Judge M and retell their experience. Tell us more about Judge M. After the verdict was read, the jury was able to talk to the judge afterwards. He told the group that cases such as Kouri Richins can be hard emotionally and not to ignore those feelings. Of course he did, because Judge M is amazing. Did he offer hugs? He wouldn't have. It's probably not appropriate judicial demeanor. But if you're a juror, are you just like, I could use a hug? Not Emily, no. Judge M's following the rules. I know. I had jurors come and hug me after cases, but I'm a hugger. I was down for it. Because it is hard. So Judge M acknowledged that cases such as this one can be hard emotionally and not to ignore those feelings. They were encouraged to talk to people about it rather than holding it in. Judge M, you're just a good human. Thank you, Judge M. Thank you for reminding the jurors that it's hard. Thank you for reminding the jurors not to ignore those emotions and that they're allowed to grieve too. The jury has the weight of this decision on them. And the jurors are going to think about the fact that now Kouri is going to be in prison and their dad is gone, and they're going to think about the kids. I think the jury made the right choice, but that weighs heavily on you. You made that decision. You and 8 other people. I think they made the right call, but it doesn't remove the weight from it. And I think that's fair. I didn't ask. Okay, Missless. So what does Judge M smell like? I don't know. The outdoors. Fresh air and mint is what I'm going with. Emily, too far. You think the same thing that I do. You think the same thing that I do. The outside. All right. I think that the jurors had a difficult job. I really appreciate seeing that they took it seriously. I appreciate that they shared their perspective on this. They don't have to. It opens them up to the internet. The internet, I have not yet seen the internet. I mean, the law nerds are always law nerdy and appropriate and lovely. But I have not always seen the internet be kind to jurors. And it is such an important thing to hear feedback on how the process is working. And it's nice to hear that for this foreperson, this is working as intended. That they started from not guilty and, we kind of don't want this to be true because it's horrific. And then looking at all the evidence going, there's no other answer except that she's guilty. That's what you want to see. And I'm glad that the juror shared. I don't know if we'll see any other jurors say anything. We normally see the foreperson at least be amongst the jurors that speak up. But I'm also glad that the juror wasn't like flying with the clerk of court to New York to do this interview and hopped on Zoom and was like, yeah, I can talk to you from here. I appreciate it. I'm glad the interview. Thank you, Miguelina, for grabbing it. Thank you, Law Nerds, for pointing out that they did talk about the walk the dog letter. If we see more interviews from jurors over the next few days, we will pull them. I love hearing what jurors have to say. I really appreciated that in LA County, we often got to talk to jurors after cases. That feedback is always so important. It is helpful in how you try cases. It's helpful in processing the work that you're doing. And sometimes I think it's helpful for the jurors to process. And we have heard of jurors on all different types of juries still getting together after their jury duty, especially on longer and heavier cases, still getting together with one another because they're the only ones who have really gone through that with you. Even the lawyers that are there in court do not go through what the jurors go through. It is different for the jurors. The lawyers are advocates for one side or the other. The jury actually has to weigh it and make a decision. It's ultimately their call, and that is a heavy weight. And we have seen cases where the jurors continue to get together. We've seen cases where the jurors continue to get together with the prosecutor. So, yeah, I hope the jury takes Judge M's words to heart and processes it with those that they trust now that they can talk about it, and stays connected to each other if they want to. So, and I imagine in Judge M's court, even though there were times where the jury was waiting a lot, that Judge M treated them with dignity. I think they felt that, or at least I hope that they did. Should we talk about the bond hearing? Are we ready to talk about the bond hearing? Are we ready to move over to the bond hearing? My kid's personal Uber driver said, or joining the defense team. Okay, that was the only time I ever saw that. I had never seen a juror join one of the attorney's teams, except for in the Karen Reed case. That was wild. But when I say you can learn a lot from jurors, So, yep. All right, let's go to the bond hearing. We are going to, let me change this because we are going to do like a court rewatch. When we got to the end of the day, Monday, after streaming for 10 plus hours, at the very end of the day, we talked about whether we wanted to go through and look at the first bond hearing for Kouri Richins and see what Amy Richins said to Judge M at the bond hearing, 2.5 years ago, 3 years ago? That bond hearing was on June 13th, 2023. It was one of the first things I covered in this case. Sky Lazaro was still Kouri's lawyer. We are not going to go through every witness at the hearing, but we will go through some of the witnesses because I'm interested to see if there are things that have more context or things that didn't come in for trial. And I want to hear what Amy said at the bond hearing that we did not see in trial because she did not testify at trial. So we are going to take a look at that. I will link down below the full coverage of that hearing. We are going to go through parts of it, highlighting what Amy Richins had to say, what Judge M had to say, the lawyer argument, and the first witness. So it's not going to be the entire thing. It's going to be part of it. Shannon asked about if I'm going to cover the David case. This is going to be probably the only question I answer today about Emily. What else are we covering? Because my brain is still in Utah, but I have been covering the David case on the Emily Show podcast. If you have the Law Nerd app, it is sent to you every Monday. If you do not, it is on the podcast channel where the case briefs are. Sorry, my back is bugging me today. So the case briefs and the Monday podcast are over on the Emily Show YouTube channel, and I have been covering it there. Those are all time-stamped, and you can tell by the title what's covered in what episode, but I have covered it over there. Bellatrix Black 469 said, why didn't Kouri's brother testify? What was Kouri's brother going to say? Eric texted me that. Okay, well, we have Eric's phone. Those texts aren't in Eric's phone. Did he delete them post-humorously? I don't think so. Oh, there was this conversation that I had at a football game. It was like 2 minutes long. I took vague notes. He can't testify to what's in the walk the dog letter because, well, then it's kind of obvious. And if he doesn't have the text from Eric, which I suspect he doesn't, because the defense would have brought them up with Chris Kotradimus, who had Eric Richins' phone extraction. Notice they didn't ask Chris Kotradimus about what was in Eric's phone very much. He had the phone extractions. They didn't ask about texts indicating an affair. They didn't even ask the PI about that, except for there's an open marriage now, buddy. I'm bringing you over tonight. They asked a lot of whose job it's not, but they didn't ask those questions because those things don't exist. If those texts existed, we would have seen them because the defense, well, the prosecution probably would have brought them forward, but the defense would have brought them forward because they questioned 3 witnesses who reviewed the text messages. The PI, the tech expert, Kotradimus, and the investigating officer. And if those texts exist, don't you think they would have looked at the investigating officer being like, what do you mean you didn't see these texts about an affair? Because the investigating officer was kind of like, I don't know, we hired a tech guy. So if they could have, they would have. They couldn't. And that's, I think, why the brother didn't testify. Oh, wait. Hold on. Shit. Before we get... Emily, really? Yes. Before we get to the bond hearing, there was one other question I wanted to answer because I saw a number of you ask. I told you I would bring it up, and I didn't want to forget because this is another error that I have seen floating around the interwebs, and I've gotten asked about a lot in my DMs. So let's answer one more question about Kouri Richins' mom. This is an answer for those of you that didn't follow a ton of the pretrial. That's not shade. I'm just, for those of you that are like, Emily, we've heard this before. Yes. However, confusion has been caused. So yes, Lyndon, let's correct the record. Haha. We've done that a couple times today. Let's correct the record. A lot of you have seen headlines that the court appointed lawyers for Kouri Richins' mom. That's not specifically true. It is an inaccurate reading of the docket. Way back in the pretrial of this case, the defense asked for attorneys to be appointed for several witnesses, including Robert Crozier. Those things were under seal. The court did appoint lawyers for some witnesses and potential witnesses that were requested at that time, including Robert Crozier. One of the requests was that counsel get appointed for Kouri Richins' mother. The drills disagree with me. And in all of that conversation about who was getting appointed lawyers, we did also see a lot of you in the chat are like, and Ramos. Yeah. At one point, Ramos had an attorney. We still don't know why. Half of it's under seal. I hope it gets unsealed one day. That might never get unsealed, but I have so many questions. I have lots of speculation, but it would be reckless. I have so many questions. But there was a docket item that popped up at the end of trial that is a docketed item that seems to correspond with other items that were under seal. But here is what the docket said. This was the proposed order. When lawyers file things and ask for something, hey, Your Honor, can you do X? They will file a proposed order that says, order doing X. It's kind of like if somebody asks you to write them a recommendation letter and you're like, hey, can you send me an outline? It would really help me out if you could, like, of course, everything I say and it's going to be true, but if you could just send me an outline of what you need, I can help modify it with my own language. Same thing. The attorneys file proposed instructions or proposed orders with the judge, and that's exactly what this is. This is a not signed proposed order that was filed during pretrial and then popped up on the public docket, probably because it didn't get its own docket number earlier on. This is not signed. This was not something that the judge ordered. It reads like an order because it was filed with the defense's request that this happened. So it's just a docketed item that did not get its own docketed number. So it got put back on, it just got filed onto the docket. So it had a number to keep everything in order because it would have been filed when the defense asked for this. And they asked for this ages and ages and ages ago. So with that, I appreciate it. Memers in the chat is coming to Dr. B's defense here and saying, if your gutters were undersized, it's important they get changed so it doesn't cause damage to the roof and siding. It's true. Dr. B very much felt strongly about the gutters getting redone. He just thought I was not streaming today, but they were undersized. I came from California. I didn't know that was a thing. Much more water falls from the sky in Tennessee. So it actually does matter here. So yes, it is an orphaned docket item. I mean, I guess I like big gutters and I cannot lie. Sure. But it is not signed. It needed a docket number. It got filed onto the docket. It is a proposed order.
The FBI!
We're going to have to go to rolling the video so you don't have to hear this. Just Raina asked, is it because Emily's mind is often in the gutter? Yes. The heavy weight of my second Audible account required larger gutters. I think that's absolutely true. I support that rumor. I do. I support that rumor. So this goes to other docketed items. This did not happen. If Lisa Darden had needed to testify as a witness, we might have seen her get appointed an attorney. However, Lisa Darden probably already has an attorney because Lisa Darden is named in some of the civil suits and her name has come up a lot in the other criminal financial fraud case. Lisa probably already has a lawyer because she got pulled right into the civil suits because money went to her that the estate's trying to get back. So she probably already has one. And they did appoint, here, let's look at the docket real quick. Let me just put this up. We're going to scroll. If scrolling makes you nauseated in any ways, apologies, but we're going to scroll real quick and look at the docket. But when we saw the attorneys getting appointed, it was way, way back on the docket, and the request was made then. So this is in trial. We got to get well past this because they asked for Crozier to get a lawyer. Oh, Emily, you can just hold on. We can control F it. We're just gonna do that. Let's see. All right. 458, motion to withdraw and appoint counsel. That's from 2024. We're going to go through these. That was from Sky Lazaro withdrawing from the case, I believe. Motion to appoint counsel for a witness. Proposed order granting motion to appoint counsel for a witness. This was back in September of 2025. And there were a number of motions that happened at this same time. State's response to defendant's motion to appoint counsel. So these things were going on throughout the record. This order granting the motion for appointment of counsel was as to Robert Crozier. And there's an amended order, an amended order granting appointed counsel for a witness. That's back in October of 2025. Then we have the not signed proposed order granting back in October 2025. So this is just cleaning up what was happening back in the docket for granting a counsel for a witness. So this is not new. This is sealed. Motion to classify state's opposition to motion to appoint counsel for Lisa Darden, sealed. This happened in December 2025. The court denied motion to appoint counsel, but I don't think that the defense's proposed order ever made it formally onto the docket. So that's all. This was docket 1262. This is sealed. Let's see where 1262 is, because that's going to be the one related to Lisa Darden. 1262, motion to appoint counsel for witness. That's December. Let's see if we have 1262. So this is all older stuff that we covered when we saw it. I'm pretty sure we covered 1262 when it happened, but we might not have. No, I don't have it. Let me see if I have the court's order. Let's see if I have the court's order on that. If not, I'll just grab the court's denial of that. Let's see. That was 1353. 1355. 1353. Bingo. I can just show you 1353. All right. Emily, you said we covered this. We did. We did cover this. Here it is. January 2nd, 2026, 3:44:12 p.m. Before the court is defendant's motion to appoint counsel for Lisa Darden, docket 1262, based on the party's briefing and counsel's argument on the record during a closed session on January 2nd, 2025. Is that 26? That would have been 26. The court rules as follows. Defendant's motion to appoint counsel for Lisa Darden is denied without prejudice as moot under the current circumstances. What are the current circumstances, Emily? Probably the state wasn't going to call Lisa Darden as a witness, and the defense wasn't sure if they were going to call Lisa Darden as a witness. So no, the motion was denied. What popped up on the docket not only says not signed across it, it isn't signed by the court, and it is contrary to this order. I can understand why it caused confusion. A lot of people covered this case without covering the pretrial, which I think is great to have that perspective. I do that quite frequently. This is one of those things because I covered this case from the beginning. I'm like, oh no, I remember when they were asking for everyone to get counsel. The court didn't do that. So there we are. That was in fact denied back in January. So hopefully that clears it up. And now you know. Oh, the more you know, Lawnards. The more you know. All right. Now, instead of you listening to whatever that is at my house, we're going to fly to Utah. Anita the Italian, can anyone access the documents on the docket? Are they free? They are definitely not free in Utah. The searches are not free in Utah. And you have to have a registered account, I believe, to grab the records, but not to look at the calendar. So they are not free. which is why I pull them so y'all don't have to. And I share those in the lounge when we have stuff that we want to see. And I will ask the lounge after this case if we want to do more of that, because maybe we will. So no, not free. Utah is expensive the way California is expensive to get documents. Federal's cheaper. Florida's free. Florida's really easy. Florida's like sunshine laws. Come and get it. But no, Utah is not. Ned asked, why would everyone get counsel? Everyone did not, but they were asking if everyone would, because they were concerned that those individuals would need their own advice about testifying. And the defense attorneys cannot give advice to the witnesses, legal advice. They cannot create an attorney-client privilege. And so I think it was proper and in an abundance of caution to be like, hey, Crozier needs a lawyer. Hey, Lisa Darden's going to need a lawyer. They need to know that they can get themselves into some fuckery. They're going to need a lawyer to advise them about whether they should stay silent, whether they should talk to the prosecution, what kind of trouble they can get into. They're going to need a lawyer. So, yeah, they're going to need a lawyer. All right. We should fly to Utah. And, oh, God, that scared me. That's going to... Okay. As you watch my soul leave my body again. Oh, today is an adventure. All of you got to watch me just literally leap out of my skin. Yep, it's going to be like that because the work is being done on the roof. All right, let's go to Utah and take a look at the past bail hearing. Yep, let's go to Utah. Let's go to Utah. The reason that I wanted to cover the bail hearing is, one, we had so many of you that did not watch the pretrial motions in this case, which I love the perspective of. I think it's fantastic. A lot of you found this case as it was going to trial or midway through the trial. So I love seeing your perspective. I'm going to put up a poll on that in a minute. I love seeing your perspective on it. And for me, so much information came in at that bond hearing that we knew going forward in the case, some of which didn't come in at trial, that I thought it might be interesting for us to revisit it together after trial. And I wanted to see what Amy Richins said again, because honestly, I do not remember. But this bond hearing is from June 13th, 2023. Kouri Richins was arrested May 8th, 2023. Oh, did y'all know that Utah doesn't release your booking photo until you've been convicted? I actually really like that rule. You let me know what you think. I actually really like that rule because booking photos, I think, could be prejudicial. And if you are acquitted, if charges are never brought, I think having a booking photo out there could be an issue. So I actually like that Utah doesn't release a booking photo until you are convicted. I actually think it's a really good idea. Because not everyone who's arrested is convicted. Not everyone who's arrested is charged. And having a booking photo out there could be prejudicial. So Utah doesn't release a booking photo until you are convicted. That said, Kouri just got convicted. So we do now have Kouri's booking photo. I bring this up to say that we are going to see Kouri closer in time to, that won't move that way. We are going to see Kouri closer in time to this because she is in this bail hearing a month after her arrest. So this is Kouri's booking photo from May 2023. So this is back then. We are going to go to court back in time in 2023 when they are first arguing that Kouri Richins should be released on bail. At that time, and a lot changed between the time she was arrested and the time this went to trial. Obviously, there was a lot of time that passed, but the charges changed as well. So just for the sake of clarity, at the time that the bond bail hearing happened, Kouri was charged with multiple counts that are different than what went to trial. At that time, she was charged with the aggravated murder with the circumstances we talked about. She was also charged with possession of a controlled substance with intent to distribute, which I didn't agree with. There were 3 counts of that that were later yeeted. That was on May 8th. Then they amended the information on, that is loud. They amended the information on May 18th. And on May 18th, they charged her with the aggravated murder in count 1, 3 counts of possession, 2 counts of possession with intent to distribute, which they yeeted, 1 count of possession or use of a controlled substance, which got yeeted. They had not charged the attempted murder yet. So when we get to this bond hearing, we are before the fraud gets added, before the attempted murder gets added. So the main charge, the main charge is the aggravated murder. So you're going to hear them talking about it differently. So we flew to Utah. We have lots of loud noises. We flew to Utah and we are going to go to court. Sorry for everyone whose pets are going crazy because of this. Know that I am also screaming. Not how I expected my day to go, but nevertheless, we're going to court back in our time machine. We're taking a TARDIS to June 2023. A lot happened in this hearing, and this is the best version of it I could find. The sound is not great. The video is what it is, but we're going to court anyway. Let's go to court. Should we fly again? We should. Back in time. All right. Doodle-a-doot, doodle-a-doot. Bond hearing. Back in time. Oh yeah, Emily is not thrilled. There's different kinds of ADHD. Mine is spiciest with external noise. Highly noise distracted. Highly. Let's go to court.
Morning, Ms. Richins. Can I have counsel for the state make their appearance, please?
Yes, Your Honor. Patricia Cassell for the state.
Your Honor, Brad.
Okay, different prosecutor. I see Katie Richins, Katie Richins' husband, Eric Richins' father, very full courtroom. This is the investigator, Mr. Gabler. Look at that. Right there in court. All right, let's continue.
Bloodworth for the state.
Joseph Hill on behalf of the state.
Margaret Olson.
Welcome. Thank you. On behalf of Ms. Richins.
We've got a different prosecutor speaking, and then Margaret Olson is the elected prosecutor for Summit County.
Please.
Thank you, Your Honor. Good morning. Sky Lazaro on behalf of Ms. Richins.
Aaron Hinton on behalf of Ms. Richins.
Thank you.
I normally do not talk about people's appearances. I don't. I do get distracted because I think Sky is an attractive woman, clearly, or at least to me. However, I am going to comment on Sky's appearance to say she is clearly much taller than Brendan Banfield. Emily, that's petty as fuck. I don't care. I bet her friends bring her cookies on her birthday too. Taller than Banfield. But also, look at the investigator. Look at the PI. The PI sitting there happy as can be. Just happy as can be to be in court. Just so happy. So happy. Yeah, I bet Sky gets Vouv and cookies from her friends on her birthday. This is shortly after Kouri's arrest. This is a very full courtroom, same courtroom that we are used to, different camera angle. And yes, the defense is sitting closer to the jury box. on this day.
All right, we're here today for a detention hearing to determine whether Ms. Richins will continue to be held without bail during
Yes,
the
this is a
pretrial
potato.
period. I've read a lot of stuff.
It's just it's a
I've
potato.
reviewed
I don't
the
know why it's a
defendant's
potato.
motion to consider defendant's constitutional right to bail, the state's bench brief, defendant's motion to set conditions for release, the state's response, and I read your reply filed last evening, Ms. Lazaro.
Thank you. I apologize for that.
It's fine. This is a dynamic situation. I'd like to hear from the state first.
The court is literally like, court's dynamic. Thank you, Your Honor. Sky Lazaro had a conflict arise in the case. There is nothing to indicate that was through anything other than just court is dynamic, but it has to do with the civil case. We went over the hearings when Sky had to withdraw his counsel. I thought it would be funnier if it was over the walk the dog letter. It wasn't, but there was whatever conflict arose because of the civil case. Sky could no longer be on this case, so it is what it is. Sky was there at closing. For those of you that hadn't seen Sky in court before and had seen, and were like, "Wait, who?" This is the former attorney for Kouri Richins and was sitting in court with Kouri's mom on the day of closings.
First, who's leading the
I
presentation?
am, Your Honor.
Ms. Cassell, how would you like to
Different
proceed?
prosecutor.
Your Honor, we have 3 witnesses that we would like to call.
Okay.
We are prepared to call them now.
Who's the first witness?
The first witness is Detective O'Driscoll.
Do we have an exclusionary rule issue? I'm not sure it applies today, but I thought I'd ask.
I don't even know who this
I'm not
is.
sure it does either, given
The exclusionary rule doesn't apply because we're at a bond hearing, but O'Driscoll's the first witness.
sort of the loose nature as far as the rules go on this hearing. Given the nature of the proceedings and I'm sure what's to come, extensive testimony in this case and a number of different issues, I would ask that it be imposed.
I mean, 1101C4 would say the rules of evidence do not apply today.
That is correct.
Exclusionary rules, a rule of evidence. Okay. It's a reasonable request, but it's denied.
Thank you.
Is it Detective O'Driscoll?
Yes.
Okay. If you'd step in front of Brittany, we'll get you sworn in.
I don't know who this prosecutor is. This prosecutor is, well, obviously we saw Bloodworth was the lead prosecutor on the case.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth,
That's
the whole
Brittany
truth,
swearing
and
in
nothing but the
O'Driscoll.
truth, subject to the pains and penalties of perjury?
I am curious as the PI is just, happy as can be. Oh, it's going to be real interesting to watch the audience. Most times I don't watch the audience. It's going to be real interesting to watch the audience and to watch Kouri on this one. This is a little more than a month after she's arrested. She has been held in custody without bail. Under the law, she is not entitled to bail. And they are putting on numerous witnesses at this hearing. We're not going to watch all of them. I am real curious to see what O'Driscoll has to say, and we might put this at 1.25 because a lot of this we've heard before.
Good morning, Detective O'Driscoll. Can you please introduce yourself to the court and explain your relation to this case?
My name is Detective O'Driscoll. I've been with the Summit County Sheriff's Office for 7 years. I'm assigned to the Investigations Division. I was assigned to be the lead detective in this case in April of this year. This case is an active case and the investigation's ongoing.
Detective, what was the Sheriff's Office first involvement in this case?
On March 4th, 2022 at 3:22 hours, Summit County Dispatch received a 911 call regarding an unresponsive male in the Francis area.
Have you listened to that 911 call?
Yes.
Who placed that call?
The defendant, Kouri Richins.
In addition to saying that someone was unresponsive, did Ms. Richins, the defendant, identify who was unresponsive and anything else about that person's condition?
Yes, she stated that it was her husband, Eric Richins, that was unresponsive, that he was cold to the touch and not breathing.
The rules of evidence are different at a bail hearing. Hearsay in different ways is permitted. So the investigating officer, the IO, the lead detective can go through and be like, this person said this person said that, this person said this person said that, and can go through and just say what this case is. And so you are going to see that the rules of evidence is or are different at this stage of the proceedings because it's different. So this was back in June 2023 for those just coming in.
Did EMS and police respond
And
to that
yes,
address?
it was recorded on a potato.
Is that the family home?
Yes.
Was a portion of the police and EMS response captured on police body camera video?
Yes, it was.
Have you reviewed that video?
Yes, I have.
On that video, what time does EMS pronounce Eric Richins dead?
03:58 hours on March 4th.
What, if anything else, does EMS say about how long he had been
Did
dead?
we hear that? Did we hear that in trial? That he was pronounced at 03:58? I honestly don't remember if we did. We might have, but I just don't remember.
EMS personnel made the comment that he had been dead a while.
Did the
I don't
state
think we
medical
did either.
examiner's office conduct an autopsy of Mr. Richins?
Yes, they did.
Have you reviewed the medical examiner's autopsy report
Yes.
and the toxicology report that's part of that?
Yes.
What did the medical examiner identify as the cause of death?
Drug intoxication with the specific drug being fentanyl.
I'm going to now ask you, Detective, some questions about someone with the initial CL. Do you know who I'm talking about when I say CL?
We all do now.
Who is CL in relation to the defendant?
CL is an associate of the defendant. She cleaned houses for the defendant's business as well as her personal home at times.
Does CL have a criminal drug history?
Yes.
Is she under supervision in a different county, a county other than Summit County?
Yes, she is.
And is that in relation to certain drug charges?
Yes.
And yes, chat. Kouri was arrested in May 2023. This is from June 2023. The hair is still highlighted. Yep. Different than when we got to trial 3 years later.
Does the program...
Almost 3 years later.
Does the court program in which she's in monitor treatment and testing, et cetera?
Yes.
Do you know how CL is performing in that program?
Based on my interactions with CL, she is progressing through the stages of that program, and that her personal outlook on her recovery is optimistic.
Have you interviewed CL in connection with this case?
Yeah, Carmen was referred to as CL throughout the filings prior to trial, to protect her identity and to protect her privacy, because they also talked a lot about her drug history and her cases. So yes, she was referred to as CL throughout the pretrial proceedings. We know now, but
approximately how much time have you spent interviewing her?
Over the course of multiple interviews, several hours each, I would say upwards of 10 hours.
Was CL in custody when you interviewed her?
Yes, she was.
Was that interview captured on video and audio recording?
Yes.
What, if any, promises did you make regarding, or to CL regarding her cooperation with being interviewed?
CL was not made any specific promises, but at the outset of our interviews, we explained to her that her cooperation in our investigation would result in us working with the prosecutors that were responsible for the charges she was facing.
this is before they finalized CL's deal. Was she given any promises? Not at this point. They hadn't even finalized Lauber's deal yet.
Did you express to CL the seriousness of this case as well as the charges she was facing?
Yes, we expressed to her the seriousness of the charges and the possible results of those charges. As well, we impressed upon her the importance or the value of her testimony in this case as it related to the charges that she was facing, and that her testimony or any information that she may have was more important to us.
Did you stress to CL?
And that's what we saw in trial. Literally exactly that.
You were asking her about needed to be credible and verifiable?
Yes, we told her at the beginning of our interview that any information that she may have, we would need to corroborate in order for it to be of value to us.
All right.
Did CL?
I'm going to put this at 1.25. They referred to Carmen Lauber as CL up till trial. So let's put this at 1.25. I'm curious to see if we see other facts that we didn't see. It's interesting to see Kouri way back in 2023, and I didn't appreciate who Mr. Gabler was sitting here, that he is sitting next to Kouri Richins. I think this is Amy's husband over here. Amy is sitting elsewhere. Eric's dad is here. It's interesting to see who is in the audience. Very, very, very full courtroom.
Cooperate with being interviewed?
Yes, she did.
Did CL know Eric Richins?
Yes, CL told us that during the time that she spent cleaning the Richins home, she got to know Eric, that she felt that he was a really good person, she liked him, and she was very saddened to hear that he had passed away.
Did there come a time when investigators executed a search warrant on CL's home?
Yes.
In executing that warrant, did you make any observations consistent with CL's testimony that she felt bad about Eric Richins' death?
Yes. Inside the home, we identified a bedroom that belonged to CL. In the bedroom, there was a mirror above a desk. On the mirror were taped.
I had forgotten all about this. The forensic accountant is also in court. The forensic accountant will be testifying in this hearing. We're going to zoom past some of that. But the forensic accountant is there in court sitting next to the elected prosecutor for Summit County.
Fixed several inspirational quotes that seemed to relate to her recovery and her drug court program. Amongst all those inspirational quotes was a newspaper clipping of Eric Richins' obituary.
I had forgotten all about this.
Did you get the impression that part of the reason CL cooperated is because she felt bad for Eric Richins?
Yes, in fact, she said so many times in our interviews.
Detective, I want to turn now to what, if anything, CL told you about the defendant requesting that CL purchase fentanyl for the defendant. What did CL tell you?
In our interviews, CL told us that in early 2022, the defendant reached out to her either by phone call or text message requesting that she procure fentanyl for what the defendant reported was a investor who had a back injury.
Interesting. That is not how that evidence came in at trial. That is not how that came in at trial at all. That is not the way that came in.
Defendant asking CL to get fentanyl. What did CL do?
CL told us that she reached out to an acquaintance of hers, acquaintance one, and requested that she introduce her to somebody that could sell her fentanyl.
Did acquaintance one introduce CL to someone that could sell CL fentanyl?
Yes, CL said that acquaintance one provided her with a phone number of another acquaintance two, who was someone that she knew could sell CL fentanyl.
And did CL say that she ultimately contacted acquaintance two?
Yes, she did.
And if you're asking,
what, if anything, did CL
if these are all leading, yes, they are leading. The defense is not objecting. It is a bond hearing. It is a different evidentiary standard. But when we talk about the way that evidence can come in earlier in the case versus the way evidence comes in later, the way that this came in at trial came in differently than it's coming in here. It was much more clear, the back and forth with CL saying, Kouri asked me for some stuff. I asked Crozier. Crozier said, I don't have that. I have this. I told Kouri they have this. Is that fine? Kouri said yes. It shifted by the time we got to trial.
purchasing fentanyl from acquaintance 2?
CL told us that she contacted acquaintance 2 after receiving his phone number and asked to arrange to meet to purchase some fentanyl from him. She stated that sometime in February, she believed she met up with acquaintance 2 at a Maverick gas station in Draper and purchased from him 15 to 30 round green-blue pills, which she understood to be fentanyl.
Using phone records through the course of your interview with CL, were you ultimately able to narrow down on what that date was in February that CL purchased fentanyl from acquaintance 2 at the Maverick in Draper?
Yes, based on forensic evidence, we were able to determine that that date was February 11th, 2022.
What, if anything, did CL say about what she did with...
I wonder if they're going to talk about any of the other dates. MJ DeMarie said my chat is buffering as well. Yes, the YouTube platform has been having some quirks. So if you're like trying to type a chat and it just disappears, there have been some platform issues. It's happened to me on other channels. There have been some quirks with chat around YouTube. It's not you. It's not your internet. There have been some YouTube quirks. So yes, it just is. Refreshing helps sometimes, but not all the time.
The fentanyl pills that she purchased from acquaintance 2.
CL told us that after purchasing the pills from acquaintance 2, she returned home to her house in Heber. She said that either later that night or the next day, the defendant met her in the driveway of that home and did a hand-to-hand exchange of pills for cash.
I'm going to turn now, Detective, to some questions regarding witnesses who corroborate CL's testimony, okay?
Okay.
You mentioned acquaintance number 1. Have investigators interviewed acquaintance 1?
Yes.
Have you reviewed body camera, audio, and video of that interview?
Yes.
Does acquaintance 1 corroborate CL's testimony?
Yes. She stated that CL contacted her in early 2022 and asked for someone that could sell her fentanyl. In the body cam, she also retrieves her cell phone and shows investigators the messages that corroborated that.
And what kind of messages were they?
They were messages between acquaintance 1 and CL on Facebook Messenger app.
And have you reviewed those messages?
Yes.
Is the first of those messages dated February 6, 2022 at 1:37 p.m.?
Yes.
Does it read, text me, I've got a question, won't do it on this?
Yes.
And that's CL writing acquaintance 1, asking acquaintance 1 to text CL because she didn't want to write over Facebook Messenger?
Correct.
Did acquaintance 1 say whether or not she ever, in response, contacted CL?
Yes, she said that she then either texted or called her subsequent to her request.
You testified that acquaintance 2 sold fentanyl pills.
They didn't bring these messages in during trial. Not all of them came in. I don't know why.
Have investigators interviewed acquaintance 2?
Yes.
They had them. I don't know why they didn't come in.
Body camera, audio, and video of that interview?
Yes, I have.
Is acquaintance 2 able to corroborate CL's testimony?
Yes, acquaintance 2 was able to recall that he sold fentanyl pills to a friend of acquaintance 1's in early 2022.
This didn't come in either.
At a Maverick gas station in Draper.
I'm going to turn now, Detective, to some forensic data questions. And whether
not all the
data
Facebook messages
CL's
came in.
narrative, okay?
Talk about it did. I don't think we saw the actual messages,
carrier records
though.
of the defendant's phone?
Yes.
And I want to just clarify one thing. I'm talking right now about
But it might have been
carrier
because we didn't
records,
see them on the...
different than cell data records. We'll have an expert testify
screen.
about cell data records in a moment. I'm just going to ask you about the carrier records, okay?
Okay.
What, if anything, do the carrier records for the defendant's phone?
Yeah, I covered this hearing, if not the exact same day it was happening, the day after it happened. There were some issues with this hearing streaming because the judge was like fighting the media up until trial. So it was either the day this happened or the day after this happened. But this hearing we covered back in June 2023. The books are going to get me. If there is a book that somebody wrote and then they end up in court about it, it's immediately going to pique my interest. I'm like, you wrote about what?
Or what, if anything, in the carrier records for defendant's phone corroborate CL's testimony?
The cell records from the defendant's phone show several phone calls back and forth between her and CL in early 2022.
Do they show any text messages back and forth between the defendant and CL?
Yes, several.
Have you reviewed those text messages?
We were only able to see the timestamps and who the sender and receiver was. We're not able to see the content of those messages because they appear to be deleted from both the defendant's phone and CL's phone.
Yep. Deleted on both ends.
Have you reviewed the call history and carrier records of CL's phone?
Yes.
Does CL's carrier records and call history corroborate CL's testimony?
Yes.
Is there a particular set of calls on February 11th, 2022 between 5:19 p.m. and 6:52 p.m. in CL's phone history?
Yes.
Question CL regarding those calls.
Yes. She said those calls were to acquaintance 2 and that they were to arrange the specific date and time to pick up fentanyl in Draper.
Turning now from CL's purchasing fentanyl for the defendant to the defendant's purported timeline on the night of Eric Richins' death, okay?
Okay.
You mentioned earlier that police interactions with the defendant were captured on video. Have you reviewed that video?
Yes, I have.
Did the defendant provide police with a written statement in the early morning of March 4th, 2022?
Yes, she did.
Have you reviewed that statement?
Yes.
What on the early morning of Eric Richins' death did the defendant report had happened that evening?
She stated that the last time that she saw Eric alive was between 9:30 and 9:45 p.m. She stated that before going to bed, they had had a drink together to celebrate closing on a house for her business. She said that they got in bed between 9:30 and 9:45, and that shortly after getting into bed, one of the children had a nightmare, and that the defendant got out of bed and went to be with that child in their bedroom and slept in that bedroom until 3 a.m. or around 3 a.m. when she woke. She stated she returned to her own bedroom, got into bed, and felt that Eric was cold to the touch. She stated that she turned the light on, saw that he wasn't breathing and that he didn't look normal, and that she then called 911.
Did the defendant say whether anyone else was in their home other than the defendant, her husband Eric Richins, and their 3 young children?
No, she stated no one else was in the home.
Turning now to the defendant's statements regarding whether she performed CPR on her husband, okay?
Okay.
Did the defendant tell investigators when they arrived at her home shortly after she called 911 whether or not she performed CPR on Eric Richins?
Yes, she reported that she did.
I'm going to refer to someone now as defendant's best friend. Do you know who I'm talking about?
Yes.
Oh, we all do.
What, if anything,
we all know about Bestie. We know. We know about Bestie Barney way more than we did back then. Yep. Yeah, we know.
The defendant tell her best friend regarding whether she performed CPR on Eric Richins?
Investigators found text messages between the defendant and her best friend that was her explanation to her friend that she conducted CPR on Eric prior to EMS arrival.
That's
and
not all that
text
text
messages
said.
read, I pumped so damn hard, so hard.
Bloodworth's like, let me explain what the text said. Let me explain. Maddie asked, did EDB explain why we were watching this again? A lot of the law nerds did not see the bail hearing when it first came in back in 2023. And we wanted to see, A, how the evidence looked at the bail hearing different than this hearing. And we wanted to go back and watch Amy Richins' statement because a lot of y'all haven't seen it. And we wanted to go take a look at Amy's recitation of what happened on March 6th because it didn't come in at trial. And a lot of you don't know. So we are going to get there, but I wanted to go through the foundation before we get to what Amy Richins has to say about what happened on March 6th, because a lot of you are like, but what did happen on March 6th? And during trial, I kept saying spoilers. Some of it's not coming in, some of it is, some of it's not coming in, some of it is. And so we wanted to go through spoilers. So on Monday, after the verdict, when we were doing Q&A, I asked chat and said, should we rewatch it? And chat was like, yep, we should. We should rewatch it. We should indeed. So here we are. And it works because all the noises outside my house make it really, 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 really hard to talk more. So, and I've forgotten a lot of this. I didn't realize that was the PI sitting back there. Like there's so much more to this.
Hard, screaming at him to come back to life.
Oh, hold on. Dramatic reading of the text message.
Her best friend, that was her explanation to her friend that she conducted CPR on Eric prior to EMS arrival.
And do those text messages read, I pumped so damn hard, so hard, screaming at him to come back to life?
Yes.
And yes, for those of you that wanted to see Kouri in cuffs, there she is, sitting there in cuffs. I don't know if she's... Emily, you judge a lot more harshly post-verdict. Yes. Yes, I do. I think she's trying to cover a laugh.
Whether she performed CPR on Eric Richins.
Investigators found text messages between the defendant and her best friend that was her explanation to her friend that she conducted CPR on Eric prior to EMS arrival.
And do those text messages read, I pumped so damn hard, so hard, screaming at him to come back to life?
Yes.
Chat, what do you think?
You testified earlier, Detective, that EMS responded. Have you interviewed the first EMS responder?
Yes, I have.
What observations did that EMS responder make?
They told me that when they arrived, they began CPR compressions on Eric, and that upon beginning those compressions, Eric began to...
Well, the camera was like, and she's in cuffs. The camera's just like, we're going to zoom right in.
Foam at the mouth. He stated that.
Sorry, I've lost the testimony a little, but we know what he's going to say. So we can look at other things. But the dramatic zoom in on the cuffs is something.
Upon beginning those compressions, Eric began to foam at the mouth. He stated that that observation indicated that CPR was not likely conducted before he arrived.
And we did not hear from that EMT in trial. That EMT did not testify. And I wonder why that EMT didn't testify.
Detective, as part of your investigation, did you look into whether Eric Richins used illicit drugs?
Yes.
What did you determine?
Based on the interviews that we conducted with those who knew Eric well, all stated that he did not use illicit drugs other than consuming THC gummies on occasion.
Those that you spoke to include Eric's two best friends that he's known since high school?
Yes, both made the same.
This is before the walk the dog letter. This is before the judge kept out a lot of what the best friends had to say. So this is all the way back. Wait, who just said the most expensive jewelry she'll ever have? I mean, Annie, you're not wrong. Those bracelets definitely have a cost.
Statement that they never knew Eric to use any illicit substances other than the THC gummies.
When I reference a hunting guide in Mexico by the initials TR, do you know who I'm referring to?
Yes.
Did you speak to this hunting guide?
Other Summit County detectives did, yes.
And what did this hunting guide, if anything, say about Eric Richins
I don't remember
using
this.
illicit drugs while hunting in Mexico?
The guide told detectives that several of their clients, when they come to Mexico, will seek out someone that can put them in contact with illicit substances while they're down there for their hunt. He stated that Eric Richins was not one of these, that Eric was solely focused on the hunt.
Huh.
Has the defendant made any statements?
I wonder why that didn't come into trial. Interesting. I mean, anyone who's traveled to states where weed is recreationally illegal, there are states I have traveled to where you get into the Uber and they're like, do you need to go to your hotel? Do you want to go get weed? What do you want to do? Colorado being one of the most notable. Every time I get in an Uber, they're like, so where do we need to go? What do we want to do? I'm like, no, I'm good. I just need to go get checked in. But I'm not surprised that they talked to the hunting guide in Mexico and was like, people come down and they're like, hey, what can we get? That doesn't surprise me at all. But if the hunting guide witnessed what Eric said, then it would be hard to get around Eric's statements and they wouldn't. Yeah, I have thoughts about that, but I'll have to reevaluate later. But yeah, I'm not surprised that this conversation was had, and they did go talk to the hunting guide. But didn't the defense ask Gabler about whether Gabler went and talked to the hunting guide? They didn't ask this witness ever. They didn't ask this witness ever. Oh, because ask whose job it's not.
Regarding whether her husband, Eric Richins, used illicit drugs other than THC.
Yes, in several statements made by the defendant throughout the investigation, there have been at least 10 times that she has said that Eric does not.
Wait, is that Chanley? Chanley! It's been so long. The outfit and the glasses caught my attention. It is formerly of Court TV, Chanley Painter, who I think was wearing green in Depp v. Heard when I was like, somebody explain to me who the woman in the green with the glasses is. She is a vibe and I love her. It feels like a whole nother world, doesn't it? Back in the day.
Throughout the investigation, there have been at least 10 times that she has said that Eric does not use illicit substances and did not use illicit substances.
Those are Kouri's statements about Eric.
Other than the THC gummies, correct.
On the night Eric Richins died, did investigators search the Richins home?
Yes.
Did they find any illicit drugs?
No.
Did they find any paraphernalia or packaging or other evidence of illicit drugs?
No.
Did they find fentanyl anywhere in the home?
Only that which was in Eric's body.
Did they find fentanyl?
Detective.
Only what was in Eric's body. I know they did talk to the hunting guide, but I bet that it wasn't the PI. They only asked the PI about the hunting guide. She never asked the IO. Mm-hmm.
The night of Eric's death to a second drug buy initiated before his death and concluded after his death, okay?
Okay.
What, if anything, did CL tell you about the defendant approaching CL a second time for fentanyl?
CL told us that approximately a week after delivering fentanyl, the defendant reached out to her
that
again
is this
by
feed that's
text
buffering?
or call and said that she wanted some more fentanyl that was stronger than the previous batch.
And in response, what, if anything, did CL do?
CL told us that she again reached out to Acquaintance 1 because she had lost the phone number for Acquaintance 2 and again requested from Acquaintance 1 that she provide her with the phone number for Acquaintance 2. She also made other statements in Facebook messages regarding that request.
In your interview, or detective's interview rather, with Acquaintance 1, did she corroborate that indeed CL reached back out to her asking for Acquaintance 2's phone number?
Yes, in the same Facebook Messenger, it showed the two different contacts on the two different dates.
And does the second Facebook message, was it dated February 25th, 2022 at 9:40 p.m.?
Yes.
And does it read, I need those again, but more, and I don't got a ride, I lost your friend's number?
Correct.
Oh, boy.
Did CL and Acquaintance 1 both say that Acquaintance 1 provided CL with Acquaintance 2's phone number again?
Yes.
What then, if anything, did CL do with Acquaintance 2's phone number the second?
Yeah, Acquaintance 1 never came in. Acquaintance 1 never came in to trial, other than Carmen saying, this is the person who connected me to Crozier. Didn't bring it in at all.
Time.
CL told us that she again contacted Acquaintance 2 and arranged again to meet up at the same Maverick gas station in Draper to purchase
Two
again
is
15 to
Crozier.
30, this time blue round pills that she understood to be fentanyl.
On the way to the Draper and Maverick, the second time, when she purchased 15, I'm sorry, did you say 15 to 30?
Yes, 15 to 30 pills.
Which she believed to be fentanyl. Did she make any stops along the way?
Yes, CL told us that the second time that she procured fentanyl for the defendant, she did.
Just a note, during the pretrial, it was handheld cameras, hand-operated cameras. So during trial, Court TV or Law and Crime, now that they own Court TV, or Jelly Smack because they own Law and Crime and Court TV, sets up cameras that are remotely operated. We saw them in Deptford. They're like on a pole and they are set up around the courtroom. These are like handheld in court cameras. So the swooping back and forth is a whole different situation than what we saw in trial. That's why it seems so different.
Did not have a vehicle to drive on that date. She said that she reached out to a friend, acquaintance 3, and asked that he give her a ride to go purchase fentanyl. She said that he did pick her up, that they traveled from Heber City to the defendant's home in Francis, where, according to CL, the defendant had told her there was a check waiting under the mat at the defendant's home.
Ooh, Kouri disagrees.
She said that
Kouri disagrees a lot. She's like, it was in the fire pit.
she checked under the mat and didn't find a check. And so she knocked on the defendant's door, and the defendant came to the door and wrote her a check from her business, from the defendant's business, for $1,300 for the purchase of the fentanyl. CL told us that afterwards they drove to the America First Credit Union in Heber City, where CL banks, and cashed the check and deposited $300 of it into her account at America First Credit Union. She said that after stopping at the bank and getting the cash, they then drove to the Maverick gas station in Draper and purchased the pills from acquaintance 2.
Did investigators execute a warrant at the America First Credit Union in Heber?
Yes, and that warrant returned a copy of the check written from the defendant's business account in the name of CL, and a receipt that shows that it was cashed and that $300 were deposited into CL's account.
What they are trying to establish at this hearing, we're not at a preliminary hearing. We are just at a bail hearing a month and a few days after Kouri was arrested. Is there enough evidence to believe at a low level she did the thing? Is the thing a murder? Should she be released? What are the facts behind this case? But it was the first time this case was in court with this level of evidence. So it is a lower standard just to determine bail.
And then CL ultimately being driven by acquaintance 3
and those stutters are within the original feed.
A second time from acquaintance 2.
Correct.
What, if anything, does acquaintance 2 say that corroborates CL's testimony?
Acquaintance 2 in his interview stated that he remembered selling fentanyl to a friend of acquaintance 1's on 2 separate occasions at the same Maverick gas station in Draper. He also said that he remembered the second time that he sold her the pills that CL was with another person who matched the age and gender of acquaintance 3.
Acquaintance 3 is the guy that was on the recorded call with the prison, Lauber's bestie. And these are all based off of the video recorded interview of Crozier. This was before Crozier was like, no, I wasn't talking about fentanyl. I was not talking about fentanyl. I was not talking about fentanyl. I was not. Nope. They cracked down on that shit. That is not what I was talking about before all that.
You interviewed acquaintance 3.
Yes.
What, if anything, does acquaintance 3 say to corroborate CL's testimony?
Acquaintance 3 corroborated all the same details that CL told us about that day, and in fact showed us text messages on his phone that also corroborated that story.
And he didn't come in. Bon Savage, thank you, Chad. Bon Savage didn't come in
now some
either.
questions about what are commonly known as bug-out bags, okay?
Okay.
I forgot about bug-out bags also, no matter where you live. not legal advice, life advice. There are things you should keep in your vehicle and your home. Mm-hmm.
Did investigators execute several search warrants on the defendant's home or the family home?
Yes.
Emily, why is this relevant? Flight. It goes to flight. For me, it goes to unpredictable weather. Flight. It goes to flight for her.
Those warrants identify what are commonly known as bug-out bags.
Yes. There were several duffel bags stored in the garage, along with backpack-sized day packs, and each was identical and labeled for a different member of the Richins family. Those backpacks were seized subject to a warrant and were inventoried and photographed. Inside the bags, detectives located several items that would be useful in an emergency situation, but the most interesting were documents needed for travel for each member of the family.
Oh, yeah. You know what's not in our emergency bags? Maybe we should put it in there. Our passports. Our passports are not in our tornado weather bags. And our passports were never in a bag that we were going to go hiking on. They were never in I never put our passports in our earthquake bags. Ever. Because we had earthquake bags. We had earthquake bags in the car too in California, because you never know. You're going to be at work and a freeway might collapse and you might get stuck there. We never had our passports in there. They were in a safe. The passports are a detail I had forgotten.
Photocopy of a state-issued ID in the children's case, along with passports for Eric and the defendant, as well as global entry travel cards for both Eric and the defendant.
Did those bags also contain clothing, toiletries, that kind of thing?
Yes.
Do detectives know when those bags were packed?
No.
Interesting.
There was a bag for Eric as well, is that right?
Correct.
That's also it.
I have no further.
However, it's also interesting that there was a bag for Eric. Because those might have been done before. That's fair. And I think that's fair if there's a consistent bag for Eric that might have been done before. Sylanacy said, man, I remember Northridge. Same. I was, Emily, we're diverting into a story just briefly. I was in Gatlinburg with Judge Abby on one occasion with the family. There is I wouldn't call it a ride, but there is a location where you can go and experience different types of earthquakes. And Northridge is one of the quakes, like this earthquake room, that you can go into a room and experience the Northridge quake. Walking by that location, because it's near where Old Smoky Whiskey is, walking by that location, you can hear the earthquake noises. Almost gave me a panic attack because I could hear it. I was like, why would, nope. I don't even want to hear the noises. I don't want to hear the noises coming out of the location. Nope. But there it is. I don't know why, but there it is. I imagine that for some, it might be like, I've never experienced an earthquake, and that might be interesting. That's not your door. It's my house. But there's one in Gatlinburg. Nope. That's not your house. It's me. I'm sorry if it's making your dogs go nuts. All right. We're going to go back to the hearing so I can mute myself.
Questions for you, Ms. Lazaro on mine. Thank you.
We're on to cross of the lead investigator. And a lot of you are like, he testified better here. Did you notice? Sky shoes, 10 out of 10. However, those are the types that is very similar. I mean, mine were always black, but that is very similar to the shoe that caused me to trip in court. Some of you know that story. But I love a heel in court. But yes, that was my noise. Notice in the difference in testimony, all of Bloodworth's questions were leading questions. All of them. Mm-hmm. I mean, I want to see Sky's earrings too, but I don't know if we need the extreme close-up.
Detective, it's O'Driscoll, right?
Correct.
Good morning.
Good morning.
I'm going to follow a little bit the same timeline just so we kind of keep things together. You said you reviewed the body cam that was provided on the night that Eric passed away, correct?
Correct.
Okay. And that Kouri made a statement that night to police, a written statement.
Correct.
Okay. And she told them that she had made a drink, correct?
Correct.
Okay, so they were aware of that. Was there anything in that body cam or investigation that talks about them looking for a glass that a drink had been made in?
No.
Okay. But you said that they searched for illicit drugs, correct?
I don't know if they searched for illicit drugs, but they searched the home.
Okay, so they searched the home that night knowing that he had a drink right before he went to bed and made no note that they had recovered glasses, looked for glasses, anything along those lines, correct?
Not to my understanding.
Kouri's defense attorneys now very much argue that the media was the one who seized upon the drink. But we're here at the very first, really major public hearing in this case, and they're asking about the drinks on cross. Of course they are.
You also testified that when you interviewed CL, she was working on both a personal and, I'm going to say, professional capacity for Kouri, correct?
Correct.
And she was cleaning houses, that she was both cleaning Kouri's personal home and then she would clean homes that were investment properties, correct?
CL told us that she cleaned both homes for Ms. Richins' business as well as at another time frame she cleaned their personal home.
Okay.
So not necessarily at the same time.
But at the time, she was cleaning homes for the business, correct?
Which time are you referring to?
On or about the time leading up to or during your investigation, end of the year, end of 2021, beginning of 2022?
At that time, from my understanding, what CL told us, she was cleaning only investment properties belonging to the Richins Realty Company.
And she was getting compensated for that, correct?
Yes.
Okay, and so the check that you issued the search warrant on for the bank, that was written from Kouri's business account, correct?
Correct.
Okay, so it could very well be that Kouri was paying her for cleaning houses, correct?
I don't want to speculate, but
It could be,
it's
despite
possible.
what CL said, correct? Okay. You also testified that CL was progressing through her drug court program and you were optimistic about how she would do in it, correct?
No, I testified that she was optimistic about her own personal
Sorry if I
recovery.
misstate that. How long were you investigating CL? When did you begin investigating CL?
I'd forgotten some of these questions.
I don't know an exact date.
A good
but
question.
The beginning of 2023.
And were you monitoring what she was doing at that time?
Yes.
Okay. Because you knew she had a boyfriend or this guy in Vegas, some other details about her life, correct?
Set of investigating CL.
It's not you,
No, we
it's
didn't know
this
all those
feed.
details.
But over the course of your investigation, you learned them.
Correct.
Did you have CL's phone?
Summit County Sheriff's Office evidence text too.
But you've reviewed it?
Yes.
The feed is jumpy. It was jumpy that day. I do not know if it was weather. It is not y'all. It's the feed in this case from this hearing.
Okay. And you testified about text messages between CL and the defendant on or about this time period you're looking at in February, correct?
He said they were deleted.
Did you review any other information prior to that time about contact that CL and the defendant had had?
I'm unsure.
Did you even
but
look?
It's possible that we looked into communications. In this investigation, initial stages, we looked into communications with everybody that the defendant had been communicating with.
Okay. But you don't recall, or you didn't look for a pattern of communication between CL and the defendant, is that correct? You were focused on February?
I guess that depends on what stages of the investigation you're talking about.
I'm talking about any of them. Did you ever look and see if CL and the defense...
Do you think Sky watched the cross-examination of this IO during trial and went, no, come on, put me back in? I wonder. It would have been really, really hard after knowing this case and doing the hearings in this case to, I think, to watch someone else do this case. I think that would be very difficult. But her cross is just smoother. It's just, did you do this? It's just a smoother cadence.
And texted each other about...
It's still snarky, but it's a smoother cadence. There was a conflict arising out of the civil case that required Sky to withdraw from this case. It was not the jail calls. It was not the walk the dog letter. There was an unavoidable legal conflict.
Anything on a regular basis?
Yes.
Okay. And how far back did those go?
I'm not sure on exact dates again.
And we're never going to hear more about it, unfortunately.
2021.
I'm curious too.
Okay. So for a period of time, because CL is working for the defendant, there's communication, correct?
Correct.
And nowhere in the communication between CL and defendant, text messages asking for drugs.
Speed.
Correct?
We didn't find any, but there were also time frames in the phones when we looked at them.
Now I want to also talk about, you said you didn't make any promises.
Correct. No specific promises.
Okay. You did, however, tell her, let me back up. When was the first interview you had with
Did the get out of jail free card already happen?
CL?
I believe it was April 28th or 26th.
Oh, the Blair Witch
26th.
camera angles. The walk the dog letter was not written until
Did you have any contact with her prior to
till September 2023. We are in June 2023. Walk the dog letter hasn't happened yet.
that?
No.
Did anybody from law enforcement have contact with her prior to that?
Not from our office.
You don't know if anyone else talked to her?
I don't.
Okay. Now, part of this came out of a raid or something along the lines that was coordinated with at least ATF and some other agencies, correct?
CL's home was subject to a search warrant based on information that we had gathered during
and because
our
of drug
investigation
court.
into CL.
Okay.
And because of drug court.
And that search warrant would essentially contradict that she was doing well and what she was supposed to be doing in drug court, correct?
Well, the results were.
She was buying drugs, wasn't she?
We didn't know that. We knew that she was associating with people that we knew had active warrants for drug charges.
Okay.
And that violates her drug court conditions. When you are on drug court, they can come search without a warrant. It's, of course, if they're going to use it in this trial, better to have a warrant. You don't have to argue over it. But yeah, if she was associating with people that had warrants out, it would have violated drug court and they could have gone and searched at any point in time. They got a warrant, I think, to be careful because they were going to use it in this case. But yeah, they could have absolutely done that.
Be a violation of drug court conditions, correct?
From my understanding, yes, but I don't know the details of that.
Okay. And as part of that search warrant, were individuals arrested?
CL was arrested, yes.
There were other individuals who were arrested too, correct?
I'm not recalling other individuals that were arrested.
Were
on the
you
date that the
there,
warrant
bro?
was served.
Okay. Were any...
Weren't you there? I mean, maybe they weren't.
Drugs recovered at the home?
Yes.
Okay. And you also recovered a firearm from CL's bedroom, correct?
Correct.
And that would be a violation of her drug court conditions, correct?
Correct.
Okay. Now, in this first interview in April, you begin the interview. I'm over here to find the right notes. by explaining to CL essentially how dire of a situation she's in, correct?
I don't have the interview memorized, but I know we talked about that, yes.
Okay, well, you told her that she was on probation to drug court for 4 first-degree felonies, correct?
Correct.
Okay, a violation of that is a potential prison sentence, correct?
It would depend on the prosecutor, but that's potentially true.
Okay, a first-degree felony.
Is it a potential prison sentence? Yes.
It carries a possible penalty of life in prison, correct?
I don't know about that.
I'd have to reference the code.
Stick to the code.
So you told her she was facing problems with that, correct? That this would be a violation. So she'd be on the hook for 4 first-degree felonies.
Potentially, yes.
Okay. And you also told her that having the fire.
I had forgotten how much in Cross they focused on Carmen Lauber, even back at the bond hearing.
Could potentially be a new crime, correct?
Correct.
Okay. And then you also told her that the U.S. Attorney's Office was essentially on board with screening drug distribution charges, correct? I'm happy to play it if you don't remember.
I don't remember specifically.
It's got to be on video or the U.S. Attorney's Office isn't doing shit with it. Let's be real. Well, like if it's not on video, they're just not.
Do you remember talking to her about potential federal charges?
Yes.
Okay. So she was aware that not only was she facing multiple first-degree felony prison sentences, she was also potentially facing federal charges, correct?
Correct.
And during that initial interview, she tells you that she didn't buy fentanyl, correct?
I don't know if she made that specific statement, but
Good question.
She talked about not knowing anything about fentanyl.
Okay.
Right. That's not how that
That
came.
interview lasted about an hour and 19 minutes.
That's not how that came out in the direct examination. In the direct examination, it came out totally different.
Hour and 20 minutes, correct?
Correct.
Okay. And that interview ends.
Your Honor, can people just have water bottles in your court? These little plastic cups are giving me anxiety. They're so small. They just look like they would get knocked over onto people's laptops.
Well,
they stress me out.
With you telling her, sometimes you tell her to think through all of this and let you know if she wants to help.
Yes, I gave her the opportunity to tell us up front whether she was willing to cooperate or if we should just not bother interviewing her anymore.
Okay. But this is after you essentially tell her that she has a potential of doing a considerable amount of state and federal prison time, potentially.
Yes, this is a common tactic in law enforcement to be able to.
Just say yes. It's a bond hearing. The judge knows what it is. Just say yes. Just say yes. That's all. You told her she could face prison time. Yes. We know that you did. Well, ma'am, this is what you're looking at. Let us know if you're interested in talking. Bye. Just say yes. Just answer the question. You're not in front of a jury. The judge knows. Just answer the questions. That's it.
Leverage charges for information.
Okay. In fact, you did in this case leverage charges for information because you told her that you didn't care about first-degree felonies or federal charges. What you cared about was information about...
Ding, ding, ding.
I told her that I was interested in the information that she may know about this case.
Okay. But you told her also that Eric died of a fentanyl overdose, correct?
Correct.
And you told her that you thought that Kouri gave him the drugs, correct?
I did not specifically say that.
You alluded to the fact that you needed information about Kouri getting fentanyl because that's how Eric died, correct?
Probably.
I don't know if I made that specific, but the information that we tried to convey to CL was that
we don't care if you were part of the hand-to-hand transactions. We want to know if Kouri killed him. That's a bigger deal to us than a hand-to-hand transaction. Yeah, 100% they said that. Jurors understand that. I don't understand the couching. Jurors understand that people do hand-to-hand drug transactions and that it is not as big of a deal as poisoning someone to death. They understand there's no need to couch it.
wanted to know the information that she may have regarding Eric's death.
Okay.
That's it. Just be straightforward. It's just
You didn't
so much
care
better.
about any additional charges. All you cared about was that information, correct?
As I said previously, we expressed to her that the information that she may have was more valuable to us than seeking charges
that
against
is
her.
a fair answer. That's a good answer.
All right. And then you interview her 2 more times. Is that right?
No, there were, I believe, 3 more after our first one.
Okay. Were all of those audio and video recorded?
If you're just coming in, this feed is like this. The feed stuttered the entire time. I'm sorry. It is frustrating. It's not your internet.
Yes.
Okay. And those were turned over to the state in this case, correct? The state being the prosecutor's office. Okay. Now, forgive me because with all these interviews, I'm not sure which one comes from which.
Fair.
You, in subsequent interviews...
Sky was also hired by Kouri prior to Kouri being arrested because she knew what was coming. But she hired Sky prior to getting arrested.
Tell CL that she needs to give good enough details that will ensure that Kouri gets convicted of murder, correct?
That's what he said. We
I don't
saw
know if
the
I made that
interview.
specific statement, but I did express to her that the information that she gave us needed to be specific enough that we could corroborate it and that it could be presented to a courtroom.
That's fair.
And that she was, quote...
That's a fair answer. I don't remember if that's my exact quote, but we said we need specific information that we can corroborate.
Screwed at this years if there's not cooperation, correct?
No, I never made such statement.
Okay. Did you ever tell her this was her get out of jail free card?
No, I did not.
Are you sure about that?
Yes.
I forgot that the get out of jail free card came up at the bail hearing. I totally forgot. Also, I think it's fair because I think Maynard said it.
Now, at some point, CL tells you that in one of the
I think
interviews
Maynard said it.
that
I thought Maynard
Kouri
said it's your get out of jail free
contacted
card.
between December and February.
She asked him, did you say this? Not did you or your partner say it. I don't think he said it. I think it was the other officer that said, this is your get out of jail free card in that interview. But I could be wrong. A lot happened in trial. But I'm not going to go back and look, but I think it was the other. She only asked the question, did you say this? She didn't say, did you or your partner say this?
To obtain prescription pills for an investor, correct?
Correct.
Okay. And she doesn't specifically state fentanyl at that point, correct?
Are you referring to CL?
I'm referring to CL.
I don't remember, but I don't believe so.
Okay. And in fact, I'm guessing it's something where on the second or third interview, CL says that those first pills, never says those first pills are fentanyl, correct? It never says that Kouri asked for fentanyl, correct?
I'm sorry, could you rephrase the question?
Sorry. In those first, in the first transaction, so initially CL tells you that there were 3 transactions prior to Eric's death, correct?
Yes, and what I have to say here is that
That was a yes or no question.
But none of the information that
Fair. CL told you there were 3 transactions prior to Eric's death. Yes or no?
we got from CL was perfectly chronological. We had to piece it together over multiple interviews to come to the conclusion that we came to.
Because you told her you needed something more specific to ensure that Kouri gets convicted, right?
No, we told her that we needed more details on what she was talking about and specific dates and times.
Okay. But in the first one, she says there's 3 transactions prior to Eric's death, correct?
At some point in our interview, she told us that there were transactions.
Okay. And she says that Kouri was only looking for prescription pills or hydrocodone pills, to be specific, correct?
CL referred to them as Roxy's.
Okay. What do you know Roxy's to be?
can be different things in the drug world.
Sir.
They can either be counterfeit pills that are meant to look like a prescription pill, or they can be actual prescription pills. But generally, they're known to be opiate-based drugs, whether illicit or pharmaceutical.
Okay, so something along the lines of hydrocodone or Oxycontin or something along those lines, correct?
It could be, yes.
Okay.
Sir, weren't you a drug cop? How are you not explaining Roxy's better? Johnny Depp explained it much better than you did, sir.
And she specifically says that she was looking for $900 worth of fentanyl pills, correct?
I don't know if initially, but she did make the statement of $900 at one point in one of our interviews.
Okay. And she says that Kouri told her to leave the pills at an outdoor fire pit at the Midway house where there was cash, correct?
I don't know if she made that exact statement, but yes, she told us that at some point in part of the exchange that she was instructed to leave pills in an outdoor fire pit in a house in Midway.
Okay. And in fact, you sat there with her in this interview and did house searches, correct? Trying to figure out which house this was.
House searches?
Yes.
Okay. Like on Zillow?
Because she couldn't really tell you which house it was, correct?
She couldn't give us an address, but she was confident that she could find it if she could drive there.
Okay. And did you take her for a drive there?
Yes.
Okay. Did you ever do?
Okay, that's me though. But that's like, that makes so much sense to me. It's like, I cannot describe it. I do not know the address, but if you let me drive, I can show you. And if I see it, I can tell you, but I don't know the address and I can't tell you on the map. That is completely fair to me.
Any follow-up investigation on whether or not that house ever sold?
Yes.
Okay. And you know that house sold sometime in January of 2022, correct?
What I understand, yes.
Okay. So Ms. Richins no longer owned that home or occupied that home or had access to that home in February, correct?
I don't know.
Well, the house was owned by somebody else, right?
Again, I don't know.
Well, you said it closed in January of 2022.
From the information that I was told from other people, other investigators that had looked into that, I was told that Ms. Richins owned the house at some point and that it sold at some point. I don't know dates exactly.
It'd be important if CL's telling you that she had access to the home and was there.
CJ asked in the chat, and I think this is a very fair question, why are people disappointed Sky wasn't her lawyer? Sky's much easier to follow. Sky's also snarky, but Sky's easier to follow. And there's a gratingness to the way the defense presented their case that would have been different if Sky had presented the case. And Sky is easier to follow. Sky's a zealous advocate, but the style is easier to follow for many. And so it's a different style of lawyering. And so I think many are just like, this would have been less stressful. Sky would have been less stressful to listen to. I also think there are many, myself included, that looked at the defense team and was like, but why aren't we arguing this? And why aren't you doing, what are we doing? And that gets frustrating too. Just easier to follow. But that said, Kouri wasn't happy with Sky either. We saw that in a few of the filings early on when Sky was arguing about getting the walk the dog letter kicked out, because Bloodworth is a snarky guy at times and put in some of those jail calls where Kouri was talking mad shit about Sky. So Kouri wasn't happy with Sky either. I don't know if she was happy with Lewis and Nestor either, but she wasn't happy with Sky during the pretrials.
In February?
Possibly.
That might be a good fact to know.
She's like, so Kouri didn't own the home? You might want to know that, detective. I mean, there's definitely snark.
then does subsequent interviews.
I mean, the snark is different. The snark is just different.
Important if CL's telling you that she had access to the home and was there in February?
Possibly.
That might be a good fact to know.
I mean, fair.
Okay. CL then.
But also, this laid the groundwork for the witness we saw at trial that came in. The witness we saw at trial came in and was like, we hadn't moved anyone in. Work was still getting done at the home.
Does subsequent interviews, correct?
Yes, we had multiple interviews with her.
Okay. And after being told that Vic, as your words are, correct, she now says that it was specifically fentanyl that Kouri asked for, correct?
Correct.
And that she didn't actually take the pills to that house in Midway. It was a hand-to-hand transaction, correct?
Like I said, she went back and forth on her memory on which instances referred to which transactions, and ultimately she told us that she was sure that the first transaction of fentanyl was a hand-to-hand transaction in her driveway.
Okay. And was what's been referred to as acquaintance 3, was that in regard to that transaction?
No.
Okay.
It was the second transaction.
Were you able to corroborate, was anyone with her that could corroborate that she saw CL hand Kouri drugs?
Not that I know of.
Okay. And then she states that now there was a third transaction that occurred after Eric's death, correct?
She didn't make the statement that it was after Eric's death, but she told us there were 3 total transactions.
So the information contained in the state's amended information, you don't know where that came from?
Which information?
That she purchased drugs after Eric's
Can you
death.
just say hi?
Yes, I do know where it came from.
Okay.
You want to go back on the desk and watch the birds, I know.
And you're saying CL did not sell drugs to Kouri after Eric's death?
CL could not remember specific dates and did not make mention that the transaction happened after Eric's death. But when presented with digital evidence from other witnesses, she confirmed that that was most likely correct.
Okay. So she just agreed with your scenario of events, correct?
No, in fact, several times during our interview, she told us that as we presented her more information, it helped her remember more.
Okay.
Which
so as
makes
you're telling her
sense
to
when
be
it's
more
your
specific,
phone.
you're providing her with information that you're gaining in, and she's saying, now I remember. Accurate?
I mean, when you put it that way.
Yeah.
This is the feed. It's not you. It is jumpy.
Also testified that you interviewed 2 of Eric's best friends, right?
Yes.
Okay. And
I want to hear more about this.
Interviews, this check was used for. You testified that she picked up the check.
She jumped to the check. She was like, I'll come back to that in a second.
So I'm going to go back to CL for just a second.
Darn it. I want to hear about the best friends.
That you allege that this check was used for, or the state alleges this check was used for. You testified that she picked up the check. There was and cashed it, right?
Correct.
And drove to the Maverick and purchased fentanyl.
She didn't drive, but she was.
Someone drove her,
Yes.
okay? And the person with her corroborates that.
Correct.
And that third witness never saw CL give those drugs to Kouri, correct? Acquaintance 3 never saw that?
Acquaintance 3 didn't tell us that he ever saw that, no.
Okay. In fact, there's no independent witness to corroborate that CL gave Ms. Kouri those drugs, correct?
No eyewitnesses that we have identified, but the investigation is ongoing.
And CL is currently out of custody, right?
Depends on your definition of custody, but she's not incarcerated, no.
Not incarcerated, just on, I think, ankle monitor and not to leave the county, right?
Correct.
But following your interviews with her, she was released from jail.
Not immediately, no. She worked with the prosecutor in the other county where her drug court is, and came to a resolution as to those charges against her. And part of that was being released on ankle monitor.
Okay, so in exchange for the testimony, not testimony, in exchange for the information that she provided to you, and a deal was worked out where she was placed, essentially released from jail on the order to show cause, correct?
I don't know the specifics of what went on between the prosecutor and CL,
Okay.
but subsequent to our interviews, we reached out to the prosecutor's office and let them know that she was being cooperative. After that, I was not involved in
I mean,
any
he has
decisions
more
regarding her
information
release.
about that.
Okay, because that's up to the judge and whatnot. But you did communicate that to prosecutors?
Yes.
That she gave you the information you needed?
That she was being cooperative with our investigation, yes.
I think O'Driscoll's trying to be precise. However, there are times it just comes across as sidestepping in the way he answers it, but I think he is trying to be precise.
I'm going to turn now to your interview, and I'm going to use initials. Are you okay with that? You had an interview with one of Eric's friends.
This I want to hear more about.
His initials are JS. Do you recall that?
Yes.
Okay. That interview occurred about April 20th. Is that correct?
That seems right. I don't know a specific date, but
Okay. And during that interview, he discussed, or you discussed with him, that he and another individual were essentially Eric's best friends, correct?
Ms. Sarah, my apologies.
Yes.
April 20th of which year?
Oh, 2023.
Three.
I apologize.
Thank you.
This is fair for the judge to be like, what year are we talking about? Because the death happened in 2022. This hearing's happening in 2023 in June. And the interview happened in April. This detective came onto the case in April. Kouri was arrested May 8th.
At any point during that interview, did JS mention that Eric had said that at any point during he and Kouri's marriage, he was concerned that Kouri was attempting to poison him?
I don't recall, but I don't think so.
In fact, you present him essentially three scenarios of what could have happened to Eric, correct? That he essentially did it to himself.
This is before the attempted murder was charged.
Knowingly, that someone else did it to him, or that it was accidental, right? Okay. And you specifically ask him if he thinks Kouri would have done it, and he says, no, in my gut, I don't believe so, correct?
I don't know if that was a direct quote, but yes, he said that he didn't believe that she would have done it.
And he also states during that interview that at the time of his death, Eric and Kouri's marriage was in a really good place.
Yes.
Correct? Now, he also details or talks about a follow.
I think this was Jake, not from State Farm, who was Captain Strays in closing. I agree, chat. But now we see why Jake didn't come in. And the defense knew that what Jake had to say was helpful to the defense. And then in closing was like, and we never heard from him. It's all hearsay. Like, it's all hearsay. Also, I don't blame Eric's friends if they're where the jury is with, I don't want to believe this could happen. It's terrifying.
Out that he and Eric had over the course of their friendship, correct?
Yes, that sounds familiar.
Okay. And that Eric and his other friend that he refers to in this interview actually had a falling out right before Eric passed away, correct?
Yes.
Okay.
Is that about the hunting? Again, are we trying to insinuate?
We also talk about
that somebody else had a motive?
He talks about the fact that of them at different times that had marital problems that they had helped each other through, correct?
This feed
JS
is just...
told me that he and Eric and their other friend would confide in each other about their marriages and would share information. And that was how he had the insight that he had into Eric's life.
He also talks about that Eric changed or created these trust documents, correct?
Correct.
Okay. And his understanding, based on what he said that Eric told him, was because
Kouri still had access to funds. A lot of you are asking, how did Kouri pay private counsel? Kouri still had access to funds, other people's pockets back in 2023. So, because the trust hadn't clawed stuff back, and if it goes to Sky, it can't get clawed back.
Eric was pissed or upset about a relationship that Kouri had, correct? Or he thought she had.
Oh? What now?
I don't remember the specifics of that part of the interview, but I do remember that JS was aware that Eric had made the trust.
And he doesn't specifically say anywhere in that interview that the trust was made because he was mad about this home equity loan, correct?
JS expressed to us that he understood that the reason that Eric created the trust was to ensure his son's well-being if anything were to happen to him.
And he also expresses to you that because you asked him why it wasn't changed back, or because the sister was made the trustee, correct? And
I'm sorry, I don't understand the question.
the sister, so in the, that was a terrible question. In those trust documents, the sister was made the trustee, correct?
From what I understand, yes.
I love this guy's like, I'll fix it.
And you asked JS specifically, or somewhere along the lines of, if they were doing so well, why would he have not changed that back? Right?
Yes.
Okay. And he tells you that
we're getting the whole thing.
it was his way of ensuring that even if they were doing well at the time, if there was a divorce, he would get the last word in it, right?
I remember him using that phrase, getting the last word, yes.
This is JS's conversation about a conversation he had with Eric. A number of you asked in the chat, when was the attempted murder filed? I went back and looked for that. The attempted murder was filed in March 2024. So a little over a year after Kouri was arrested, or a little less than a year after Kouri was arrested, the attempted murder was added.
All right. Now, you also testified today about this hunt.
I have cat fuzz.
That took place down in Mexico, right? Correct. And this hunt was February of 2022, correct?
I don't know specific dates, but I'm aware that Eric was on a hunt in Mexico shortly before his death.
Okay. And JS tells you that he was really upset, actually leading in the days right before he passed away, about what had happened with this hunt, right?
We're back to pronoun issues. He, whom? Which he? JS or Eric? Whom is upset?
Yes.
And he was upset that they had paid an outfitter for a number of permits that they believed the outfitter had procured, correct?
Yes, from what I'm recalling, he was upset about the outfitter or the guide had not gotten enough permits for the amount of animals that they ended up taking, and it caused some.
Oh, I bet after hearing trial, none of this had a lot of resonance for me when we were looking at this in 2023. But now that we know so much more backstory, as we're going through this bail hearing again, it's interesting to me that Eric was upset regarding the hunt down in Mexico. None of this came in the murder trial, but that there weren't enough permits. I can imagine that he was particularly sensitive to that situation, given that that's why he was on a hunting ban in the United States. Yeah, I can understand that he was frustrated.
Concerns over legal requirements of tagging animals.
Okay.
Yeah,
and
I bet Eric was particularly sensitive.
Correct.
Okay.
Particularly sensitive about
and
the
this
tags
is the
needed.
same. Is this outfitter the person that you investigated? Or that you interviewed?
Someone associated with that hunt and that outfit, yes. I'm not sure the exact association, but a contact for that outfitter.
Okay. So that outfitter was aware that they had made some serious problems for Eric with regard to how many animals they took in Mexico, correct?
According to JS, yes.
And
that's not good.
In your subsequent investigation, Eric had some heated conversations actually the night before he passed, or the night that he passed away, with that outfitter, correct?
Do we know they were heated?
About that, yeah.
Okay.
From
In fact,
who?
He was searching how far it was to drive from Scottsdale down there, correct?
Correct.
Why was he wasn't searching how far it was to drive from Scottsdale. He was searching how far it was to drive down there, I thought, from where he was. I might be misremembering that when it came in at trial. But who said that he was having heated conversations? If it was Kouri, I don't know if I believe it. If it was Eric's text messages, I believe it more. Chad is telling me it was from Scottsdale. I had missed that detail. Thank you.
Well, his phone showed that search.
Okay. And JS also told you that he had information or believed that this outfitter was somehow connected to the cartel, correct?
I don't recall. That sounds familiar, but I don't recall if those were the words that he used.
But essentially,
JS made a statement about the cartel when he was talking about Eric and that hunt, yes.
Okay.
Counsel, would you approach for a minute?
Yes.
Okay, so they're going to approach. This feed is choppy. It was a choppy day in court. It's choppy. It's choppy. I remember the searches. I just didn't remember. Oh, I think I remember this. Hold on. It was choppy the day it happened. It's still choppy. It just is.
No, we're good. We're going to take a break. Do you mind clearing the gallery first, and then we'll reverse the process on the way back? All right. So everybody past the
They are taking a break and clearing the gallery because the court was pissed. This hearing was not supposed to be streamed in real time. Some of the outlets were streaming it. The court found out that outlets were streaming it. Court TV and others kicked everyone out of the gallery, called in members of the media like one by one, and was like, it's not supposed to be streaming contemporaneous. I think it was a 1 or 2 hour delay or more. So the court yeeted the entire gallery.
So, ladies and gentlemen, I need to handle an issue with some members of the media that are live streaming without permission to do so. This is a good opportunity to take a restroom break. We're going to reverse the process we used on the way in. If the gallery would please follow the deputy's instructions, proceed orderly on the way out. We'll let you stretch your legs. We'll come back in about...
He said orderly. He said orderly. Chat. Orderly. Orderly?
20 minutes. Thank you. Now.
Oh, and there's Mr. Kostradimas. Okay, so the tech expert sitting there next to the elected DA, next to the forensic accountant.
All right.
The judge was pissed about this. I love that the camera's like, oh, we're not going to stop rolling. We're not going to stop rolling. We're just going to roll. And so the camera was like, nobody told me to stop rolling.
I think they're live streaming it separately. I can clarify, but...
Yeah, I wouldn't. ABC4 is live streaming.
ABC4 is in trouble.
ABC4 has the signed order.
KUTV's in trouble.
And Court TV.
Court TV's in trouble. EDB wasn't in trouble. EDB pulled the court orders. If they say no live streaming in real time, I'm not live streaming in real time. I don't want to get in trouble with Judge M. Oh, no way. I'm not getting yelled at by the court. Nope, we can wait. I mean, they kept filming. The mics were on.
You can see. Folks,
the judge fought with the media this entire case.
the jury box can sit down if you like. You're okay. Counsel, you're okay to have a seat if you'd like.
Thank you.
So then defense stays at defense table. They're just asking where they're going to put Kouri, if she's going to stay in the courtroom or not. She's talking to her attorneys. I'm zooming through all of this. They take Kouri back, I think, probably to the interview room. The court calls in whoever the producer is from like Court TV and is like, hey,
Adrian? Are you able to confirm?
What are you doing?
What's your name?
Adrian?
Are you able to confirm whether or not you're allocating the ABC4 news stream or live streaming audio through WebEx?
Oh, no, we're not on the WebEx. We are plugged into the media room with everyone else.
Okay.
It's my understanding that
That's fine.
Oh, okay.
Thank you for confirming.
Sure thing.
Okay. Chris, can you reach out to somebody from KUTV and confirm whether or not they're doing the same?
Mm-hmm. He was so mad. Okay, we're going to zoom through this to resume Sky's cross-examination of O'Driscoll. Once the audience gets back in, O'Driscoll resumes the stand. The judge was big mad. On that. But again, we being Baker Media did not become part of the pool until later, but followed all the media orders.
Identification documents in there, correct?
Correct.
Are you aware that those are now expired?
No.
This is back to cross. Let's see. We're going to zoom just a little bit.
Do you have any questions with the district attorney's office prior to you talking to her?
This is a super choppy part of the feed. We have seen some of this testimony in trial. I'm going to try to zoom past the roughest part of this to redirect. I think we're just about done with cross.
On that date at that time, no, I don't believe so.
Okay. Was Detective Woody removed from the case?
She wasn't removed from the case.
Woody got a puppy. Why is this so hard for everybody to understand? The Lawnards are like, I'm sorry, if you are offering me the opportunity to work with humans or puppy, I am picking puppy. I don't know why this is so hard to understand, but apparently it is. All right, we're back at 1.25 speed, chopped feed and everything.
Could no longer fulfill those duties.
Okay, what is she doing now?
She's in patrol.
Traffic.
No, patrol.
Patrol,
Yes.
as in like a
Responding to emergency calls, yeah.
Okay.
She's also part of the K-9 unit.
Right, she got a dog.
So she went from being the lead detective in a murder investigation, potentially, to patrol, correct?
That happened in our office.
Okay, thank you.
Mr. Bloodworth, anything further?
I appreciate that people tried to make it nefarious, but also it's not a demotion to go to K-9. But again, perception.
Yes, Your Honor, thank you.
Within the scope of cross, please.
I like that he's like within the scope of cross, and Bloodworth is like obviously and always. Obviously and always. Kelmarie, we saw him a little bit.
Detective, I'm crossing.
It's just the camera operator's choice. But we saw him a little bit.
Examination, Ms. Lazaro
And then we're
asked
going
you
to
about
zoom a little bit. I covered this full
Ms.
hearing
Richins'
back in 2023.
narrative from that night that
We
she
were
gave her husband a drink.
Jumping around
Yes.
in this hearing
She asked
today.
you about whether or not the police recovered a glass, a cup, a mug, some kind of container for that drink that evening. Remember that?
Yes.
Were there any glasses or containers near the defendant that evening?
On the evening of the death.
I think he meant victim.
Correct. I guess it's the morning of the 4th when police arrive.
Right. I'm unsure without being there on scene. But from reviewing the body.
And am I right that the only information that indeed Ms. Richins, Kouri Richins, the defendant, gave her husband Eric Richins a drink was the defendant's own words, right?
Yes.
The argument about that changed significantly by the time we got to trial, right? You can see where Bloodworth is going with this in the bail hearing in 2023, but by the time we got to trial, it was like, oh no, she gave him a drink. Yep, we're pretty set on that.
Ms. Lazaro had asked you about gaps in timeframes in cell phones. Based on the carrier records, what have you been able to determine about gaps, particularly from early January until shortly after the defendant's?
We were able to determine from looking at the phone that it appeared that data from several different apps in the phone was missing in that time frame between January and just shortly after Eric Richins' death.
Let me turn now back to CL. The very first time you met with CL, you testified that you kind of laid out
All right.
kind of the predicament.
We're going to zoom past the redirect on CL. I don't think we will gain anything new from that we didn't see at trial. But again, talking about the fact that Kouri Richins did not wipe her entire phone. She wiped from January to Eric Richins' death from her phone. It was not the whole phone. It was just a period of time. And that will come up more. They're going to call the next witness, Mr. Kostradimus, who is going to testify, to the best of my memory, about Crozier and Carmen Lauber, which we already saw at trial. I covered the bond hearing back in 2023, so the full hearing is there. We're going to zoom. Though I found Mr. Kostradimus delightful, I think we are pretty clear on the narcotic transactions. I'm going to look at the first couple of questions for the forensic accountant, because I think it was at this hearing that the forensic accountant talked about the day and date debt that Kouri was carrying, and we didn't see that in trial, but it absolutely boggled my brain when they talked about it. And then we will look at what the impact statement was, arguments from the lawyers and from the judge.
For the court to be the truth, the whole truth, and nothing but the truth, pains and penalties of perjury.
Because the audio on this is going to do me in at some point. Truly.
Morning. Could you state your name and spell your last name, please?
Brooke Karrington, Karr.
I think at this time, Brooke was still working for the estate.
INGTON. I am a principal managing partner at Financial Forensics.
All right, I'm going to see if this is any better at normal speed with the stuttering. I hated it when we did it last time. I forgot how much I hated it, but the stuttering is so difficult.
Is this a company that you started?
Yes, it is.
And when did you do that?
Official.
Background training experience. Brooke Karrington is the GOAT. Forensic accounting is Bay. If you want to be nosy and you like numbers, what people are doing with their money, follow the money is always a solid way to go. We're going to zoom past background training and experience.
Okay. And who hired you?
And we're going to zoom past the estate hiring her. We know all of that.
Were you able to find information regarding the defendant of homes?
Yes.
The stuttering is so bad.
Those documents are typically recorded, and they are public documents, and they're typically at counties, recorder's offices. There's also information along that line at the assessor offices, and each state has a little bit different process of doing them. Most of them do.
I love that she's also like explaining to the judge.
Which is through the county recorder.
Okay. I'm going to show you, if I may approach you,
Right. I'm going to zoom a little bit until we get into the loan servicing, because I believe her testimony was fairly extensive, but the loan servicing is what I'm interested in.
I do know on some of these what these lenders do require, and it's in the...
Okay, we should be around here when we're talking about the hard money lenders.
Do you find this significant?
Yes. On a positive note, it depicts that the business was growing and she was actively acquiring properties. I think it's noteworthy, and it's an indication that things were growing quite significantly, and sometimes that is problematic.
Now, why is it problematic?
Well,
it's kind of a basic thing, like in business school, where growth too strong to...
Business school? Business. There's no business school.
Is challenging for a business.
Okay. Were you able to determine at the end of 2021 how much the defendant was obligated on those debts, those $6 million debts? And actually explain to me the difference. What does obligated on a debt mean?
That's a very important question and very, very important point to understand here. I don't have access to the documents that tell me the terms of these loans. So I don't know what the interest rate is of these loans. I don't know the terms that she's agreed to for these loans. I don't know what payment is required on these loans. What I do know is these are what we colloquially call hard money lenders. And I do know on some of these what
she got more
these
access
lenders
through
do
search warrants
require,
later.
and it's in the neighborhood of 12 to 15%. These are not conventional loans where there's a 30-year payment amortization. These are typically short-term loans, and the house flipping business, the fix and flip business, typically are turning those over a little so they don't need a 30-year loan. They need a shorter-term loan. So I understand we're obligated on, but I do not know what the balance is at the end of a particular time period.
I see. You need more to make that determination. Is that right?
That's correct. And that would be the loan documents themselves, the promissory notes, and the ledger from the lenders to show what payments were or were not made and how the interest was related in other fees. Typically, these lenders have significant loan origination fees, and if payments are late,
Emily,
then
did you forget about all of this when agreeing to cover it again?
Interest rate
Yes.
is higher on the late payment.
I did.
Perhaps default fees, things like that.
Okay. So do you have a rough estimate on what she was obligated to
This
at the
is
end
what
of
I wanted to
2021?
Yes.
And what's that?
At the end of 2021, a little over $4 million.
Okay. And you don't know if that's you don't know what she had paid back, but you know that was what, at that point, she was obligated on.
That's was obligated on that she still owned at that time. And this is, I believe I've done a pretty good job looking for property that I don't know about.
Okay.
All right.
Bank account.
I forgot how badly this skipped. Let's see. We're at 236. I'm going to see if I don't think the other feed's better. I don't think it is, but it's making me. Oh, I forgot how challenging this was. But we learned some interesting information. We, in context to trial, have seen, and I'm going to switch feeds and see if it helps, but in context to trial, we have seen that JS, who they were talking about at closing, there's a reason that they weren't called during trial because it was all hearsay. And when we go through Brooke Karrington's testimony, it is largely about the daily loan servicing, but I will go back and look. It was a substantial amount of money that was owed to be paid daily and then weekly. It was, when it got to weekly, it was thousands and thousands of dollars that had to be serviced weekly. So with that, we are going to zoom past Brooke Karrington's testimony into the impact statement of Eric's sister. This is part of why I wanted to cover this. We had not seen this previously. Well, we saw it for those of you that watched the bail hearing with me originally. Yes, it's appropriate for impact statements to be made during the bail hearing because it goes to whether or not the defendant should be granted bail. So we're going to look at the sister's statement to the court, the prosecution arguments, the defense arguments, and the judge's finding. For those of you that were watching during trial when I kept talking about spoilers from March 6th, now that we are after the trial, we saw that there was a wake at the house on the 5th. Eric died overnight, the 3rd to the 4th. Everybody was at the house on the 5th trying to make it nice for the kids and pretend that everything was fine. It's all fine. Everybody's fine. It's all good. And shotgunning beers or whatever. The next day is when the locksmith was called. And at trial, we heard about the locksmith being called and that there was a kerfuffle about the locksmith being called and that Kouri was trying to get into the safe. And one of the sisters disagreed with Kouri getting into the safe. And we heard from the divorce attorney that the sheriffs called the divorce attorney and were like, you need to explain to Kouri. I'm aging myself. That's how I hold the phone. You need to explain to Kouri what's in these documents, because Kouri was flipping out at the house on the 6th to the point that the sheriffs got called, and the sheriffs called the divorce attorney to be like, I need you to explain to her what the estate attorney. Yeah, not the divorce attorney. No, yes, the estate attorney. I need you to explain to Kouri what these documents say. And that was the witness that was asked. So you were telling her on the phone that she was getting kicked out of her house. And that witness was like, it's ridiculous. That witness. We get more context for what happened from this statement. So for those of you, let me just put up a poll. I'm curious if you had seen the, if you've seen this statement. I believe this is Amy Richins. Let's see. From June 2023. Yes, no. I'm going yes, no, yes, but I forgot what she said. All right. I'm putting up a poll, and we're going to go back to court and back in time, because we can do that, and take a look at what was said. Because I'm sure there's stuff from this that I have forgotten. I'm hoping the stuttering is not as bad.
Thank you.
Fingers crossed. But there was one pool camera. So if one feed was stuttering, all the feeds were stuttering.
Yeah, before we rest, we would ask that this be marked as State's Exhibit
2 has not been admitted.
I'm going to zoom beyond what they're admitting for the court. For our purposes, I want to get to Amy speaking with the court. So she's speaking to the court as the victim representative and the family representative.
Go ahead.
Dear Judge Mrazek, I'm here today to represent my brother, Eric Eugene Richins, whose life was taken in a senseless act of poisoning on March 3rd, 2022. His wife, the defendant, has been accused of committing this crime. If she is found guilty, she has committed the ultimate act of betrayal. Eric is gone, and I am brokenhearted. He was my best friend and protector. The feeling of loss is so great it is visceral. And with the sorrow comes a wave of panic at not being able to see him again. I can never talk to him, never.
Oh, Kouri is just chewing on her face. It's not gonna hold the words in, ma'am. But it's interesting after reading the Walk the Dog letter. Remember, this is June 2023. Walk the Dog was written in September 2023. This is before Kouri's like, bring me home, let's get those bitches. Oh boy.
Or hug him again and never more be a part of his life. Eric's world revolved around his family, his love for hunting, the family cattle ranch, and his intense drive as a successful entrepreneur. Being born into the Richins legacy shaped Eric's formative years and resulted in a lifetime of hard work, dedication, and fierce loyalty. At an early
she looks
age,
mad.
Eric learned the joys of keeping horses and cows around. He spent countless hours work the ranch, hauling hay, feeding the animals, and mending fences. He loved our family unconditionally and was a devoted son, brother, uncle, and father. Eric was a family man who always strove to be the absolute best father and husband. He was an attentive and loving father to his 3 sons and a devoted husband to his wife of almost 9 years, Kouri, the defendant. Eric did absolutely everything in his power to provide his family and his 3 sons with every possible to grow and have fun. He was the coach or assistant coach on all his boys' teams, which included soccer, basketball, and baseball. He spent countless hours coaching
Busy
and teaching the
schedules.
boys to play aggressive and give it their all. Eric truly cared about every single child he coached and wanted the absolute best for all of them. There was never a dull moment when you were around Eric, whether it was him showing up to a family dinner with no socks or because he had to make an emergency bathroom stop along the way, or his calling to tell you he rolled the 4-wheeler for the upteenth time is stuck and he needs you to come get him. It was never boring. Eric loved to have fun and always wanted to make sure everyone else did as well. He owned almost every motorized toy possible, from 4-wheelers and side-by-sides to trucks and snowmobiles, and was so excited to share those with his sons. He had the perfect combination of business sense and foresight. He built a very successful masonry business from the ground up and helped
face.
many friends do the same. He had a special ability to build close relationships with everyone he worked with, which really allowed his business to thrive. Eric loved every aspect of his job, but most of all, he loved the people he worked for. Eric faithfully supported organizations that he truly believed.
I think Kouri looks mad and nervous. Like, what is she going to say? There's no cross-examination. There's no direct examination. This is an impact statement. And I think Kouri is mad and nervous about what's going to happen. Hi, George. We've said hello. The Lawnards have gotten to see both you and your brother. Do you want to say hi? I don't think it's polite to come say hi and not actually say hi all the way. I know. Your boy's not home yet. I know. The chat's worried about you when he goes to college. I know. I am too. All right. We've got an emotional support kitty. We've got a Fred and a George today. All right. We're going to continue. Kouri's face is going to face. I know. Look at that face. What do you think? Yeah. Mm-hmm.
Believed in. He never was one that wanted recognition or accolades. He did most things anonymously and without recognition. Eric was a true champion of all.
Very fuzzy.
It did not matter if you were an employee, friend, family, or the next random person walking down the street.
I
If you
scared
needed
him
anything,
by
you
trying to
could count
blow
on
the
him.
hair off of my face.
He truly cared about each person he met. Eric loved fully, laughed loudly, and lived life. He enjoyed great adventures to far-off places, but also cherished the small and finer things in life. No obstacle was too great for Eric. He simply viewed each one as a challenge. No peak was too high, and the next adventure was always just around the next bend. Words cannot describe the loneliness and loss that is felt in every heart that was lucky enough to know him. Eric was such an inspiration and role model for us all. His loss has created a Grand Canyon-sized hole in this community. Except instead of taking millions of years to slowly form, our worlds change overnight. His 3 boys' entire worlds and their perspectives on life changed. None of our lives will ever be the same. Eric died under horrendous circumstances. I am tormented at the thought of what he endured. I play it out in my mind. I go through the terrible sequence of events. I wonder when he realized he was in mortal danger. May have said to him in his last moments. How long was he conscious?
Oh, that's
knowing he would die.
A tough thought.
Where were Eric? Did they hear Eric's body fall to the ground? Did they catch a glimpse of their father taking his last breath? It's torture to think of. Why did Eric lose his life? Why did the boys lose their father? Was it because of Kouri's greed and desire to get life insurance and other?
This guy's like, no. Just use the Kleenex and maybe they won't be able to tell. Just use the Kleenex.
their assets? If so, that is abhorrent. How could anyone value human life so cheaply? I cannot comprehend it. I'm overflowing with grief and pain at the thought that Eric meant so little to her. If Eric had died because of an illness, he would have been cared for. He could have looked after him and been with him. If he had died because of an accident, people would have tried to help. There would have been kindness. But
I guess hiding your face in a tissue is better than whatever was happening before, but the judge can see you, ma'am.
He had here. There's no concern. In his last moments, after being intentionally poisoned, he was faced with betrayal and terror. The thought of it is unbearable. I am haunted by the horror of it. It has been a living hell for our family. We have watched as Kouri has paraded around portraying herself as a grieving widow and victim while trying to profit from the death of my brother.
Oh boy.
Both by trying to profit from a book about his death and trying to get life insurance and assets that should go exactly where Eric wanted them to his boys. Immediately killed, Kouri told us she could not help us get anything ready for the funeral as she was too distraught with grief.
Oh boy.
We shortly found out that was not true at all. In fact, she pulled herself off to go close on the purchase of a $2 million home, hire a real estate agent, hire an architect to create CAD drawings of the home, hire a lawyer in order to file a lawsuit on Eric's trust, hire a locksmith to come break into and clean out my brother's safe, and attempt to have Eric cremated. She mustered up the strength and resolve to do most of this within 48 hours of his death.
Holy shit.
Kouri assaulted me.
I'm going to back that up because I was talking about how fast things moved. Look, man, I am more discombobulated when my dinner plans change than Kouri seemed to be when her spouse unexpectedly passed. I have walked through way too much grief in my life. I've walked with people through too much grief in my life. But even when people are expecting someone to pass, I have still not seen people able to move this fast. And even when they know, even when people are in hospice, different than a sudden death. But a sudden unexpected death, and in 24 to 48 hours, she's like, boom, 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 boom. She's ready to move. And I think after we saw Bloodworth's point in trial, that for Kouri, that night started with the drinks. It's because Kouri has planned this out in her head for months. So yeah, that night started with the drinks because that's where her story that night started. But what she was going to do after started in her mind months before. So we're going to hear more about the safe. I'm going to back it up. But after hearing Bloodworth, because we never saw what she wrote in that death investigation narrative until closing, which was a very smart move. And we saw glimpses of that in the body cam and in Katie's testimony where Kouri was like, I'm going to sell the house. I'm going to do this. I'm going to do this. I'm going to do that. But when you take it in context of trial, the way that Amy's laying it out and how close the time was to an unexpected death is wild. That she was like, on to the next. Got to go close on the house. So I'm going to back this up as Amy gets into what happened with the safe, because that we didn't hear at trial, and I kept saying spoilers. So if you did not know about the safe, and a lot of you have not seen this bond hearing before, I think we will hear some of this when we get to sentencing and impact statements at sentencing. But yeah, there's Kouri filed a lawsuit against the estate within like a week. It was so fast.
lawyer in order to file a lawsuit on Eric's trust, hire a locksmith to come break into and clean out my brother's safe, and attempt to have Eric cremated. She mustered up the strength and resolve to do most of this within 48 hours of his death. Kouri assaulted me. I will never forget the look in her eyes when she attacked me that Sunday morning. It was early and had been snowing most of the night. I was just getting ready to leave and heading out to the car when I saw a locksmith in Eric's detached garage.
This is the morning after the party, the Bryce Pants party that we saw the video of. Yes, Kouri was charged with the assault. Yes, Kouri pled with regard to the assault. But when the sister says Kouri assaulted me, Kouri was charged with that too. This is about the locksmith.
Garage, starting to drill out his gun safe. Snowing most of the night. I was just getting ready to leave and heading out to the car when I saw a locksmith in Eric's detached garage starting to drill out his gun safe. I asked Kouri multiple times why we could not just call my dad for the code. I could not understand why she was breaking into and ruining Eric's safe. To this, she screamed at me at the top of her lungs, called me some inappropriate things I cannot share with you here.
Please do.
And then told me to get out of her house.
You can curse in court. You can curse in court. You can curse in court.
I could not understand why she was breaking into and ruining Eric's safe. To this, she screamed at me at the top of her lungs, called me some inappropriate things I cannot share with you here, and then told me to get out of her house. It was then that I told her that she could not kick me out of my brother's house. My sister, Katie, was now the executor of Eric's trust and estates.
The words I would have said. I will talk about why this didn't come in at trial after we get to this.
And just like Eric, she would not want the defendant breaking into his gun safe. Kouri looked at me with pure hatred and rage. I was messing up her plan. I was getting in her way. And because of that, she attacked me. Multiple times. It took 4 people to pull her off me that day. Before the funeral, Kouri opened a bank account and asked everyone that was grieving to send her money instead of sending the family cards and flowers.
Yep.
2 weeks after Eric's passing.
Oh, she didn't just punch Amy. She, from my understanding, tackled Amy and was trying to punch her while people were trying to pull her off. This is how the sheriffs end up getting called. This is what was being talked about when Staking was on the stand and was like, no, I thought she was valid. No, I thought she was valid. That this is what Staking was talking about. But Kouri lost her fucking shit on Amy.
Multiple times. It took 4 people to pull her off me that day.
She punched her multiple times.
Before the funeral, Kouri opened a bank account and asked everyone that was grieving to send her money instead of sending the family cards and flowers. 2 weeks after Eric's passing, that we were told she had taken down my brother and removed all his clothing from the house. Kouri put together a golf.
When they went back and searched the house in April, there were not seemingly men's clothes in the closet. They didn't focus on the photos being moved out of the house when they went back through the way that they did in Banfield. 2 weeks.
Tournament in Eric's name. The family cards and flowers. 2 weeks after Eric's passing, that we were told she had taken down my brother and removed all his clothing from the house. Kouri put together a golf tournament in Eric's name 2 months after his death on what would have been his 40th birthday and told his family, all of us, that we were not allowed to attend. Since Eric's...
The golf tournament was on his birthday. Oh boy. I wonder how much money she took from the charity golf tournament. Oh, the way I am too happy that the sentencing is on his birthday. Oh, I don't know how you feel about karma. Whether you're like, karma's gonna get you, karma is a cat purring on your lap, but holy shit. Woo! The universe is like, sorry, bitch. No. You want to have a golf tournament on his 40th birthday and tell his entire family that they're not invited? I got plans for you for his 44th birthday. Girl. I wonder if this will come back up at the impact statements when they make them to the court on his birthday.
Death, it has come.
Just back that up. That's wild. Well, the family will get to be there, won't they?
Put together a golf tournament in Eric's name 2 months after his death on what would have been his 40th birthday, and told his family, all of us, that we were not allowed to attend. Since Eric's death, it has come to our attention that Kouri took out multiple life insurance policies on Eric without his knowledge. It appears that she forged his signature on various documents, assigned herself as Eric's durable power of attorney, inappropriately diverted money from his business to herself, and assigned herself as beneficiary of Eric's portion of our mother's retirement account.
I had forgotten about that. The financial fraud stuff had not been charged yet in this case. This is the stuff they were finding out through the PI that law enforcement had not found out yet. Kathy at Oz, Kathy, good to see you, asked a great question. Can she read this again at sentencing? I'm sure she'll want to add to it. But these are all appropriate things for sentencing. I had forgotten about the retirement account.
Forged his signature on various documents, assigned herself as Eric's durable power of attorney, inappropriately diverted money from his business to herself, and assigned herself as beneficiary of Eric's portion of our mother's retirement account. I should also not forget to mention the multiple life insurances she has taken out on the boys. Her most recent business venture was authoring a children's book about how to help grieving children cope with the loss of the death of a parent. In this book, she had the audacity to use the boys' real names and even use their last family portrait. Her behavior gives me great concern, as she has exploited the boys for money and will likely do so again. In addition, Kouri has weaponized Eric's children, manipulating my dad to do or not do things by threatening to cut him out of their lives if he did not capitulate to her demands.
Is anyone shocked? Is anyone shocked that she was weaponizing the grandkids? It's incredibly toxic. It happens all the time. But is anyone shocked that she was weaponizing the kids against Eric's dad? It's awful. I remember the life insurance about the kids. I can understand why the family was so concerned. Yeah.
She similarly deprived the boys of contact with myself, my sister, and her daughters, unless we agreed to give her the money in Eric's trust. Money that Eric wanted to go to his 3 children.
Oh, shit.
As if that were not...
Which would leave the kids with nothing. The trust is the only thing that Eric could do to protect those kids at this point. And I had forgotten she was weaponizing the, you can't see the kids, give me the money in the trust. This is after the lawsuit started.
real names, and even used their last family portrait. Her behavior gives me great concern, as she has exploited the boys for money and will likely do so again. In addition,
And this
Kouri
is
has
proper for bail.
weaponized Eric's children,
This is proper
manipulating
for
my
bail
dad to do
consideration.
or not do things by threatening to cut him out of their lives if he did not capitulate to her demands. She similarly deprived the boys of contact with myself, my sister, and her daughters, unless we agreed to give her the money in Eric's trust. Money that Eric wanted to go to his 3 children. As if that were not enough, I have been told that Kouri started telling their 3 little boys that none of Eric's family or friends loved them. She apparently told them none of us cared for them or wanted to be around them, even though that is the exact opposite of what was happening.
This is
We all
appropriate
want
for
nothing
bail.
more than to be there for those 3 little boys, my nephews. Yet Kouri has made sure to cut us out of every aspect of their lives. This is all just a brief summary and the start of what our family has been through over the last year. We have scarcely gone a day without finding out some new allegations or evidence regarding something Kouri appears to have maliciously done to attack and undermine my brother, his 3 little boys, and our family. We have all been there since the beginning of Kouri's and Eric's relationship. I was there on one of their first dates. We were there at the wedding. We were there when each of the boys were born. We have been there for every birthday party, school graduation, and rodeo. We welcomed her into our family and treated her as one of us. Not only did she betray our brother, it feels as though she has murdered and taken away a part of our souls as well. Because of her actions, there has not been a day that has gone by we have not lived with paralyzing anxiety and fear, worrying for the boys' lives as well as our own. I may be naive, but I never knew evil like this existed.
Wow.
I was in fact willing to kill Eric for money. Who's to say that what she will not do? Who would be next? Kouri was in a desperate financial situation when Eric was killed, and that situation seems even worse now. We understand that she has defaulted on loans and is already a defendant in other lawsuits based on her financial misdeeds.
True with
I am
banks.
truly concerned that she will stop at nothing to dig her way out of the problems, including murder. She seems devoid of moral sensibility, and there
This
is
is,
no telling what she will do if she is released.
Appropriate for a bail
Judge
hearing.
Mrazek,
Please don't let her
fate
out.
lies in your hands. Please do not allow Kouri to use the fraudulent life insurance proceeds to get out on bail. That would be morally reprehensible. Please do not allow Kouri to take advantage and make a mockery of our justice and legal system anymore. She has done enough. Please do not allow Kouri to hurt Eric's memory, our family, friends, and community anymore. We have been through enough. Please do not give Kouri the opportunity to hurt Eric's 3 boys anymore. They have lost enough and have been through enough. Since Eric's death, we have learned and unfortunately are continually reminded that Kouri is desperate, greedy, and extremely manipulative. Out on bail, I will be afraid not only for my own life and those of all of my family, but most for the lives of Eric's 3 sons. Has already suffered enough. Please do not let Kouri out on bail where she will be a risk to do further harm. Please protect what Eric put his life on the line for, his 3 boys. Thank you.
Amy, thank you.
Okay.
Ms. Cassell.
The statements at a bail hearing are different than what you will see at an impact statement after trial. But I think in this case, we are going to see some similarities. And I wouldn't be surprised if Amy made an impact statement and said, I stood here in 2023 and told you, and I now know. And you can never let her out of custody. Because now they've seen the walk the dog letter where she has threatened, both of them threatened Katie's children and more. I would not be surprised if there is more that they know. And so I think we will see more than we saw in this statement and more than we said in trial. And I think we will see it circle back. There were lots of things in that statement regarding bail that I had forgotten. This did not come in at trial, probably because, well, not probably, you are probably feeling some kind of way. You are completely valid. But the way you are feeling might make it hard to be more neutral and objective on the evidence. And a lot of what was said, a lot of the fuckery that Kouri was engaged in does not help the jury decide if she committed murder. It helps you decide if she's the fucking worst. And that's when that balance of more probative than prejudicial comes in. And some of this was determined to be more prejudicial than probative. The incident with Kouri attacking Amy over the safe was more prejudicial than probative. I think the judge has been incredibly cautious, sometimes maybe too cautious. I also think it puts a point on the fact that Kouri didn't know about who the executive see Amy making a statement about this at sentencing. So some of the things that we have seen here are things that will be appropriate impact statements. They were not things that were appropriate for sentencing. Chat, it looks like I have no idea. Sorry, y'all. I have no idea. I don't know if that was me, if that was YouTube. I do not know. I am so sorry. Either way, well, you're going to have to turn into the case briefs to see what I said during that glitch. I promise you it was astute and it was brilliant and it was unmissable. It will be in the case briefs. It might be my Wi-Fi because there's work being done on my house and I don't trust that it's not my Wi-Fi because people are on my roof. The roof is getting new gutters. So YouTube, just doing the things. Either way, this was appropriate for a bail statement, why they're concerned about her getting out. Some of it is too prejudicial for trial, and that's why we didn't hear about it at trial. I wanted to hear from Amy at trial, and the defense ran the risk of opening the door to some of this because the defense in their opening statement, and this is when my little ears perked up in opening, the defense promised that you would see that Kouri knew about the trust. And if they started trying to go down that road about, well, Kouri knew about the trust, Kouri knew about the trust, Kouri knew about the trust. If you know about the trust, you're not throat punching your sister-in-law and tackling her to the point that not only do 4 people have to pull you off of her, but the sheriffs have to come. And we saw Kouri's booking photo. Kouri does not seem to be a tall woman. She barely fits on the booking photo. She is petite. She is not tall. She and Banfield might be the same height, in fact. So needing 4 people to pull her off her sister-in-law indicates to me rage. Pure fucking rage. And the judge is going to be allowed to consider that when we get to sentencing, though it wasn't considered at trial. So, do I think we will see Amy making a statement as a, let me pull this back up. Do I think we'll see Amy making an impact statement at sentencing? Yes. I had completely forgotten about the charity volleyball tournament, or sorry, volleyball. Emily, you're such a Californian. I know, golf. I had forgotten about the golf that I'm sure that Kouri took the money from. I had forgotten that Kouri said in lieu of cards and flowers, send me money, and opened a new bank account. Probably. Speculation on my part. Probably so her creditors couldn't find it at that moment and take it because she was in a fucking financial spiral. Probably why the new bank account. And this is stuff that they were finding out from the PI as this was going. So I'm not surprised. They also had to go through, while this was going on, they were in now like a year into the lawsuit with regard to the trust. Kouri sued the trust sued Kouri. More has happened since then. We'll circle back to it. It's been stayed for a bit. We'll circle back to the trust. It will get unstayed. It's going to be a minute, but it is stayed for now. So we will circle back to what's going on with the trust, but the multiple lawsuits were going on with the trust. There was the assault case going on for the incident in March with the throat punching Amy. There was the beginning of the fraud investigation that wasn't filed yet. The attempted murder wasn't filed yet. So this was the beginning of everything spiraling. Yes, Kouri was charged in that. It was a misdemeanor. But Kouri, I have just mascara. Today's delightful. It's fine. It's a work call. But yes, Amy pressed charges. It resolved. It was a misdemeanor. But I think the defense risked, and this is why at trial I was like, ooh, you're saying Kouri knew about the trust. Because I think Kouri's behavior indicate that she did not, in fact, know. I think if it had gone further down the road with the defense on that, this could have come up. So, yeah. Will we be covering the civil case? Yeah, we'll get back. We've covered it. I've covered it. We'll get back to it. It's stayed. Will I cover the other financial criminal case? Yes. I hope there will be cameras in the courtroom. Lest we have to send our own cameras in the courtroom. Hell, I will go to Utah and sit with an iPhone and record it if need be. But yes, we will cover it. Oh, Judge M's not getting rid of us this easy, but it's going to take time. Nothing is going to happen relating to any of that until after sentencing. No, I'll go without the extreme zooms. But yeah, we'll be covering it. So we will make that happen. I want to know what happens. I talked about that at the beginning of stream, what I thought could happen. We're going to listen to the lawyers argue. I want to hear what Judge M says because I don't remember. Emily, that's not the reason. It is a work call. We need to hear what the judge rules. That is, we have to close the loop. Chat, we have to close the loop. We can't not let Judge M make his ruling. We got to let Judge M make his ruling. Emily, we know what he ruled. So not everyone does. 75% of you hadn't seen the bond hearing. I think this bond hearing is a very good example of why certain things are kept out at trial. Do you agree? Was this a good example of like why certain things are more prejudicial than probative? Kouri hosting a golf tournament and not letting the family come. Kouri putting money in lieu of flowers into her own new bank account. Kouri attacking her sister-in-law. Does that help a jury decide if she murdered Eric Richins? Not really. Does it explain who the fuck Kouri is in a way that you're just like, girl, there's rules against name calling, and I am trying to not do that through my hands or out loud. Right. And that is why when you look at what does more prejudicial than probative mean, it is this. This is the shit that is appalling, that makes you look at somebody and be like, what the fuck are you doing? I can't. But it doesn't help understand if she committed the murder. I think it is one of the most stark examples of that because there's shit you can't unhear. Same with the walk the dog letter. Her being like, let's go get those bitches. That makes a little bit more sense. But there's more in the unredacted walk the dog letter where you're just like, oh, fuck her. You want to leak your sister-in-law's children, your nieces and nephews? You want to leak them to the media to put pressure on your sister-in-law? No. Fuck that. That's not, no. Not that, no, that's gross. What are you doing? And those are where the judge has to decide if it's helpful or not. But I think the defense could have opened the door a little bit in that. And I think they were cautious not to, which is probably part of the reason that we didn't see the defense call witnesses, because there was a flood of information that could have come in if the defense had started opening those doors. And I think that they didn't. I think the defense was mindful about that. All right. Let's see what the judge ruled. I saw a few of you saying, now we need to read the walk the dog letter. We did, though. We did. I don't remember which day of trial it was, but one of the early days of trial, we were like, fuck it. Let's pull it up. Let's read the unredacted part. We did. We just did it recently. And then the original will be in the description. The first time we read the walk the dog letter, which is a lot of me going something like,
oh my God. Oh my God. Oh my God. Why would you write that in a letter? Like, it's a story. It's a novel. It is a book. It's a very important book. It's going to sell hundreds of thousands of copies. I'm going to be a New York Times bestselling author, and y'all just don't understand because there's idiots everywhere. Okay, I didn't say that part. I didn't know about the memes, but that's what the first one's like.
And chat, if you'll indulge me, Emily, why do you even ask? We're going to say yes. We're going to watch the judge's ruling. But I might have pulled up the filing where Kouri was talking about her lawyers, because we hadn't revisited it in a minute. We might just need to take a peek-see at that. Just a little peek. The mods are like, girl, we're not in trial. We're streaming for 5 hours. Yes. Yes. That's the bonus round. We'll get to the bonus round. Go like the video. How many likes do we have on the video? Go like the video. I'm just going to steal from Lawyer You Know. Go like the video and we'll do it in the bonus round. Let's see what the lawyers argue and what the judge has to say. We'll bonus round it.
Ms. Lazaro, is the defense calling any witnesses?
I am not. I guess what I'd like to do is just largely have the court review the briefing and the attached exhibits be submitted and considered as part of this, but I don't intend to put on any further evidence.
All right. Would you like an opportunity to make any closing argument for today, Ms. Lazaro?
Yes.
Why don't we have defense go first, and we'll just give the state the last word.
Thank you.
Okay.
I guess I'd start with whether or not the court has any specific issues they would like me to address.
No, I mean, candidly, there's a threshold legal issue here, right, that comes out of the briefing, and the state has been candid about the pending Barney case. I listened to the oral arguments. I think the state is wise to request a ruling in the alternative, but I'm persuaded by the defendant's position that as a matter of law.
Chat, the mods have it. Also, I've been insulted way worse. I did go to junior high in the 90s. So, the mods have it. Don't give people attention that they need. It's best to ignore. I know the replay crew is going to be like, shit, what did I miss in the chat? Idiots everywhere. I went to junior high in the 90s. Okay. I played men's water polo in high school. But sure. So continuing on. I know, chat's like, I missed it. The mods are too good. So's Nightbot. But also, YouTube's chat has been so weird that half the time chats are not going through because of YouTube's chat. So it's YouTube also has it handled. Sorry, it's okay, chat. We're paying attention to case. We're paying attention to the case. It does not matter, but it does kind of make me giggle when people want attention that badly. It's just, you know, boo-boo, if you just want attention, the law nerds are here to chat. You just have to be kind. The law nerds are a good group to be kind. But trolling's not going to get very far. Though I do appreciate the giggle because the tech has been stressing me out and that actually made me laugh. So appreciate it.
While a defendant charged with a capital felony supported by substantial evidence does not have a right.
The judge is laying the groundwork for what is required to be shown. Hi, George. For what's required to be shown. So the judge is reminding counsel where to focus their arguments and what the standard is. The standard is presumed no bail. And so with the presumed no bail, it's a difficult argument for the defense because the legal presumption is no bail.
As a matter of law, while a defendant charged with a capital felony supported by substantial evidence does not have a right, they can nonetheless request bail, and the district court retains discretion, at least under the current status of the Utah Code, to consider the request. So fast forward past that.
I will do so. And don't necessarily.
Judge M, can we zoom past all that? I'm well aware of what the law says.
Necessarily disagree with what may or may come out of that case that's up on appeal.
Right.
With regard to the sufficiency of the evidence, I mean, we're here because of a really tragic circumstance, and I don't think any of us want to forget that.
I mean,
especially
just
my
like
client. She loved her kids. She loved her husband. But she's also charged now with his murder. And so I just don't necessarily want that to get lost on the court, that we understand the gravity of the situation. With regard to the evidence, I'm going to skip through most of it. I think the most important thing, if she poisoned him, is did she ever get it from CL? Was it ever requested from CL? I don't think the state has been able to draw that nexus. I don't disagree that CL was buying drugs. I think that's clear.
I think that's clear.
She has a history of being a drug distributor. She was jammed with first-degree felonies. She had a potential federal case hanging over her. And, you know, then when they look at her phone, they find evidence of additional drug distribution.
Well,
with a new charge.
I mean, it wasn't just her phone. That was a rude pause. Sorry. It wasn't just Carmen's phone. It was also Kouri's phone.
Pursuant to essentially the detective's testimony, is they walked her down the line of, I need more evidence. This is what we need to know.
Are you saying that detectives walked the dog? Is that where Kouri got the idea from? Emily, we're just starting unfounded rumors. I mean...
No, and provided evidence to her essentially until she got it right. And then she was released. When we look at the cell phone mapping, yes, we know she went and picked up a check. We know that she was cleaning houses. We know she cashed a check. We know she picked up drugs.
I mean, but Your Honor, the checks could just be for the cleaning. It's fine.
They can't put her anywhere in the same vicinity of Kouri's phone.
Kouri's phone wasn't there. Kouri's phone was
because
wiped.
Apparently the mapping's not available from Verizon, which somewhat surprises me, given it's Verizon.
I think it's a length of time between the events and...
The location is not, the judge is right, the location is not available from Verizon for Kouri's phone because they did not request it soon enough.
The request.
Correct. But they have things about her buying and selling fentanyl. They have zero corroborating evidence for anything Kouri, for giving it to Kouri. She didn't tell anybody that she was buying it for Kouri. She never had anybody with her when she dropped it off. There's nothing to make the most important correlation in this, and that's that it was ever provided to Kouri that there was no fentanyl or traces of fentanyl found in the home anywhere. And I think that's significant. I think if she gotten
as O'Driscoll said, it was not in the home because it was in the victim.
30 pills on at least 2 separate occasions, that's a lot of fentanyl. I mean, if one's lethal, all right, we're talking about a lot of fentanyl, and nothing is found, no traces anywhere, absolutely nothing. So
it was found.
I think the state's making a big leap in their evidence by saying, look, we have this girl, we know she's a drug dealer, we know she's buying fentanyl, but there's nothing to corroborate anything she says that ties it to Kouri. The glass,
I mean,
Kouri tells them she made him a drink, right? The glass is there. No one thinks to bother to.
Where's the evidence that the glass is present?
Well, I didn't look for a glass, I guess is what I should say.
Okay.
So no glass was tested. So there's nothing to show that Kouri did anything to Eric. Detective O'Driscoll's testimony, it could have been accidental.
The feed stuttering is really frustrating. It is, this feed was like that this day, and there's nothing we can do.
Accidental. I mean, it very well could have. And I think that, given the evidence presented today, is a very plausible situation. With money does not make you a murderer. Being bad at managing your accounts makes you bad at math, but it doesn't make you a murderer. The other thing
bad
I
at
think that's
math.
significant is by the testimony that came out today, the hard money loans that she owed, at least, far exceeded life insurance policy. And so even getting the life insurance money was not going to solve Kouri's problems, not even close to solving her problems.
And I think that would have been a better argument for the defense. They didn't argue that much. They touched on it just a teeny little bit. The defense did not argue it much that, look, even the life insurance isn't pulling her out of the crater that she's in. She's better off. They tried to say Eric was worth more alive than dead, but I don't know if it's the strongest argument, but it would have at least narrowed it down to something.
And so
then again, if she's bad at math, she might not have appreciated that.
While, maybe there's some other issues with Kouri's business, there's nothing to tie it to her having any motive or in any way being in a better position from Eric's death. In fact, she's in a worse position because of his death, because Eric had a business. He was continually making money. He was, from what it sounds like, the majority of the contributions into the joint account. So his death, from a financial perspective, has harmed her far more than any money that she gained from any life insurance. That I'll largely submit on the remainder of our briefing, as I trust the court is.
I have, carefully. Thank you. Ms. Cassell.
And it's just, I trust the court to review the briefing. Different lead prosecutor on this motion.
With respect to the no corroborating evidence, there's a lot of corroborating evidence that corroborates CL's statements. And I think one of the things that we have
No.
is
Boy. Linear. We just need a linear argument. That's all.
She was primed and told what to say. But what really happened is she's a year later she's asked to consider what if she remembered anything else, and she came back with, yeah, I remember more, and that's very typical of witnesses. It's typical of people that we have testified. And then just you heard all of the corroborating evidence, Your Honor, the matching with the cell phone, with the mapping. Do we have CL putting the drug in Corey's hands? We do. We have a hand-to-hand that was testified to. So we have the evidence that Kouri got, or the defendant got the drugs. We also have the evidence that corroborates all or most of CL's story. We would have more if there weren't texts that were deleted. We would
have more if Kouri didn't wipe her phone, and Carmen also wiped her phone. Yes, you would, but they did. They wiped their phone. And I think that Koster-Demas did a good job of talking about that the cache on the phone can only hold so much. And so so much was deleted off of Kouri's phone, it overwrote and overwrote again.
A great deal of information that was deleted, and that was deleted off of the defendant's phone. So I think that is sufficient evidence just for CL, and that makes CL credible. The idea that no glass was tested, well, if you look at the pictures that we have submitted, there's nothing there. It's a stage scene. How they can argue that Eric somehow consumed this himself? There's no glass. There's no baggies. There's nothing that this was ever taken by Eric. And also to say it's accidental, 1 or 2 pills might be accidental. 20 or 5 times the lethal dose is not accidental, Your Honor. That is someone who wants Eric dead. And the person who benefited the most from Eric being dead is the defendant, or the person who thought she was going to benefit the most from Eric being the defendant. She thought she was going to be entitled to Eric's estate. She didn't know that there was this trust that had put the money into Kouri Richins' thought on the day that Eric died that she was the one that was going to benefit. She benefited from the insurance policies. She thought she was going to benefit from more, and she thought she was going to benefit from Eric's estate. She tried to benefit from the other.
She thought she was going to get to run his half of C&E without him telling her how to spend his money, because she told Katie at trial, and this is interesting because you can see it connect more after trial. You can connect the dots looking backwards. Can't really connect the dots looking forward. And we saw Katie say that day, Kouri was talking about who was going to run Eric's part of the business. So somehow Kouri believed that she was going to get half of C&E. So no, she didn't think she was better off with Eric making money. She thought she was going to be the other half of the business partner, pay someone, Grossman, maybe, less money to go do some of the physical work. She was going to run the business and take half of that business without the roadblock that was Eric determining how she was going to spend the money. She thought she was getting 50% of the business year over year over year without anyone telling her what to do based on what Katie said. But that's exactly why your partnership should have a buy-sell agreement, so you don't end up running a business with someone you don't want to be in business with. But Kouri didn't know. Scotty didn't know. Scotty didn't know. Scotty didn't know. Don't tell Scotty. Kouri didn't know. Kouri didn't know what was in the buy-sell agreement. She knew what was in the prenup. And in the prenup, it indicated that she got Eric's half of the... Of course, she didn't know about the buy-sell agreement. And in the prenup, it indicates that if Eric divorces her, she doesn't get anything from C&E. But if he dies, she gets Eric's interest in C&E. She just didn't know that Eric's interest in C&E was life insurance and not continuing to run the business in perpetuity, because she never saw the buy-sell agreement. She only saw the prenup. Right. She thought that she was just going to take half of that business year over year over year over year over year. And she was going to treat it like her own personal ATM without the pish posh of Eric. And then when you bring Josh Grossman into it, you've got someone who might be able to go out and do some of the physical labor. And she can do the administrative stuff. And that makes so much sense why she was telling Katie, I've got a plan to run the business. She was going to treat C&E like a fucking ATM. So when the defense gets up there and is like, no, Kouri's better off with Eric alive, she thought she was going to still get $300,000, $400,000, $500,000 a year without having to also have a spouse. And then you've got Kouri with her lender, who I still have questions about. You got Kouri texting her lender how inconvenient it is to be married. You get rid of the inconvenience of being married. She doesn't know that the buy-sell agreement means that if Eric dies, she gets yeeted out of the business. And she's only thinking about the premarital agreement that says if he dies, she gets his half. She thinks it's in perpetuity, not that she gets bought out. Right. It makes so much sense. That's why she was saying to Katie she already had a plan. Because she had no idea about the buy-sell agreement. Right. Because why would she know? But she went in and changed that life insurance but they had Emily, girl, they had multiple life insurance policies at that same company. She might not have known what those were for because there were multiple life insurance at the same company. It wasn't just the business life insurance that were there. Oh, that makes so much more sense. So why is she mad about the work truck? I very much wonder if after Eric's death, before Cody Wright, this is pure speculation on my part. I wonder if Kouri bought more from Carmen, either to keep Carmen on side and assure Carmen that, hey, look, that didn't go to Eric. That wasn't for Eric. That had nothing to do with it. Or if she put it in the work truck, in an allergy bottle. And that's why she was so mad that they didn't search it. And that's why she was so focused on the allergy bottle, the allergy bottle, the allergy bottle, the allergy bottle. Interesting. I wonder. It could have been to keep Carmen on side and to distance it from buying it from Eric, but where did it go? And why was she like, he said it was in an allergy bottle. He said it was in an allergy bottle in the work truck. He said it was it's in an allergy bottle in the work truck. The work truck. You never searched the work truck. Cody took the work truck. You never searched the work truck. Why the fuck are you so mad about the work truck? And that was the big work truck. I'm curious. Because if you're cleaning out a work truck, you're just throwing everything away, especially if you're grieving. I mean, I don't think anybody's putting fentanyl in their like massive work truck in an allergy bottle. Like, that's just dumb. Especially when there were other places in the house to put things. And there were still all the prescription stamped hydrocodone in a baggie somewhere else. So why would Eric be buying things off the street that could be dangerous when there's other bottles of hydrocodone in the house, an oxycodone in the house. Why would you even bother? Because there was stuff left over from Kouri's pregnancy. Oh boy. Well, this is why we sometimes look back at things in hindsight, because connecting the dots backwards is so much easier than connecting them forwards. And Katie testifying that she had a plan for the business only makes sense if she didn't understand or didn't know what the buy-sell agreement was. Yeah. She must have been really fucking pissed when she found out that she was getting life insurance and not an unlimited ATM machine. Because I wonder if she was sitting there thinking, great, how hard can it be? He just answers emails. How hard can it be? Grossman can go lift shit. And I can email. I mean, girl, I don't know about that. But how hard can it be? And I'll just run the other side of the business. And the money will just come in like it did for Eric. Hundreds of thousands every single year. Because they said she didn't know about the insurance policy. They said it in trial, Emily. Why are we just putting this together now? I don't know. But they said it in trial that she was surprised about the insurance from C&E. Hence the massive fucking freak out when she realized how badly she miscalculated. Because the day Eric died, she had a full fucking plan that she told Katie about. Katie testified to it. Then they have a full drink up on the 5th. And then the morning of the 6th, fuck. What are we doing? What do you mean Katie's in charge of the house? What do you mean I'm not running the business? What do you mean I only get life insurance? What do you mean I don't have an ATM that is this business that she has all the bank accounts for because she's using them to forge all the other shit for the life insurance policies? No, for the business loans. She sees that there's hundreds of thousands of dollars in the C&E bank account month over month because she's using those bank accounts to splice her bank records. So she sees $700,000, $800,000 in the C&E bank account that I don't doubt she wouldn't have tried to siphon it off. Oh boy. Well, I think we all understand why she was so mad, though. I mean, her friend Allie Staking says it was valid. Her plans were foiled. She did not have all the information she needed at the time. And I think that's because Eric wanted to make sure that she didn't. That makes a lot more sense. That Eric was not worth more to her alive than dead because he was a roadblock. And that's why she's saying Big Married's inconvenient. The money's not inconvenient, but she thought she was still going to have it. Huh. Interesting. I wonder if we're going to hear more about that assault in the impact statements in May. I'm so happy the date of that sentencing has worked out the way it has. I did not realize how much impact that would have for the family until rewatching this, which is sometimes why we have to look back, because this was years ago. Oh boy. Well, we can see why she was so pissed. All right, let's let this prosecutor. Sorry, ma'am, I didn't mean to interrupt. We had to. Why is Kouri so convinced that? Oh, Travis must be home. George has been in here silently all day, and now all the meowing. Hello, Trav. We're just finishing up. They are doing gutters today outside. That's what all of that is. How are you? Oh, George is like, do not talk. Pet me now. Do you see how happy? George wants to breathe Travis's air. He is just going to put his face in Travis's face. I know. I get confused. Hi, buddy. He was in here quite a bit this afternoon saying hi. Good to see you. George is just like, take me with you, human. Take me with you. Yeah, George wants to just climb in. When Travis gets home, George is like, pick me up and let me bump into your face. Let me be with my human. He's so happy. He's the happiest cat. And he meows until Travis picks him up. He jumps up on the footstool on the ottoman and then meows and meows and meows until Travis picks him up. And then is like, hello, my human. All right, let's let this prosecutor finish. But we now have kind of figured out why the defense's argument of, but Eric was worth more to Kouri alive than dead, doesn't make a ton of sense. Because she thought that every month she was getting half of that company paycheck for life. Wow. Well, let's let the prosecutor finish arguing and let Judge M rule, and then we'll go take a look at some of the things Kouri called Sky in the motion that we're going to bring up.
Life insurance policy on Eric's
and then we'll be done.
Business didn't happen. She also was in dire financial straits, Your Honor, writing checks on closed accounts or checks with no money in them. I know you cut me off.
It was in your brief. I got it.
I thank you.
The judge is like, I can read,
but,
thanks.
That's significant because she was in dire financial straits. She was deep in debt, and the way to get out of that debt was to kill Eric Richins. She benefited financially, and she had many cases, and we talk about this all the time. Prosecutors say we don't need motive. This case has motive. This case has motive that she needed to get out of this debt, and that's the reason she killed Eric, in hopes of getting his estate, in hopes of getting his life insurance policy.
Business.
And that, Your Honor, we believe is substantial evidence.
I think she thought she was getting I think she thought she was getting half of that business. Yeah. All right. Extreme Judge M close up. Hello, Your Honor. Extreme Judge M. I appreciate that he rules from the bench.
The issue before the court is whether defendant Kouri Richins should continue to be held without bail during the pretrial period. Defendant is charged, among other crimes, with aggravated murder under Utah Code 76-5202.
This murder has aggravated us too, Your Honor.
To convict defendant of this charge, must prove beyond a reasonable doubt at trial. Defendant intentionally or knowingly caused the death of another individual under any one of the following circumstances: for pecuniary gain, or by means of the administration of a poison or of any lethal substance. Under Article 1, Section 8 of the Utah Constitution, a defendant charged with a capital offense has no right to bail if there is evidence to support the capital charge. And under Utah Code 7720-201 sub 3, a charge of aggravated murder is considered a capital felony for the purposes of determining bail during the period before the state makes an file a notice of intent to seek the death penalty. Accordingly, at this time, the aggravated murder charge in this case is considered a capital felony. Moving to the substantial evidence inquiry, consider the evidence offered by the parties, both through live testimony today and by documents attached to their briefs, which the court has reviewed at length. And having had the opportunity to weigh the credibility of that evidence, the court determines the state's evidence, notwithstanding contradictory evidence.
I mean, this feed is so rude. It got better for trial, thank God, but this feed is just glitching on our honor, our Judge M. It's so rude.
A reasonable jury reaching a guilty verdict on the charge of aggravated murder. Indeed, a jury could reasonably choose to rely on the state's evidence regarding means in motive, and consciousness of guilt, which includes evidence showing that Eric Richins died of fentanyl ingestion, that he was not known to be a user of illicit drugs other than the occasional, that defendant purchased.
Even though it glitched, we can fill in the blanks. We know the weed gummies. We know. Good Lord. I have never, look, the amount of weed gummies, and then it just disappeared. It was like the defense went, weed gummies, weed gummies. Empty bottle. Just totally shifted.
15 to 30 fentanyl pills from CL approximately 1 month prior to Eric Richins' death.
And the judge is basing this on what could a jury find? What could a reasonable jury find from the information we have today? And so that's what he's going through. This is before the fraud is charged. This is before the attempted murder is charged. This is at the very, very, very beginning of the case.
Cell phone mapping confirms, or at least indicates to a reasonable jury, that CL's phone was near the Maverick and Draper on February 11th, and that while there, CL's phone made calls to acquaintances, capital A acquaintances as listed in the testimony and the information, and sent texts to defendant Kouri Richins, and that CL's phone then traveled to Francis and then was in Francis and then returned to Heber. CL's sworn testimony that she handed the fentanyl that she acquired to Kouri Richins in a hand-to-hand transaction in her driveway. We also have motive. At the time of Eric's death, defendant knew how the premarital agreement would operate, but was not aware that Eric had changed his estate plan. So at the time of Eric's death, defendant's subjective understanding was that she would get a greater share of the marital estate if Eric died during the marriage, as opposed to what she would receive under the premarital agreement if the parties divorced.
Yep.
Moreover,
that was all in the briefing.
Evidence admitted in the case shows that in the months leading to Eric's death, defendant's personal and business accounts were overdrawn. She was making significant recurring debt payments, many of which were to hard money lenders, and that her lines of credit or lines of credit available to her were maxed out. And at the time of his death, Eric's life was insured for approximately $1.2 million, not including the policy related to the buy-sell agreement, with defendant listed as the beneficiary. Moreover, we have evidence from which a jury could reasonably infer consciousness of guilt.
Yep.
We have evidence regarding...
This is before the walk the dog letter. Listen to what he's talking about with consciousness of guilt before we even get to the rest of it.
Regarding the search that was extracted from defendant's second phone after her first phone was seized. And then we have inconsistencies made by defendant as compared to other evidence in the case regarding whether she called 911 immediately, whether she performed CPR.
Phone searches, CPR, that 15-minute gap. Very Banfield. Emily Banfield catching all the strays. Yeah. Forever at this point. I don't think they know about Josh Grossman yet at all, based on Grossman's testimony. Grossman went to the family after he saw that Kouri was arrested. We don't know how close in time based on his testimony, but if they know about Grossman, they don't have all of that put together yet because it didn't come in here at all. And it was after he heard that she had been arrested, after he heard about the book, that he came forward to the family to say, I need you to know what I know. Because And then he had a conversation. My best memory from the testimony is then he had a conversation with Gabler and then I think law enforcement, but he reached out to Eric Richins' family first, which was really interesting when he testified. I think that came out on cross and I was like, that's interesting.
Whether she did something else for the 15.
So the court's talking about the consciousness of guilt before we got to trial.
We have evidence regarding the search that was extracted from defendant's second phone after her first phone was seized. And then we have inconsistencies made by defendant as compared to other evidence in the case regarding whether she called 911 immediately, whether she performed CPR, whether she did something else for the 15 minutes between.
Like wash the dishes and get rid of all the trash? Because the only thing in the trash was the cock and bull, Your Honor? Like that? Are we talking about like that?
Between discovering Eric dead and calling 911. In considering this evidence, a jury could reasonably choose to discount and find unpersuasive defendant's efforts to poke holes in the state's case. And in so doing, a reasonable jury could reach a verdict of guilty beyond a reasonable doubt on the charge of aggravated murder based on the state's evidence. For these reasons, there is substantial evidence to support the capital felony charge of aggravated murder against the defendant in this case. Having made that determination, the court considers whether it has discretion to grant defendant bail, notwithstanding that she has no right to bail under Article 1, Section 8 of the Utah Constitution. And having considered the arguments and authorities cited in the parties' briefing, the court determines as a matter of law that in the case of a capital felony that is supported by substantial evidence, while a defendant does not have a right to bail, the defendant may nonetheless still request bail. And the district court has discretion to grant bail if the circumstances warrant doing so.
And denied.
But the circumstances of this case weigh soundly against granting pretrial release of any kind. First, defendant is charged.
That's not you, that's not me, that's the feed. No wonder Judge M was mad at the media. It kept glitching.
Death penalty and no less severe than an indeterminate prison term of 25 years to life.
So she is facing no less than 25 years to life. I had forgotten this part too, but there it is.
Of those sanctions, the severity of the sanction conviction for aggravated murder creates a powerful incentive for a defendant to resort to desperate acts that might include harming themselves, harming the members of their family, or harming witnesses in the case.
Yep.
Because an incentive this powerful cannot be adequately managed in the community, it weighs heavily against granting any form of pretrial release. Second, the state has offered substantial evidence that defendant procured fentanyl on more than one occasion, and on at least one occasion deployed that fentanyl to cause the death of another person. As a general matter, an individual who is capable of this kind of decision-making is not a good candidate for supervision in the community. More specifically, given the uniquely dangerous nature of fentanyl, which has been demonstrated tragically by events in Summit County, defendant's alleged conduct, as supported by substantial evidence, is especially dangerous. Indeed, these circumstances constitute clear and convincing evidence that defendant would pose a substantial danger to the community if released on bail, a substantial danger that cannot be adequately managed by any combination of conditions of pretrial release that are available in Summit County. For these reasons, the court finds the circumstances of this case as supported by substantial evidence, weigh soundly against any form of pretrial release. The state's motion for detention is granted. Defendant Kouri Richins shall continue to be detained without during the time she awaits trial or other resolution of the criminal charges against her. Ms. Richins, you have the right to an expedited appeal of the...
You have the right to an expedited appeal. Good luck. Not going to work. Didn't work. They tried it again. Not going to work. Jody, this is a great question. Jody said, okay, so she at least gets 25 years. She at least gets 25 years to life. So it's an indeterminate. 25 years is the minimum. 25 years period's the minimum to life. So that's indeterminate or life without parole. That's what she's looking at on count 1. So yes. Peapot Fairy said, could Judge M sentence above the minimum, like 40 to life? Not to the best of my understanding, based on the research I have done in Utah, not without the other cases. So he could sentence the first degree aggravated murder, then the attempted murder. Those are different dates, so those can go concurrent. There is a sentencing aggravator. I do not know if it is a term of years or a factor towards LWOP for them being in a domestic partnership and cohabitating. So that amount of years, if it's an amount of years, can get added together. Then the financial fraud cases can get added. So if he wanted to do 25 to life, he could do 25 to life plus the amount of years on the attempt, plus any sentencing aggravators, plus the fraud count, plus the other fraud count, plus the forgery count, and add them all up consecutive. But he can't just be like, 25 does not seem enough. I give you 60. That he cannot do. But he can add those things consecutive, or he can do count 1, life without parole. Done. Kate Rose said, why did I think it was an automatic LWOP like Donna? Because I thought the exact same thing, and I said it more than once. I was incorrect. So probably because I said it and I was wrong. Because I thought it was an automatic LWOP. And then I was like, oh, no. It was pointed out to me that I was incorrect. And I was like, oh, it should be. In my brain, if it is a DP eligible case and the state does not seek DP, my brain defaults to, oh, then it's LWOP. That is not true in every jurisdiction. And I forget that frequently. I also forgot that in Florida, a second was LWOP. So, yep. And I thought I was going to look at it freshly while the jury was deliberating, and then they didn't deliberate longer than me walking out of the room and then coming back in. So that's where we are.
You must file a notice of appeal within 30 days of the court's ruling, and you have the right to be represented by counsel on that appeal. Let's pause there for a moment. Ms. Gusell, any questions?
No, Your Honor. Thank you.
Ms. Lozara,
No, Your Honor, thank you.
where do we go from?
The law nerds would like you to start reading audiobooks if you're asking for any career input, Your Honor, though I think you are a very astute bench officer. You have protected the record for appeal very well. Sometimes I think you were too patient with the defense, but then you did tell them to sit down, and that was money. But where do we go from here? Sentencing. We go to sentencing.
Are you prepared to set a preliminary?
I don't think so, because I think just based on the state's briefing and evidence provided, there's a lot of stuff that
That's a prior mug, different mug. We've gone through like 4 different mugs in this case with Judge M.
don't have yet, and probably need experts to look at, especially with regard to the phones.
Okay. What is a reasonable time to set a scheduling conference, understanding that I'm going to push counsel to move this case as fast as possible, given that Ms. Richins is in custody?
Are we back to gentle pressure, Your Honor? Thomas asked, does Dr. B know about Judge M? I will tell you about that after we finish this hearing. I have a story for you.
I understand that and appreciate it. I guess that question should be posed to the state.
Can we just take a moment to appreciate Mr. Kostradimus's socks in court? Hold on, I got distracted. Emily, really? Well, Scotty with the magic mustache is not in court, but the socks are great. They're like purple stripy. I dig it.
As fast as possible.
The socks are fire, Mr. Kostradimus.
I understand
I like
that
it.
and appreciate it. I guess that question should be posed to the state as to when they think they can get me things. Like, I can't prepare without the evidence.
Your Honor, it was his 50th birthday. I can't do my assignment if they don't do theirs. I know, it all just comes back to clueless, truly. But she's not wrong. Like, Your Honor, I can't tell you if I'm ready for the prelim until I have all the evidence. She's not wrong.
I'm at their mercy at this point.
Can we check in on the 26th? Whether you think you've received everything?
I will, yes.
Do you want to do it in the morning or the afternoon?
Let me look.
All right. This is just about the end of this hearing. I'm going to let the court wrap it up.
Third, Your Honor.
Because lawyer scheduling still gives me anxiety. The amount of time,
June 23,
the amount of
Mrs.
time I spent trying to set dates.
I'm out of town as long as I can.
She's like, can we WebEx?
We do it
Corey's like, I don't need to check my schedule. I'm going to be sitting in jail.
the 30th instead then, so I
We
can.
can't. I'll be out of town. You want to go to the 7th?
Mm-hmm. Emily, how much of lawyering is just everybody trying to pick dates with yes?
I can't cancel the 23rd.
We can also special set it.
I'm sorry. What else do you have?
No, it's fine.
What else do you have?
That's fine.
I just wanted the court to wrap up the hearing
Courtroom B.
and make whatever
Thank you.
say whatever he was going to say.
And we're going to do it in stages. I appreciate your patience. Just listen to the deputies. Everybody in front of the bar, sit tight. The deputies
Oh, he's talking about how he's dismissing everyone from court. A very busy courtroom.
are going to clear the gallery one section at a time first. Please just sit quietly and let them do their job. Thank you.
Your Honor, do you mind if Ms. Crossland goes with the...
That's thank you. Otherwise, the court is in recess. I appreciate your patience this morning. Ms. Richins, I wish you the best of luck on 22nd. Thank you.
He said that almost every hearing. I wish you the best of luck. I will see you on whatever date. Every single hearing. I imagine he does that with every single case, with every single defendant. I wish you the best of luck. I will see you on this date. However, it's not necessarily going to stop him from dropping the hammer at sentencing. Law nerds, we have had a very busy day. However, I was able to find the filing that I was talking about with Sky. Love Shell said, Emily, is Sky representing Kouri in any of the civil cases? No. Once there's a conflict, the conflict goes to Kouri, so it covers all of the stuff. So no, she is not representing Kouri in any of the cases. So nope, nope, none of it. He is a thoughtful judge. She was not happy when he was reading guilty verdicts, though. I can understand why. However, not happy. The quick story about Dr. B. I have told Dr. B about this case probably since this hearing, I would imagine, because I'm like, you're not going to believe this with the children's book and the Moscow Mule and the we have copper mugs. We love a Moscow Mule up in here. It might not look at them the same way, but we love a Moscow Mule up in here. So we'll just make them together. I'm teasing. I make them better. So, not to be competitive, but we were talking about this case and I was like, you're never going to believe this, judge. And then we were driving while I was listening to one of the hearings. I think we were headed to Chattanooga for football. But I had told Dr. B multiple times, and I was like, hey, this hearing is going to creep into the time we need to be in the car. So we're just going to listen to the hearing while we're driving, if that's good. Brian's like, sure, good. Griffin's like, whatever. Travis was on the band bus. Griffin's like, it's fine. And so as we're driving and the hearing begins, as we're on, the speakerphone in the car or through the car, Dr. B's like, oh, this is the judge with the voice. I was like, mm-hmm. He's like, oh, I understand. I was like, this was this year, at the end of football season. This was what, November? November of 2025. And Dr. B was just like, oh. When I say Dr. B doesn't watch stream, I mean that Dr. B does not watch stream. Dr. B is like, what'd you talk about today? Can I get the TLDR? Right. So everyone that works with Dr. B, you can tease him about that. But yeah, he has no idea what we talk about on stream. He's going to hear about it today, though, with all the noise. Oh, he's going to hear about the noise. Red Rocker brought up a great point. Cameras in the house. We should show where she was before he died. I don't think that any video was recovered from inside the house. They did not recover Kouri's phone until April. I don't think there was anything left to recover by April. And I don't think they could have grabbed it before they got the autopsy reports back, because with the autopsy report, with the EMS, were just like, it could be an aneurysm. I mean, it could be a heart attack. We don't know. And there was nothing in the house to indicate a drug overdose until all the labs came back. Labs can take 90 days. So they didn't have her phone until April. All of that would have been gone. So yeet. I mean, she yeeted things pretty successfully. I mean, at this point, I think that Brian Higgins and Proctor should be a little bit embarrassed that Kouri, luxury prisons for rich people, figured out how to wipe her phone better. Well, I guess Higgins was fairly successful in wiping his phone, but got clocked for it. She wiped her phone fairly successfully. Well more so than Proctor. I don't advocate for wiping the phone, but well and done truly better than Proctor. Proctor's like, oh, there's nothing there. Oh, incorrect. There's plenty there. So we will get back to questions. But we are going to look at this old filing. Emily, why are we looking at an old filing? Because it talks about the jail calls. This was still filed by Sky Lazaro and Kouri's attorneys. They were trying to yeet the entire Summit County Prosecutor's Office off the case. This was filed in May 2024. So almost a little more than a year after Kouri's arrest, after the walk the dog letter, after the rest of it. They were alleging prosecutorial misconduct. I should just swoop while we talk about this, because we're going back in time. We might as well go all the way back in time for the schadenfreude of it all. They were alleging prosecutorial misconduct. The defense was alleging that the prosecution was listening to attorney-client privileged calls from the jail. The prosecution responded and said, hey, other attorney refuses to use the attorney home wave. So when we start listening to the jail calls, we don't know it's the lawyer because the lawyer's not calling on the lawyer line. There's a lawyer line for a reason. And if the lawyer won't call on the lawyer line, there isn't shit we can do about it until we hear that it's the lawyer, and then we stop listening. But all the jail calls were going into the box or the Dropbox or whatever the program they use to share things. And the defense had those calls in there. And the prosecution's like, no, once we realize it's the lawyer, we stop listening. I think there's a solid argument that the lawyer calling on the non-lawyer line potentially waives an issue of privilege, potato. It is a legal issue that did not get thoroughly vetted. But there's a lawyer line, and the lawyer wasn't calling on the lawyer line. So they wanted the entire prosecutor's office removed from the case. So this is email attachments back and forth between the prosecutors and the defense attorneys talking about this issue back in May 2024. So we're going to take a look at that now because I'm amused. And chat was like, yes, let's. And it's well been buried in the pretrial motions. But again, lawyers use the lawyer line. But apparently lawyer didn't want to use the lawyer line because didn't want to put the HomeWave app on their phone or something, to the best of my memory. This is the defense filing to yeet the prosecution. Relevant factual background. On December 11th, 2023, defense counsel emailed Summit County Attorney's Office the following, notifying them that she discovered Kouri's jail phone calls to defense counsel had been produced in discovery. On December 11th, 2023 at 2:49 p.m., Jamie Thomas wrote, Summit County team, I discovered this morning while reviewing discovery on Box that the jail has been listening to and recording Kouri's jail calls to Ramsey and that they are produced on Box. Did you know that this has been happening? Ramsey is clearly an attorney of record in the criminal case and the DCFS case, so I am concerned. Yes, there was an ongoing DCFS case before the children got placed with Eric's family. In the series of responses that followed, Summit County Attorney Bloodworth, who is now lead counsel in the case, stated, quote, Ramsey refuses to register for and use the HomeWave app that shields attorney-client calls. His calls are, therefore, recorded as any other call. Correct. See, there's a process, and if you don't follow the process, then they just all get recorded. Mr. Bloodworth goes on to state that the prosecution has been listening to at least a portion of the calls between Kouri and defense counsel since May 2023, and the entire prosecution team had been in possession of the calls for the entire period of May 2023. That's not exactly what he says. He further took the position that because defense counsel had not downloaded the HomeWave app, it seems that Ramsey consented to the state maintaining the recordings. I don't disagree with that argument. There's a way to call in, and if you don't call in, it's going to be on the recorded line. I don't think they capitalized on that. They said they stopped listening once they realized it was the attorney, but then they argued the other side. It seems that Ramsey consented to the state maintaining the recordings. It says this is a recorded call. Defense counsel responded whether or not Ramsey uses the HomeWave app, attorney-client privilege calls are in the possession of the prosecution team, which is the concern. Okay, then use the app. This call is being recorded. So counsel gets big mad. Counsel's still mad about the walk the dog letter. On March 26, 2024, defense counsel visited Kouri in the Summit County Jail. She notified Sergeant Thomas that she would need a paper pass as the defendant had notes relevant to the defense. Sergeant Thomas is the same Summit County Sheriff's officer that conducted multiple searches of defendant and her cell and improperly seized the walk the dog letter, read it, and turned it over to the Summit County Attorney's Office. The judge did not find that that was improperly seized. Sky says that the walk the dog letter was attorney-client privilege. This is before they started arguing that it was a novel or after. I don't quite remember the timing, but first it was a novel, then it was privileged, or vice versa. Either way. They are talking about the jail and they are talking about the calls. They go into the legal argument. The court denied all of this, obviously, but the emails are what I wanted to go through because they're funny. Emily, really? Yes. Yes. This is from Wednesday, May 15th, 2024, from Bloodworth to Jamie Thomas, CCing fucking everybody. Good morning, Jamie. Since May, Ramsey has deliberately refused to use the HomeWave app. According to Kouri, Ramsey thinks the app somehow bugs his phone. According to Kouri, Emily, how does the prosecution know that this is according to Kouri? Because it's in the calls. Probably when Kouri's talking to other people about her lawyer. So Bloodworth is emailing the defense team, telling them this is what Kouri is saying. Kouri is saying that he refuses to download the HomeWave app. Also, get a work phone. Just get a second phone. Get like a work cell phone. I guess even if your work cell phone's bugged, it would be concerning. Get a burner. Get a burner to just call the jail then. Either way. According to Kouri, Ramsey thinks the app somehow bugs his phone. Also, according to Kouri, could you imagine the lawsuit if you were bugging defense attorneys' phones? Could you imagine the money? Either way. Also, according to Kouri, Ramsey knows that in refusing to use the app, the state maintains the recordings of their calls. Accordingly, it seems that Ramsey consented to the state maintaining the recordings. Moreover, the state has transparently been providing these recordings in discovery for nearly 6 months. The defense has not raised any concerns during this time. Therefore, it seems that the defense has ratified the state's approach and waived any current concern. Again, the state has not listened to these recordings and prefers that Ramsey use the fucking HomeWave app. I inserted the flourish. It is unclear why the defense is suddenly concerned. Emily, when did you become a fan of Attorney Bloodworth? It might have been in this very communication sequence because the writing has always been sassy, but these emails brought all of the sassy. So then what happens? Below are the call details and the upshot of the calls I was referring to when I said Ramsey was aware that Kouri wanted to replace Skye as lead counsel. We're available to discuss this today if interested. Regards, Brad. November 18th, 2023, voice call with Renee at 12:23. Kouri did not like Ramsey at first, but now he is her favorite on the team. Ramsey wrote 90% of the filings. January 19th, 2023, voice call with Ronnie at 12:12. Kouri is done being here. Skye needs to get her the fuck out of here. Kouri considering firing Skye and putting Ramsey in charge. Emily, did all of this need to be included in the emails? I mean, yeah. Why not? People don't believe it when they say these are recorded calls. They're recorded and everyone will listen to them. And occasionally you'll lean out your door. You guys, you're not going to believe this shit. Come here. You're not going to believe what's on this call. You guys. Who's got the butter? Bring snacks. Yeah, no, my office. 5? Great. I'm going to the bathroom. See you in 5. No, you're going to, yes. You guys, we need to just bring a chair. Emily, that's so messy of the lawyers. Look, man, it's a hard job, but sometimes the jail calls are giving. Sometimes the jail calls are interconnected with other people's cases because they're all in custody at the same time. Either way, this one, they're diming out the fucking attorneys. January 20th, 2023. Video call visit with Lisa, 8:51. Recap of call with Skye. Family except DJ, done with Skye. Video call visit with Lisa, 9:01. Continuation of above. Lisa complains that Skye has no trial experience, discusses putting Jamie in charge. They are mouthing words so that we can't hear. Skye can't present at trial. She, quote unquote, doesn't have it. Skye's ego is taking over. The writing is on the wall. All the legal analysts are saying the same thing about Skye as Lisa and Ronnie. Video call visit with Lisa, 9:36. Continuation of above. Kouri particularly angry. Kouri referred to Skye as a dumb bitch. Lisa Zillowed Skye's house to see its value, more mouthing and whispering to avoid being heard. Emily, Skye had a conflict? Skye said it was a legal conflict, y'all. She said it was a legal conflict. I believe it. That's what she said. 11:24:23, voice call with Ronnie at 6:41. Kouri upset that Sky did not visit and not answering her calls. Ronnie advising Kouri to dump Sky. Kouri says if she does not hear from Sky over the weekend, she is moving on to Plan B on Monday. She should have written some letters to the court, like Sarah Boone. 11:27:23, video call visit with Lisa, 9:01, discussion regarding replacing Sky with Ramsey or Jamie. Voice call with Renee at 12:47. Kouri spoke with Ramsey about replacing Sky. Ramsey did not want to discuss on phone. He will visit Thursday because Ramsey know this shit's being recorded. Video call with Lisa at 4:21. This is all still on like Thanksgiving week. Video call with Lisa at 4:21. Ramsey taken off guard when Kouri said she wanted to have someone else at RQN take the lead. Voice call with Ronnie at 5:34. Kouri informs Ronnie that she informed Ramsey that she wants to replace Sky as lead. Brad Bloodworth. Responding to this email from December 11th at 5:38 p.m. Whether or not Ramsey uses the HomeWave app, attorney-client privilege calls are in the possession of the prosecution team, which is a concern. Also, in prior call, you mentioned Ramsey was aware of Kouri wanting to change lead attorneys. Can you direct us to which call you are referring to? Thanks. Jamie. And then this continues to be the same email thread, but yeah. Can you refer us to which calls? Oh, yes. Let's discuss which calls. Here you go. Here's a sampling. Would you like more? You can go listen to your client call you everything but a child of God on your own time. Here are the days. I'm sure there's more. This was after the walk the dog letter, before the conflict. But look, there was a legal conflict. Attorneys are used to their clients being upset. Kouri has decided that the way she views karma and the way it is acting in her life are two different things. So Kouri was upset. She wanted Sky out, and she got what she wanted. I wonder what all the legal commentators are saying about her defense attorneys now. Oh, wait, I think I'm aware. I've probably been one of the kinder ones, because I try to maintain my own rules about name calling. However, when I said that Kouri was monitoring what was going on in this case, not only through her own ability to watch things on the internet, I'm sure her family also is in sharing that information. They wanted to know what people were saying about this case from the beginning. I'm sure she's still mad this case didn't get as much attention as Karen Reed. I can only imagine. I can only imagine what she has said about it. I actually can after listening to enough jail calls. But when we talk about like the bond hearing, a number of you commented, oh, I think Kouri was told to like fix her face in trial. I don't think Kouri was told to fix her face. I think Kouri was alerted to what the internet was saying about her and tried to shift how she would be perceived and to lean into, I'm just a baby. I'm not making mad faces. I'm just a girl. I'm a small girl. Like, I think that was based on how she was watching other people perceive her. I don't think her lawyers told her. I'm sure they said no outbursts in court, but I don't think they had to tell her. I think she was very dialed in through all of the conversations she was having with how she was being perceived. And I think that matters very much to her. And we saw that in the prosecution's case in chief. I think we've seen that in the communications we've seen from Kouri throughout this case. And that tracks with what we've seen of Kouri, because that tracks. It tracks. Big fan of Justice 42 said, EDB, please tell Mr. Koster-Demas. Please tell again how Mr. Koster-Demas likes us. He likes the Law Nerds. He talked about what a nice community it was. We will talk about who we will have conversations with. Again, it is my comfort level to wait till after sentencing, because I think any conversations prior to sentencing, I just don't want to create problems. I very much don't want to create problems. And I think the defense will find problems even where there aren't any. And we are patient law nerds. We can wait. Also, time is a construct. And by the time May gets here, we're going to be like, oh, good, here we are. It's May. We can have these conversations, which I think is good. Let's see. Auntie Lime said, nobody panics when things go according to plan. The Joker. True. It's true. I use the analogy that everybody has a plan until they get punched in the face, but I played water polo in college. So everybody has a plan until they get punched in the face. And then things kind of go sideways. Paralegal Mandy said, EDB going to hype her internet besties up today. Sing it with me. Hype your bestie up. I should have read this much earlier in the day, because today the noise has sent EDB sideways. Thank you, Lizzie. Courtney, thank you. I put my Law Nerd pins on my lanyard. It's like Disney around here. Let's fly. I love it. I love it. I love it. Cut and Run said, I'm going to Nashville in a few weeks. What should I go and see? It depends on the type of Nashville experience you want to have. I think the Parthenon is very cool. If you are interested in the Parthenon, they have a 40-foot Athena at the Parthenon. Centennial Park is beautiful. Great to play Pokemon Go. If you want to go to a concert, see what is happening at Bridgestone. I love the Ryman. If there is anything you want to see at the Ryman, go to the Ryman. But there are many other smaller concert venues around Nashville. Go find live music. The massive bar scene on Broadway is a little sensory overload for me, especially because a lot of them will either have a band on one floor and then a DJ, or like a band and a band. And that's a lot for me. If I'm going to go see music, I want to see music. If I'm going out to like eat and drink, I want to talk. You're shocked, I know. I want to do the talky things. I very much like I think it's 1230 Supper Club. I'm trying to think of things that are downtown. I love karaoke at Cross-Eyed Critters. It is in the Graduate Hotel. It is fantastic. The bar upstairs, White Limousine, is great. Sometimes you need reservations depending on the day of the week, but it is great to like have a drink and depending on the weather, sit outside. Love it. The Graduate Hotel is a total vibe. Cross-Eyed Critters karaoke is so much fun. It's just so much fun. The karaoke hosts are great. The bartenders are great. Love, 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 love. One of my favorite places. For a like sit down farm to table type of a meal, Adele's is delightful. There are many other places, but it is right downtown, which makes it really easy. Anything at Bridgestone is going to be fun. I really like Bridgestone. What else? Chat has some other suggestions as well for Nashville. So go look. The Parthenon's closed for repairs. Oh no. Rude. Okay, well, Centennial Park is still lovely. There is a board game cafe that also has like great food, boozy coffee, or just boozy drinks. And you can play any of the board games they have there. Bongo East, I believe is the name. It is so much fun. It's over in East Nashville near I Dream of Weenie. Yes, it is a hot dog stand, but they are the best fucking hot dogs you will ever find. So if that is your vibe, I Dream of Weenie is delicious. And you can get, like a mac and cheese covered hot dog. So much fun. And the board game cafe, they have it almost arranged like a library. So the way that they organize the games are how many players, how long the game takes, how much knowledge you need of the game to sit down and play. And you can just grab a game off the shelves and sit down and play. So much fun. So much fun. And yes, I Dream of Weenie is delicious and hilarious. It is always a vibe. So it just depends on the vibe of Nashville you are looking for. But as for the big bars, it is hard for me. However, 2nd Street does have a Taco Bell cantina, and it always has live music. And they will give you Taco Bell because it's Taco Bell, but also put booze in your slushie if you were looking for a drinking type experience. And it's fantastic, and I love it. I also love the food hall on Broadway because you can just walk around the food hall and sample food from all different places. They also have a cotton candy that does like cotton candy on top of shave ice. Emily, the desserts, it's so good. But a lot of the foods you can find in Nashville are in the food hall, and they have live music in there too. Really fun. And then you can just kind of cruise around. Food hall's great. So those are some of the downtown things. Love the Frothy Monkey. Warren will tell you that you have to get the Frothy Monkey latte with banana. It is his favorite. There are a few others that are my favorite, but it just depends. So love. Trisha Lynn, it is when I see a Taco Bell cantina, I'm like, I am doing this. It's so good. It's so good. So good. Is Dr. B still sneaking into your Audible by accident? Well, Dr. B thought that the book about Hercules was actually historical and then didn't understand why it had a trigger warning. So that's in the family Audible. He has access to the second Audible. But he is now invested in the Blood of Hercules series. So Dr. B found that one on his own. He's like, I don't understand why it was giving me warnings. I've never had a book give me warnings before. I'm like, what did you find? He was like, it's just this book about Hercules. I'm like, show me the warnings and show me the cover. I'm like, oh, buddy. There might be history involved. There will be other things involved. Enjoy. Have fun. He had no idea. He really was thinking like Percy Jackson vibes, not spicy vibes. Yep. So it came up in his recommended. He was like, this is going to be great. Why are there warnings? I was like, oh, sweetie, what do you mean? And then he was like, actually, I really enjoy this. Yes, Dr. B. Yes. Welcome, Dr. B. Though the other night, half a chat will get this, half a chat will have no idea. The other night after we finished trial, very tired, obviously. You could see me buffering by the end of Monday. And I'm like, Dr. B, thank you for making dinner. What's for dinner? He's like, so orzo with, and I was just like, what did you say? And he's like, orzo. He's like, it's just and I'm like, I know what I know what orzo is. I don't know how to explain. But oh God. Okay. Orzo, great. Orzo. Fantastic. Good. I don't know how to explain to you my book, but we'll come back. We'll come back to that another day. So I am still not far enough away from the little orzos to actually be able to look at orzo and go, yes, this works for me. So for everyone who also looks at orzo sideways after reading, that's where I was on Monday. It was so fucking funny. It was just so I was cackling. It's a book. I can't give more context than that and stay on the internet. It's a book. It's a book. If this book has not come across your frame of reference, it is probably maybe not for you. The trigger warnings are to be taken very seriously. You will not be able to look at orzo the same way again. Or you might. I don't know. It just depends. I cannot at this point. Maybe we'll get back to it. Emily, did you try to eat dinner? I didn't want to hurt Dr. B's feelings. He made dinner. It was so nice. Lissy, chat was having all kinds of YouTube issues today. So YouTube was a lot. YouTube was a lot today. It was 2009 Dragon asked, it's like 50 Shades of Grey. No, it's a good book. And it laughs at 50 Shades of Grey and says that is a book for children. It's on the other end. Yes. We have lots of people with very, very serious jobs that need very, very serious books in the chat. If a book where the first response is, it's probably not for you, is for you, then just Google. Just Google. It's in the chat. Thank you for the gifted memberships. If you're like, other people scoff at my reading list, read the trigger warnings, decide if it's for you or not, get it on Audible. The voice actor performance on Audible of that series is so fucking good. It is so good. Disgruntled Moderate said, you should ask Banfield where to get those noise canceling windows. You know what? I know. Dr. B, we don't have the triple paned windows. Chat, if you're asking what the book is called, it's in the chat. The chat is putting it in the chat. It's in the chat. Chat has shared. Butcher and Blackbird. It's a trilogy. We'll talk about the trigger warnings on members only. Because then if it gets yeeted off the internet, we can figure it out. Chat's got you covered. Take the trigger warning seriously. You are either going to go, ha, or you are going to go, what the fuck? Those are the only options. And that both are fine. I have no judgment. Both are fine. So let's see. Ashley, Party of One said, I have a theory that Grossman said, what do you mean the whole truth? Because he wanted to say more than just what the lawyer's questions were. It's fair, especially knowing he called the Richins. I want to know what else he had to say. And maybe one day we will hear from him. Maybe not till after sentencing. Maybe one day we'll hear from him, but it's fair that he might have said, what do you mean the whole truth? Because a lot of you in chat pointed out, and I didn't think of it at the time. I was like, I've never seen anyone give that answer before. Versions of that answer, but never quite like that he was probably advised like, hey, there are some boundaries of what you can say with regard to hearsay, etc. And he might have really been, but you told me there's certain things I can't say. And I can understand, especially knowing how literal I can be, that looking at, well, the whole truth includes what somebody said to me, but you've told me I can't say what somebody said to me. I can see where there could be a disconnect there. So, Charlotte said, are you feeling refreshed? Today has been a test of my patience, but I'll get there. Not just yet. But we had a good work call today. However, we are 6 hours in. I'm going to answer a few more questions, and then I am going to need to go because, again, Emily does not stream for 6 hours a day on a normal day. But here's what we're going to do. First of all, tomorrow, I do not know what time because I need to figure out what's going on at my house, and I have not had time to ask more questions. But tomorrow we are going to do a members only live. I'm not going to just do a stream. We're going to do a members only live. We have lots to catch up about. I will be recording a podcast. My kiddo has like multiple performances this week, and that is going to get very busy. A number of you have asked if we are covering another trial immediately. Not just yet, because of how incredibly busy family scheduling is, but I am keeping an eye on things coming up. I will say, as we get into April, I have a senior in high school. So the amount of things that need to be done between now and May are insane. And just for calendar context, I do not want to jump into a trial and then be like, oh, but I'm going to miss this week and that week. It will stress me out. It will stress you out. It will stress me out. It will stress me out a lot. If we cover things that have passed and go back retrospectively, we will. We also have some court days we need to catch up on from some other trials that we need to go back and catch up on. But starting a trial that I cannot cover consistently stresses me out quite a lot. And I know all of you understand the kiddo stuff, but the stress is that kiddo has spring camp. Well, kiddo has WGI, spring camp, band, but his graduation and his move-in for DCI are within days, if not day. So he is going to graduate from high school and then go to DCI. Here's the thing. He moves into college to start college marching band like within 48 hours of DCI finals in August. So in April, I need to make sure he's ready to graduate, go on tour, and move into college. Because we're going to have like 24 to 48 hour turnarounds on those. And that's going to be hard on me. So it is, there's a lot being navigated, and I do not want to start a trial that I will then be like, oh, hi, we were here for a week. I'm gone for 2 weeks. So if we do things after they are done, a lot of you have asked me about the Afro Man trial. We might do that in retrospective. I think that one's gone pretty quick, but we're going to have to navigate a very busy next few months. And I've been really mindful of trying to make sure that I plan my schedule to be able to do all the things. And so jumping into a trial right now, it needs a lot of scheduling. So it's transparently just I do very badly at, this is not going to shock you. I do very badly with, we'll cover a witness and then we'll zoom. Bull. That's never going to happen. We'll zoom. No, we won't. Did we skip one try? Did we skip one witness in Banfield? It was like, nah, we'll zoom past a few witnesses. No, we didn't. We're like, shit, we're in it now. Let's go. We're in it. Let's just go. And, so even trying to like truncate things doesn't always work very well. Cause then I want to, like, if we're covering it, I just want to see it. Once we get past opening statements, I just want to see it and we'll just watch it together. So we will be navigating what's next together. I will keep you posted, but the end of March, April, May are going to be tough. Just scheduling wise. And so we'll figure it out. We might go back and grab things. And there are a lot of hearings that have happened that I want to catch up on. So scheduling wise, that's where we're at. Tomorrow, we are going to do a members only. We have lots to talk about. We've got a podcast that we're going to record together. We've got lots to talk about, but it's just, there's just a lot going on. There's just a lot going on. And Travis is so excited. He's so excited about school. He's so excited about DCI. He is so ready to just like go. And I am very excited. I am very emo. I am very excited. But the timing of things are tight. But he is so ready to go back out on tour. It really started like earlier this month that he's just like, Yeah, I'm ready for WGI season. I enjoy WGI. I love WGI, but I want to be back out on tour. Like he's like, it's this time of year where he's like, all right, body's feeling good. We've rested. I'm ready to go out on tour. It's weird for me to think of him going out on tour and then not being back home. Like tour to college. It's just like boom, boom, boom. I'm excited for him. I know he's excited, but also it's weird that graduation is going to be like, okay, I will see. You're not going to be back at the house for more than like 24 to 48 hours until like Thanksgiving. So yeah, yeah. So yeah, there's a lot. There's a lot to do. There's a lot to do. And it's our first that's going to college. So there's just a lot to do. And Travis is just like a dude. He's just like, what? I just need a couple pairs of shoes and like a jacket. I'll be fine. Can we get some sheets? It's like, oh yeah, I mean, it'll be fine. It'll be fine. He's like, I mean, what do I need? I need a computer and some chargers and like a pair of shoes and a jacket. Okay. But that also makes it easy because his expectations are like, I can put it all in a bag. So it's going to be, it's going to be busy. Heather said, what about the additional fraud charges? They are all in a second trial that is following behind this one. We talked about it early on in stream. And we went over what some of the options might be there. So, yep. Shelby asked, do prior criminal acts impact civil cases? Not always. In this case, they absolutely can. Kouri Richins being convicted of Eric Richins' murder will impact the case with regard to his trust. It will. That case is stayed. Now that there's been a verdict, that case will start moving. We will be following it. But yes, it will impact it for sure. Absolutely will. I am so glad, Sarah. Thank you for the kind words. I love this community. I also love that when new members of our community find our community, there will always be some that are like, oh my God, y'all talk a lot. Yes. That's not for everybody. Yes, we do. My teachers have been trying to say that since like kindergarten. Correct. But that works well for us. It does not work well for everybody. But when people find this community, they're like, this is fun. And I love that as we go through trial after trial, and new law nerds are like, this is fun. I want to stay here. I love this corner of the internet. Same. That also those involved in the trial, and I always tell you guys this, always, but people who are involved in these cases watch us. It's not just us, but they watch us. They see how our chat is. And we have had witnesses in cases, victims' families in cases, reach out to us and talk about the fact that this chat is different, how they appreciate it, and how nice it is to see, even though we are discussing the case or discussing a certain witness's testimony, that we are talking about the testimony. We are not attacking the person testifying. Yes, a witness might get a side eye. We might be like, is that true though? But we are not attacking people. And that is so different from elsewhere on the internet. And it is something that y'all help us wrangle, that the mods help us wrangle, and that those who are a part of the cases recognize every time they come across the law nerd corner of the internet. I mean, you can't miss us. We are the largest audience watching trials. So you know that we're covering it because we have the largest live concurrent viewers. So we populate towards the top of everything. Of course we do. But when I run into people who we have covered, it has never been awkward. I have never run into Elaine Bredoff. I think at this point, though, I have more perspective, and I might be like, girl, you really were trying. You were really trying. I mean, the microphone was trying your patience, but I think you really were trying. but it matters and people see it. Dr. Shannon Kouri was in our chat, among others, and having witnesses reach out and say that they appreciate our community, even if they're like, I don't want to talk about this case, I just want to let you know. It is just so appreciated that y'all are down for it and they see it too. And so I appreciate sharing that with you, even when those that reach out about cases are like, hey, I just want to let you know. I love being able to pass on that compliment. And then when people reach out in a more public way, be able to pass on that, like, hey, there is a mutual respect here. Mr. Kostradamus, we love your PowerPoints. And he's like, you got a cool group there going. I can never forget John Stamos. I'm still partly mortified. I just didn't really believe it. I know now. I am aware. I am aware. But you guys have helped us create a really special place, and I appreciate it. It's also why I pick the cases that we cover mindfully to make sure that what we are covering fits within the way we do the things that we do. There are some cases that I just don't and won't. And I appreciate that you guys know that, because there's always going to be someone covering it, which is great. Sometimes it won't be us. Sometimes it'll be us later. We will see. Old Stuff Beth TX says, Emily, daughter, and I both seeking diagnoses for our neurospicy brains. Watching your channel for the past 4 years has given me courage and hope. Bet you're going to make me cry, Beth, and I love it. Courage and hope about why my life has been shaped the way it has, Leonard's rule. I love that. And I love how many of you, help me learn about myself. You've watched me do it in real time. But also, if me talking about stuff that I'm experiencing, struggling with, working through helps, I am happy to help, because it's stuff we don't always talk about. And it always reminds me of my coworker, Paul, when we were talking about how he figured out he was allergic, to fucking everything. Paul is allergic to everything. We've told some of these stories on members only. Paul, yes, we have. The one about the cashews. It's just true. But he was like, he was talking about being allergic to chocolate and being like, everybody else talks about loving chocolate. I didn't realize that what I was experiencing was not what they were talking about. Like, I thought people liked that it like made their gums feel like they were on fire and that it was like painful. I thought people were just like enjoyed that sensation. Like, my mouth feels like it is on fire. Why do you all like this so much? This is not a vibe for me. Didn't realize that was an allergic reaction. And so because we don't talk about it, right? You don't like, explain to me the ways that you like chocolate. Doesn't it feel like your mouth is burning off? And then eventually somebody would be like, no, no. But you don't have those conversations, especially when you're younger, because you just assume that like, oh, this must be what everybody's talking about. I imagine it's the same with like being colorblind. It's like, oh, I guess everybody says that color is that. I mean, how do I know what you see through your eyes is the same as what I see? I don't know. How do you know? I don't know that people, when they say visualize it, they literally can see shit. What's that like? And then Judge Abby and I, even having these conversations, she's like, so you're telling me when you're like studying in law school, you can't like see the page you read and like kind of go back and reread it in your mind? I'm like, what? No. Is that how people remember all the case names? Because I can remember the facts, kind of like song lyrics, but I don't know what the fucking case name is, except maybe International Shoe. So what do you mean? And she's like, wait, what do you mean? I'm like, nothing. Zero. She's like, what? I'm like, yeah. She's like, how does that work? I'm like, I don't know. Everything is processed through sound. Everything. because there was nothing visual at all. Right. And how would you know that? Because when my water polo coach is like, visualize it, I'm like, okay, I thought it was like a metaphor. I didn't know people could actually like run plays in their brains. Weird. Anyway, so we don't learn until we talk through things, but we don't know to talk through it because we don't know somebody else's experience is different. Because how do we know? Which is what I love about talking with y'all, right? You guys were with me when we learned about aphantasia. It was in Utah during the neurologist in the Gwyneth Paltrow case. Thank you, Gwyneth. Right. It was I was like, wait, what? Nuh-uh. Because they were talking about how brain functioning had changed. And I was like, wait a second. We all did that in real time together. I know. Which is why I like Audible so much. Because I can remember the stories that I hear. I do not remember the things that I see. Which is why most of my memories are tied to music, lyrics, conversations, whatever. Which made being an attorney that did a lot of writing not my fucking vibe. But being in court was my vibe. I'm like, nuh-uh, Your Honor, you said exactly this. And this witness said this. And that witness said this. I can remember what I hear. I have no idea what's in my writings. And I'm pretty sure those words are backwards. But I can remember what I heard, which made trial court work very well for me. But I also needed to talk out my cases. So I would often talk out my cases either to coworkers or to myself because I could remember the conversation I was having out loud with someone else or myself better than I could remember what I read. And so I just kind of accommodated myself through just scribing and voice to text. So yes, remember everything I hear. So anyway, Jack's Snack Pack asked, how did y'all figure out it was really John Stamos? He DM'd me on Instagram from his official account, which was lovely. I was like, hey, John Stamos, what's up? I'm so sorry. I thought I was being punked. I love having you in the chat. It's fantastic. So thank you. That's how. Mindful Mess says, yes, I do this for my students. EDB, you do this for me. We're different, not less. Exactly. You never know how someone else is experiencing things. And now I want to talk to everybody about it all the time because I'm fascinated by it. I talked about this. I was at a YouTube event and I haven't had this conversation with Spidey, but I would love to. Not Itsy Bitsy, not Spidey D, but Spidey behavioralist, mentalist. I had this conversation with a mentalist at a YouTube event, and he was talking about how much mentalism was tied to how people process information. And I was talking about how I processed information. He's like, wait, what? And I was like, yeah, no, nothing. He's like, so if I said like, envision a number, what do you got? And I'm like, I would just say like 10. Because then I've heard myself say 10, like 10. But I don't see the number 10 in my brain in any way. And he's like, that's fascinating. And we had a very long conversation about what that looks like in his work and how much mentalism is tied to how people process information. Other people's processing. Yes. Other people's processing. All right. I'm going to answer just a few more questions and then we are going to go. This is Susan McGregor said it better than I did. Love the people, evaluate the behavior legally. Yes. You know, along with trust but verify and be kind. And then when people get convicted of horrific shit, I may on occasion take shots at their height if they had opened up that door. Banfield opened up that door for me. Sweet Steffi said, do you dream? How does that work? Auditory only. Conversations, things like that, but auditory only. Like an audiobook. But a lot of you, when you listen to an audiobook, you can see things happening. I do not. I just hear it. This will be the best. Have the best time on the side with TIC. Going to South Hall this weekend. It's beautiful. Have the best time at South Hall. You will love it. I wish Judge M would just read everything. I think it is great. It's fantastic. But I am being beckoned. So I have got to go. Things are happening and I have got to go. But Banfield did make his height an issue. He really did. We will be bringing the cookies on May 8th when Banfield is sentenced. It is not because we are celebrating a sentencing. It is because we are friends and friends bring each other cookies. Though I don't think anybody brought Banfield cookies. Maybe his boss. Maybe his boss will also have cookies that day. His boss who brought the tea. Tea Patrick. Be fantastic. All right. Law nerds, I am getting flagged. I have got to go. Apologies. I will let you know once I know what is happening at my house, what time we will members only tomorrow. For those of you looking for a stream tomorrow, there will be a members only stream. If you are not a member, I completely understand. We will not be covering case things. We will be covering all of the other things. But we will have a members only tomorrow. If you were gifted a membership during trial, I hope to see you then. I will let you know in the app when we schedule that, and I will let you know in your member places here on YouTube and in the app. So I will keep you in the loop for that tomorrow. Law nerds, I love sharing these cases with you. I love getting to chat with you. I will see you soon. We have much to cover, so do not worry. And I will see you on the next one. Hopefully with less background noise. Fingers crossed. I'm going to go find out what's going on, and I will see you soon. Law nerds, have a good night. Take care. Bye.
Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.